Good afternoon. Good afternoon. Ladies and gentlemen, good afternoon. Welcome to the House Judiciary Committee on Thursday, the 2nd of March, 2023. We have a total of 172 witnesses today on quite a few bills, including legislation that is very challenging and difficult for the committee and for all of us across the state. Specifically House Bill 1. There will be at times very difficult testimony that's very difficult to hear, and I want to say now, just for members of the committee and for everyone here, we're going to, especially on House Bill 1, be liberal in how we address the 3-minute clock and the 2-minute clock, especially for victims of abuse. We want to hear their stories and we want to give them the opportunity to speak. But we have a wide range of different bills today, and we're going to be beginning with the first panel from the Judiciary, from House Bill 1190, with regard to their truancy reduction pilot program. Judge Jensen, Magistrate Raymond, and Dana Falls are all on virtually. Here in the committee room, we have Magistrate Jones, Richard Barton, Jamie Lee Townsend, and Kendall Timmons. If we could have them come up, please. And what we'll do is we'll take the people at the table first, and then we will go from there. So whoever would like to go first, that's perfectly fine.
Go ahead. My name is Althea Stewart-Jones, and I've been a family magistrate in the Circuit Court for Prince George's County for almost 16 years. This is my 13th school year presiding over our Truancy Reduction Court program. I am urging you to pass this bill. In addition to presiding over our Truancy Reduction Court, I preside over our child in need of assistance, which is our child abuse and neglect cases, as well as some delinquency cases. I believe my dockets in these two case types, especially in the delinquency docket, would increase if we did not have a truancy reduction court program in our county. While the children and families come to us with the same types of issues and problems, the approach to working with our truancy docket is different. Problem-solving courts focus on understanding and addressing the root causes of the problems. Students often do not go to school due to issues at home, such as caring for family members, undetected or undiagnosed mental and or physical disabilities and impairments. Our truancy court coordinators and case managers are in weekly contact with the youth and families and provide support and services and referrals for services. We work collaboratively with the school system to ensure that these issues, as well as the students' educational needs, are addressed. These resources greatly improve the lives of all of our students and families in our program, even those who do not meet the rigorous graduation requirements. In our county, due to the growing population of Latino families, we have a bilingual case manager that helps with communication, as well as making sure that all of our services are culturally competent. Truancy reduction is not a school-to-prison pipeline. It is just the opposite. We have helped our students engage in mental health services, substance abuse counseling, mentoring, and tutoring program, and have prevented some of them from actually being adjudicated delinquent. I hope that my testimony has provided a glimpse of our truancy reduction court and the positive impact that it has had in our community. I hope that all other jurisdictions in this state are afforded the opportunity to have a truancy reduction court program as well. Thank you.
Good afternoon. My name is Jamie Townsend. I am a blessed mother of two daughters, Haley 15 and Kylie 7. There's a quote that states, "It takes a village," a quote commonly referenced to raising children. And while that is true, I believe that adults need a village as well. That is exactly what the Truancy Reduction Program team has been, a village, an anchor, a healthy support system. My children and I entered into the Truancy Reduction Program at the end of 2018. Although my addiction relapse was the root cause of me failing to send my oldest to school, there have been other barriers, non-drug related, which have contributed to us remaining in the program for so long. Nonetheless, the amount of support has remained consistent. Just last year, the Truancy Reduction Program found an organization that offered to pay for the cost of repairing the leaking roof within our home, which ultimately caused black mold and sickness to occur within the household, and again, absences from school. Truancy more recently has also offered to help with the expenses of driver's education for my oldest daughter. Mrs. Timmons and Mrs. Bergeron have supported my children at school functions as well, coming to basketball games, as well as attending a school paint night honoring Black History Month. The level of support my children and I have received from the Truancy Reduction Program has been endless and has positively impacted our lives forever. My daughters still have their mother and a chance at a successful education. I don't know the statistics of cases which have been successful and those that have not been. I can, however, tell you that our truancy case is quite unique, as we have been in the program for almost 5 years. That being said, just imagine what truancy can do for other families. The support is definitely there. You just have to be a willing vessel. Thank you.
If you'd move the mic, that'd be great.
Thank you, Delegate. My name is Kendall Timmons, and I have the great privilege of being the Regional Truancy Court Program Manager for the First Judicial Circuit down in Wycomico, Somerset, Dorchester, and Worcester counties. I've served in this capacity for the past 6 years. I've had the opportunity to meet many families, some with stories like Ms. Townsend has been brave enough to share, and others with some challenges that were maybe a little less difficult for us to assist the family in overcoming. As a truancy problem-solving court, we have the great opportunity to independently evaluate the needs of the participant family and the actions available to be taken in our schools and our communities to meet those needs. No matter the county or the court involved, we share the common mission of increasing the youth's consistent access to their education and ultimately the future that they deserve. Working in this space for the past 6 years, I've fielded many phone calls and emails from families around our state seeking the support that we provide in our communities within their own county. Oftentimes, I have to tell them that the law simply just does not allow for this type of program to exist in their county. And I do work diligently, as does my team, to find somebody within their county for a soft handoff. I don't always know what happens to those families after those phone calls are made or emails are sent. I hope that they do receive that support. There are plenty of support systems out there. The schools, the departments of social services, other homegrown grassroots organizations, but I simply cannot have knowledge of every possible support in every county in this state. That's why I ask for your favorable vote for this measure today so that we can make sure that there is someone for a family to turn to in each of your counties. We're here today because, like us, you have the great opportunity, to ensure that those very families, some living in your own counties, have access to truancy reduction problem-solving courts.
All right, thank you. My name is Gray Barton, and I'm the Director for the Office of Problem-Solving Courts. My role, I oversee the planning, implementation, and sustainability of the 62 problem-solving courts for the judiciary and have done so for the last 20 years. The Truancy Reduction Court is but one part of a continuum of options for students who are absent or disengaged with school. By the time the child enters the program, the school has been unsuccessful in implementing multiple non-court options. Doing nothing for these students and allowing them to give up on their education is not an option. This program is beneficial because it gets students back to school, identifies barriers to school engagement, and provides these children and their families with needed services. For example, last fiscal year, 388 habitually truant students and their families were helped by the 7 truancy reduction courts. 49% were African Americans, 35% Caucasian, and 11 indicated that they were more than one race. As Magistrate Jones indicated, in Prince George's County alone, 45% were Hispanic. And among these 388 students and families, there were 641 referrals for services within the community. The highest, being at 171, were for mental health services, followed closely by transportation services. I understand that there are people who actually do not work directly with truant students who will argue these courts are essentially a pipeline to prison. I argue that by listening to Jamie, our parent, who's with us today, the judges and magistrates, read the written testimony from workers within the school systems that the truancy courts work in, and one from the Howard County Board of Education, it's demonstrated without question that the need of these children and their families are what is at stake for the jurisdictions who will not be able to participate in such a sound problem-solving court without the passage of House Bill 1190. Thank you.
I understand we have a video from the judiciary that I believe is for 3 minutes. Go ahead.
I just literally stopped going to school. Like, I was going through so much that it was just like, what could be worse? So I just stopped going to school for a long, and I mean a long time.
I think the alarm bells and the red flags went off when she stopped coming to school. Those were the actions that were different than they had been in previous years.
I hated school. Like, I hated everything about it. I was always in drama. The work was hard. I didn't have little to no motivation. I went through a lot of stuff at home, so it made me want to just give it all up. Like, school was just another stress to me.
We knew we were going to need that extra partnership and support with the court system and the truancy court and Judge Jensen.
Having the court kind of be a partner with the school system was a huge deal, and it was a huge opportunity for her to take advantage of those extra supports and finish out what she needed to do to get that diploma.
When she heard for the first time that she wasn't going to walk with her class, her whole countenance, it was like her whole body just sort of like sunk in on itself.
I didn't want to go on Snapchat, none of that, no social media, see everybody having fun and they cap and gown. I was sad because I went through a lot all 4 years of high school, and that was the biggest thing I was looking forward to, being the fact that I had made it, because I wanted to drop out since my 9th grade year.
Maybe you didn't walk with your class, but to me, being here in court today and sticking this thing out to graduate is an enormously incredible thing that you've done. Today, you should know that you are successful.
I want to recommend to the Kent County Board of Education this member of the class of 2018 as a qualified candidate for the state of Maryland diploma.
You're probably the first high school graduate that's ever going to come through circuit court for Kent County.
You wanted to give up, but I can still see the order work you said that you didn't want to give up.
What it goes down to, if you put your mind to it, you can accomplish anything. I'm proud of you and I love you.
We judges don't get to do a lot of happy, feel-good types of things. And we see that the court's efforts in collaboration with the Board of Education and with Kendra's family achieved a goal, gave me just personally great satisfaction.
At first, I didn't want any help from anybody. Now that I see it actually paid off and helped me, it felt like I actually had people on my side. Like, I didn't think none of this would come my way.
I think for the first time today, she held her head up and she looked me square in the face. And I love that, because that just says a lot, that she's got some confidence now that I didn't see 2.5 months ago.
All right, we're going to hear now from Judge Jensen, who's on virtually, then Magistrate Raymond, and Dana Falls, please.
All right, good afternoon. I am Judge Karen Murphy Jensen. I'm the presiding judge over the Kent County Truancy Court for the past 5 years. I've been a member of the Maryland Judiciary for 23 years. Kendra is doing great today. She is the mother of a 3-year-old, and she has pursued a career in cooking and fashion alterations. So I thought you would like to know that. I'm going to really start my comments by telling you all what truancy reduction is not. This is not a juvenile proceeding. It is the Board of Education that brings a petition, not the state prosecutor or the Department of Juvenile Services. Because it's not a juvenile delinquency proceeding, the court has no authority to place the child in detention or otherwise remove a child from the home. It's not a criminal proceeding. It's not a proceeding in which a parent can be incarcerated for failure to cooperate in the program. It's not a child in need of assistance proceeding, and thus the Department of Social Services is not a participant. Again, the court cannot remove a child from his or her home and place in shelter, foster care, or any other out-of-home placement because the child is not going to school. In fact, the law is clear that truancy for a child is really a civil infraction and is treated as thus. Additionally, I think as Mr. Barton also made mention of, participation in this program, whether successful or not, does not lead to negative consequences for the student. A student cannot be suspended or expelled for failure to attend the program. And I'm going to submit by not taking advantage of the program, the student may be more likely not to graduate or be prepared to proceed in school. So I urge your support of House Bill 1190, and I do thank you for your time, ability to participate remotely. Thank you.
Magistrate, please.
Oops, sorry. Good afternoon. My name is Joni Raymond Brubaker. I am a family magistrate. I've been in the Circuit Court for Frederick County presiding over juvenile delinquency, child welfare, and family court matters for more than 6 years. This bill is important. I see youth on a weekly basis that have entered the delinquency or child welfare system, many of whom we know are going to go on to enter the adult criminal justice system unless we intervene and try to break the path of where their life is headed. Many of these youth have had a lack of support in their family life, substance issues, early trauma, attendance and behavior issues at school, well before making it to the delinquency system. So this means we can intervene before they enter the judicial system with truancy programs. Truancy courts identify reasons why children don't attend school, and they work to address the practical issues like caring for younger siblings, giving children and parents caring people through the judge or magistrate and program staff who are there to listen about their concerns and try to help. Truancy has been identified as one of the early warning signs for delinquency, social isolation, and educational failure. We also know that without a high school diploma or GED, these youth are not as employable and earn less than their graduate counterparts. We know that keeping kids physically in school increases their chances of graduation, and it increases their chances of success, giving them a solid foundation. With truancy courts, the court can coordinate and oversee the delivery of services to these families. The court can be the convener and bring services to these youth and families who are identified early to re-engage them before they graduate to the juvenile delinquency system and to address those root causes before they become ingrained family patterns that can be passed on to younger siblings. The program will assess to see if there's a lack of appropriate social, emotional, and behavioral support, barriers due to poverty or being unhoused, transportation issues, safety concerns, trauma and mental health challenges. We are about helping these families, wrapping them in services and giving them every opportunity to remove barriers to education. It's about building partnerships with organizations and coming up with specially tailored incentives to engage them in their education. We don't have one in Frederick County currently, and I truly believe that this is necessary in Frederick County, and I urge your support for House Bill 1190.
Dana Falls, please, for 2 minutes.
Thank you. My name is Dana Falls. I'm Director of Student Services in Frederick County Public Schools, and I've been Director of Student Services in 2 school systems for over 16 years. I have seen the benefits of when the community surrounds a student and family that is struggling with attendance in school, and the results can be amazing. When we focus on incentivizing the student, we focus on getting to the root causes and having the right community partners available to provide that support, we can have amazing results. Where we have failed as a school system prior to that with many interventions and attempts. The implementation of a truancy problem-solving court would enhance the experiences that we're already doing in Frederick County through a Truancy Reduction Council. We've formed a partnership with many community providers to do just that, examine root causes, meet with families, and incentivize students. Anybody who says that this is equivalent to a zero tolerance policy or promotes the school to prison pipeline is at best ill-informed and at worst completely disingenuous, because it is not that at all. The focus is on supporting the student. I don't want to pat myself on the back, but since we've put our Truancy Reduction Council in place without funding and without support really formally from the court, I've invested over $1,200 in the last 2 years incentivizing students out of my pocket. And so anyone who says this is punishment or this is some way to penalize students is dishonest in their approach. This legislation would allow us to formalize and to enhance what we're doing through resources that could come through the courts and through additional resources from the community partners. Thank you.
There are questions for the panel. Delegate, I see you, Delegate Taylor, then Delegate Kaufman, then Delegate Bartlett.
Thank you, Mr. Chair. Ms. Stewart-Jones, it's good to see you again.
Yes, thank you.
You said this is your 13th year?
Presiding over truancy reduction, yes.
Okay. So, whenever I hear truancy, and it just puts a dagger in my heart. And when you couple that with courts, I'm thinking, oh no, that's a bad thing. But what you guys have shared today is this is really a good program, potentially. So can you tell me what it would look like if we didn't have this program?
Yes, the jurisdictions especially that have contacted me to come and observe and talk about what they have the option of the school asking the state's attorney's office to prosecute the parents for not sending their children to school. The parents can be fined up to $50 a day, and they also can be incarcerated. The other option where some jurisdictions call and say, well, we're not doing anything. The school is doing all they can, but we don't have anything. The state's attorney's office is not bringing petitions. And so basically that develops into a larger community problem because the students drop out of school. As you all know, that truant students are at high risk of unwanted pregnancies, substance abuse, delinquency, or criminal behavior, a whole gamut of situations that they can get in that is not good for them, it's not good for the family, it's not good for the community. So basically, it's those two options, state prosecution against the parents or do nothing.
Thank you, Mr. Chair, and I thank you for starting the day on an uplifting day on what's going to be a hard day. And lastly, before I get to my question, I just want to say that I will be asking fewer questions today because of the volume of things. It's more important to listen. But my question is, as a result of this is an expansion. Am I correct? The fiscal note says it's an expansion of the program. And therefore, my question is, given the judicial backlog, even though it says as funds are permitted, do you anticipate needing to hire more judges to work with these talented young people for this wonderful program? Because the judicial backlog is already terrible, so I was just wondering if it's an expansion. Will you need more judges?
I think I heard you. You asked if did you hear?
Yeah. There'll be more. In our estimate, that there is not a need for additional judges or magistrates we haven't seen that in the other jurisdictions that implemented these programs, and it is expansion. This bill is an expansion to allow other counties to do it. Currently, as it sits, it's only allowed in those 7 jurisdictions rather than the whole state.
Okay, thank you. I guess time will tell. All right. Thank you very much, Mr. Chair.
Thank you. Thank you, Mr. Chair, and thank you all for being here today. Good to see everyone. Thank you for that video. That was very well done. So my question is with respect to juvenile courts, because juvenile law can be kind of difficult to understand because there's so many nuances. But how does this program differ from the juvenile court cases? Because I'm looking at the bill and I see that, you know, the court administrative judge may, the county administrative judge may establish the truancy program, et cetera, and there's problem solving court. And can you just kind of outline that just a little bit? Not too much, but just a little bit. Thank you.
Okay, so in juvenile court, there's the child welfare cases and the delinquency cases. In those cases, the Department of Social Services or the Department of Juvenile Services brings a petition against someone. With the Truancy Reduction Court program, there's a collaboration of the school system and all of our other stakeholders, and it varies from county to county. The Department of Social Services, it could be some of our county service providers provide mental health services, in-home services. We all collaborate and focus around the child. We're not pitting one party against the next. It's basically looking at that family, trying to address what the issues are, and working with that family to ensure that the child, number one, goes to school to eliminate the truant behavior, but also addresses why this happened in the first place. So it's a totally different concept. Problem-solving courts in and of itself is different. We see these youth and families at least every 2 weeks initially until they start making some improvement. We do not see that in all the other case types.
Can I ask one quick question? Okay, do you actually sit down with the families? Is that what you're saying?
Yes,
Okay.
before it even gets in the court, and Kendall can talk about this as well, our court coordinator and case managers meet with the family to make sure they understand, because really it's voluntary. If they don't want to do it, they don't want to do it. But, you know, the option is for a lot of the parents, the school may file the petition against them, or the student would just continue to be truant. And most families do not want that. Most families want their children to be in school, get an education, and to be good members of the society.
Okay, that satisfies my question. Thank you.
Thank you.
Mr. Chair, thank you. It's okay if you come back to me.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. I believe the lady's name was Kendra. So when Ms. Kendra was graduated, had she already given birth, or was she pregnant at the time? Does anybody know?
I do. No, she wasn't pregnant.
She was not pregnant. Okay.
As far as nope, she was not.
And in Baltimore, can anyone comment on what they're doing about the truancy in Baltimore?
Sure, I can talk about that. And so in Baltimore City, there's actually a non-court truancy program run by the University of Baltimore. They have that. So it's not. It is one that the judiciary supports and actually provides grant funding for that initiative. But it's a non-court. They actually see the students in the. There's only a handful, a couple handfuls of schools that are involved with that, and it changes from either year to year or semester to semester. But it is a non-court option.
So in Baltimore City, we don't really have a handle on how much truancy is taking place in the educational system. Is that what we're saying?
I do not, sir. No.
Okay, so we don't have any statistics.
No, not from Baltimore City.
Thank you very much.
Yes, sir. Thank you so much. Thank you so much for being here. Could we talk about what is something that was said in reference to Prince George's County and the parents? And I wanted to see sort of and so I wanted to come back, how you can explain the role that parents play in terms of holding them accountable. For me, when always wear this hat up here is my former role as a council member. That's one of the things I will often talk about is that we parents, I mean, maybe it's not the politically correct thing to say, but really should take some responsibility ensuring their children come to school, particularly when they are in grade school, you know, that K through 5th grade. So if you could talk about if this program would, like, what happens there, and then would this program help to, you know, hold some accountability for the parents, if I'm making sense?
Yes. We don't have the stick, so to speak, to incarcerate or fine them. And we don't want to. But basically, a lot of parents, if they may be suffering themselves from mental health issues or substance abuse issues, or a lot of times they may be homeless and they don't tell anyone. They're ashamed. They don't know that the school system should provide transportation wherever they are to ensure that the children get to school. We make sure that the parents give the kids a curfew when needed. And if they don't, we ask them, why not? Why didn't you follow through? We make sure that the parents, when the children have mental health needs or whatever needs, make sure that they get them to those services. So that is how we hold them accountable. We hold everyone accountable, including the school system, because sometimes they ask for a petition, but they haven't done all that they're supposed to do. Have they tested for an IEP? Have they tested for a 504 plan? And if the students do have an IEP or a 504 educational plan, are they implementing it correctly? Are they suspending students for non-suspendable offenses? We address that as well. So we try to make sure everyone is held accountable, everyone is on the same page. We make sure we have workshops for the parents on how to engage with the school, how to make sure that you can log into your child's family portal to check their attendance every day, to look at their grades. So it's more of giving everyone resources to make sure that everyone's on the same team. And that's one of the biggest, I guess, what's the word? Serendipities, I guess, for lack of a better term, that we see at the end of it all. They're working together. And so even when the court case closes, the student, the families, and the school system know how to work together to continue the success of the student.
Okay, thank you so much, Madam Magistrate. Thank you. Thank you.
The last question, Delegate Simpson.
Yes, thank you very much. Sounds like a great program. I really appreciate having our Frederick County represented here. My question is, why the courts? I mean, I understand there's all these services and things like that, but why particularly obvious? Why the courts? What is it? It's not SINS, it's not SINA. You know, you're saying, well, we're not doing this, and then how many kids are we talking about? I mean, I know a lot of kids didn't go back to school after COVID. I know there's some kids that are out there. So what is the advantage of this being through the court system?
Want to take it?
Judge Jensen, do you want to take that?
There are a lot of questions in there. I'll try to sort of parse back. In Kent County, over 5 years, we've had 257 kids go through the program, but Kent County is small. I think the other jurisdictions here can probably tell you, or Mr. Barton can tell you how many kids have gone through the program. I think it's a great question, why the courts? And I think my response to that is that hopefully the respect that people have for the courts and the authority that comes from the courts is an added component to encouraging a child to be successful in school. Because if the triaging at the school level isn't working, and I'm going to submit prosecuting parents is probably the most inefficient way to tackle this problem, just by virtue of the fact it takes so long for those cases to wind their way through the criminal justice system, plus the unequal, when I say unequal, not every jurisdiction is the same. Most prosecutors don't even want to touch these cases. So they're the only two options. So the court steps in this role of problem solver. being the lead collaborator to try to solve this problem. And we don't have the sticks that I would have in juvenile court, because as I said in my comments, I can't remove, I can't detain. But what I have seen, it's really the respect that families have for the courts that really is part of what makes it so successful. And that the court is sort of like the lead, the lead agency with all these other agencies working with us to assure success. So that's how I would respond to that question, why the courts? Because why not, without the courts, you're left with the schools or prosecution. That's what you're left with. That's it. And I can't tell you how many dispositional reports I've read in juvenile cases, DSS reports in SINA cases, or even pre-sentence investigation reports in criminal cases that talk about that person's school history and how many times truancy is raised or when they stop going to school. So again, it's another opportunity for us to intervene early so they don't end up on these other dockets.
I wonder if the parent who testified could give that perspective.
Briefly.
The question is why is the courts the appropriate place as opposed to like the schools providing the carrot rather than the stick and providing the resources?
I would have to say that the court is actually, I look at it as a positive. It's a group of individuals that, although yes, the school administrators obviously want children to attend school and hold a parent accountable for not sending their child to school. However, the court system has been a extra support system and has helped me hold myself accountable for decisions that I have made in the past and in the present.
Can I just say, this is the last-ditch effort, basically, by the school. The school has already been trying to engage the family. So it's not like they automatically go to the court. When we get referrals, they have outlined every effort that they have made to try to engage the family, meeting with them, doing home visits. So it's basically, okay, so let's try this. This is it, before other actions through another court has to be done.
Delegate Simpson, if I may. In this country, the court is meant to be the great equalizer. And we may have a family that's brought into truancy court on a truancy petition, but at some point in their child or children's educational history may have had a poor experience, whether that was a personal experience or something greater for the whole school system. And so they've shut off communication. And their child goes to school when their child goes to school, and if their child doesn't go to school, they don't go to school. Because I'm not dealing with those people who harmed me in some way. And so when we come before a truancy court, we have the opportunity to mediate that and move past a past hurt so that we can have a more successful future. But if there isn't that intermediary or that equalizer, then the family just goes on and ignores the phone calls from the schools, doesn't participate or engage in the referrals made by the schools because there is that hurt or lack of trust. A lot of times, that's where we step in to overcome.
So there was mention of a program that was outside of the courts. Does anybody know of how that is, or the research?
I don't have. I can provide any research that they may have. I don't have it with me right now. But there, as Magistrate Jones said, there are many interventions. This is not the only. We're not saying that this is the only one. We're saying provide this option to jurisdictions that don't currently have this.
Thank you very much.
I'm
sorry. I have to stop right here. It's 1:45. We've gone on quite a lot of time on this bill. Thank you very much.
Thank you.
We're going to move to the panel of those people in opposition. There are two people, Alicia Fio and Frank Patinella. For 2 minutes each, please. Whoever would like to go first. We have 172 witnesses. Thank
Good
you.
afternoon.
Who would like to go first? Thank you.
Mr. Chairman, members of the committee, my name is Alyssa Fio. I'm an education attorney with the Maryland Office of the Public Defender. I come with 25 years of experience representing students in education-related matters, specifically students with disabilities. I handle truancy every single day. I have been working on the school-to-prison pipeline for 25 years of my career. I understand the school-to-prison pipeline in a much broader way than has been described today. We recognize the good intention of this bill, and we appreciate the service that the judiciary has provided to families. But with our experience representing students throughout the state, OPD opposes HB 1190 and urges the committee to issue an unfavorable report. The committee has OPD's testimony. I won't go into it at length here, but I do want to highlight a few things. Truancy, as we know, is due to a complex array of factors, including unmet and unidentified academic needs, student discipline, lack of appropriate social and emotional supports. OPD represents students with a wide range of academic and mental health needs. Many of our clients have experienced school failure for years and yet are never referred for an evaluation to determine if they have a disability impacting their educational performance. And we know that the relationship between academic performance and academic achievement is greater, has a greater risk of absenteeism. And we know that students with disabilities are at greater risk of absenteeism as well. According to the Maryland Report Card on Amnesty's website for 2022, Black students with disabilities represented the highest chronic absenteeism rate at 48.4%. The IEP team is the appropriate place, the appropriate forum to address those students' needs along with community supports. Rather than expanding court involvement, OPD urges the state and school systems to focus on evidence-based interventions that are non-punitive and center on prevention. I'll stop. I'll just say that there are other things that are being done through the Maryland Blueprint. There's the local coordinating councils, local care teams. We don't need to increase court involvement. Thank you.
Thank you.
Mr. Chairman, members of the committee, thank you for the opportunity. My name is Frank Pathinella, Senior Education Advocate with the ACLU of Maryland, also representing the Coalition to Reform School Discipline today. We are urging an unfavorable report on this bill. I want to thank the supporters of the bill because we agree on the intent. However, we strongly believe that expanding truancy courts now and the overall strategy to address truancy is premature. As OPD noted in its testimony last year, the 2011 report from the Maryland Judiciary recommended that expansion of truancy courts should be predicated on more definitive evidence. That was more than 10 years ago, and to our knowledge, there's not been a deep dive into the data and evaluation of these programs since then. That report needs to be updated, and it should dive into the myriad of programs and best practices around the country. Perhaps there are more effective approaches that the state should pursue. Secondly, in a report cited in my written testimony, Rhode Island's truancy courts became another disciplinary device that triggered more family involvement with the justice system, which in turn led to threats of fines and imprisonment for minor issues such as failure to complete homework or classroom disruption. There's no guarantee in this bill that truancy courts in Maryland will not become another failed punitive measure that will unfairly punish students of color and continue to feed into the school-to-prison pipeline. My last point is about the blueprint and how much time and funding is being invested in this $4 billion major education reform initiative. One of the big pillars is about providing comprehensive, evidence-based, and culturally responsive approach to struggling students and their families to address barriers to learning. Truancy falls into this strategy. The blueprint established a new consortium of coordinated community supports to help schools address the myriad of challenges that families face through community-based providers and wraparound services. At the core of this approach is establishing strong relationships and trust. That's how families are going to be receptive to interventions. The courts are not the experts in this kind of service delivery. So for these reasons, please pass this bill. Do not pass this bill. Thank you.
Slightly inconsistent with your testimony. Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. What is the school-to-prison pipeline?
So the school-to-prison pipeline is, we know that we have an overrepresentation of students of color in the juvenile justice system, as well as students with disabilities. That, there are many factors that lead to that, including disproportionate school discipline, school push-out, lack of academic achievement. This body in 2017 passed a bill which would limit the push-out of pre-K to second grade students. This body understood that that was part of the school-to-prison pipeline. When we start pushing kids out at an early age, we are increasing the risk of involvement in the juvenile justice system, and that ultimately leads to
Define what you mean by push out.
so disproportionate school discipline. We know that students of color, Black students, African American students, are more than double at risk of being suspended or expelled. Students with disabilities, likewise, are disproportionate. As they represent themselves in the population, they are a greater number proportionally of this number of students who are suspended or expelled.
And one more time, what's that website where the statistics are located?
So it's in my written testimony. I actually put, there's links in the testimony that actually takes
Yes,
you.
just call me real quick so people
So the
that are
Maryland State,
listening.
sure, the Maryland State Department of Education has all of the data regarding school suspension and school expulsion, and it disaggregates it by race, ethnicity, and students with disabilities.
Thank you very much.
Further questions for the panel? Seeing none, thank you very much. That
Thank
concludes the testimony on House Bill 1190. I just watched Delegate McComas leave. House Bill 1020, and Delegate, here she comes. House Bill 1020, Delegate McComas. Judge Sandy, Dorothy Lennick, Michelle Smith, Lori Ruth, Brett Smoot. You're going to have to add a couple chairs up front, and we'll hear from all six of you. We'll have to do the do-si-do and change seats and do all that, but there are six of you, and we're going to do one panel. All right?
Thank you, Mr. Chair. It is a delight to be here. I miss you guys very much. Just saying, I do. HB 1020, Child Custody, Legal Decision-Making, and Parenting Time, is the product of a commission of judges, attorneys, advocates, and mental health professionals. The commission took public testimony around the state where individuals expressed their thoughts and concerns regarding child custody decisions by the judiciary. Oh, I'm sorry. Okay. The goal of 1020 is to codify the numerous landmark case law regarding custody decisions. The goal is that this would be one reference for the public to understand the facts, issues, and legal framework that a judge uses to analyze and determine custody. The codification of the case law takes away the mystery of how and why a judge makes a particular decision. The guiding principle in all custody decisions under the state of Maryland has been what's in the best interest of the child. Throughout the years, custody law has been determined by what is the best interest of the child. The public, the attorneys advising clients, and social workers who assist those going through custody litigation and others touched by custody litigations can understand the various factors the judge considers when determining what is in the best interest of the child in these cases. Thankfully, most custody cases are resolved by parents deciding through joint consensus, mediation, therapy, or negotiation what is in the best what would be the best custody arrangements. Codification of the case law is a way for the attorney counseling the client to say, here's the case law. In this one book, the Family Law Article of Maryland, Annotated Code, each section of the statute can be further researched easily by the judge, attorney, or pro-litigant by following the annotations, and then if they so desire, look up the case law. According to the fiscal note, it has been introduced the last 3 years, and I think it's longer than that, as a House and Senate cross-files. And although the current fiscal note indicates there is not a cross-file, that is not true. Senator West and I would would beg to differ with that analysis. And in fact, we are going to make sure that the bills are conformed because the disability community has made gains over the years regarding equal status of the disabled person in a custody case. So we are, my bill is going to conform with the amendment that Senator West has put on his bill. So I feel this is a common sense bill that makes custody law understandable for parents to understand their rights and obligations to their child or children. And passing this bill is the right thing to do. So please support the bill. And with that, I turn it over to my very esteemed and honorable panel.
Mr. Chair, Mr. Vice Chair, and members. My name is Ricky Sandy. I'm blessed to be a circuit court judge in Frederick County. Before that, I was a magistrate, and I was honored to be on this original commission. The statute brings changes to the antiquated terms of custody and visitation into the 21st century to parenting time and legal decision making. Truly, the language now is analogous to jails. I don't think any party should be subjugated to quote unquote visit with their own child, nor should a child be demoted to a piece of property over which somebody has possession or custody. It provides a clear and uniform set of factors for the court to consider in custody matters found in one place, and all of them are child-focused. It has always intellectually vexed me that in regards to property, we go to Family Law 8205, specific factors for the court to consider. They are outlined. If it is for alimony, we go to 11106. They're right there in the book. However, when it comes to the most important issue before the court, our children, we tell litigants, go and read two old cases, Montgomery versus Sanders and Taylor versus Taylor. The former is a case from January of 1978. Archie Bunker and Mrs. Cunningham were still on television. Many of the litigants are self-represented. These litigants may or may not have access to a law library to read the cases. And even when they find them, the decisions were written by judges. So we direct them to read the case law, which includes such terms as judicial prognostication, patrio pertatus and patiat debit, non in atra sate consisterare. All of these terms, if they can navigate through them, they may get the factors. We ask for support of this bill.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm going to throw this right out because what Judge Sandy just said is absolutely the crux of it. I'm going to add one small thing. This is a tidbit that may interest you. I testified in favor of this bill on the Senate side a couple of weeks ago. The very next day, I had a trial on a child custody case. A very esteemed judge of more than probably 30 years on the bench said to me during my closing argument, because I have consistently been arguing the factors that are set out in this statute since the commission issued their report. I'm probably one of few people that do that. I'm hoping there are a lot of attorneys that do that, but I do that. And this judge said to me, that's very nice, Ms. Smith, and I couldn't agree more, but could you tell the legislature that we need those in a statute? And I said, I will do that. And here I am. So you heard it from him, you heard it from me, and I'd like to just say, in addition to the pro se litigants having not the first clue how to navigate the labyrinth of child custody matters that mean everything in the whole world to them, there are young attorneys who don't have a clue either. I have trained some of them. And to tell them to go read that antiquated case law is not what I do. I tell them to go to the commission report and read that. And that's what I'm asking you to pass in this statute. So and I should say who I am. I'm Michelle Smith. Some of you know me. I am here today on behalf of the Maryland State Bar Association Family Juvenile Law Section Council. We have 1,200 members on our section who practice custody cases in family law every single day, and we urge a strenuous, favorable report for this bill.
Ask Ms. Ruth to speak next, and then we'll ask Delegate McComas and Ms. Lennig to switch, and then we'll do a switch on the other side. Ms. Ruth.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I'm the legal director of the Women's Law Center. I also participated in the commission, which was now 10 years ago, which is hard to believe, and I think the bill's been here almost every year since. We also urge a favorable report. I just want to answer a question that was asked a few weeks ago in judicial proceedings by a senator who said, why do we care about the language? Why does it matter? That makes no sense to me. And on Monday, driving to work, I was listening to NPR, and they were interviewing a woman, and it was about climate change. And the reporter said, why do we care about the language? What difference does it make? Why does it matter? And this woman, more eloquently than me, said, because language sets the social norms and social mores of society, and that's why this update of the language matters. We've been urging every year in our testimony, if you do nothing else, if you're not willing to do what we really want, which is adopt this language into a statute, at least forward the social norms and mores and get away from custody battles. I cannot tell you the hundreds and hundreds of people who start their conversation with us is I'm having a custody battle with the other parent. We want to change the dialogue, and the way to do that is to modernize the language. And for those reasons, we urge a favorable report. Thank you.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Dorothy Lenig. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. I'm here today to urge a favorable report on House Bill 1020. In the interest of time, I'm just going to say me too.
Thank you, Mr. Chair, committee members. My name is Brett Smoots, and I'm a staff attorney at Maryland Legal Aid and a co-chair of Maryland Legal Aid's Family Law Task Force. My role at Legal Aid is I'm in our centralized intake unit, which means that I'm a point of first contact for folks trying to utilize legal aid services, usually over the telephone or in one of our walk-in clinics. And again, legal aid, we serve low-income folks, many of which we don't have the resources to represent, so brief advice is the best we can do, and that's what I do every single day. And these factors are incredibly hard for folks to access because, again, they don't have legal search engines. Some of them don't have the internet or the ability to even utilize public transit, which of course is super reliable, to get to their local library. So it can be very difficult for them to access the factors and understand them as well. And so if I had a codified list I could just simply share with them or just tell them over the phone, it would be a great help to them to know what information the courts find important when making custody determinations. It also would selfishly make my job a bit easier because I could just give them the list and not have to go through my spiel. Also, House Bill 1020, as you've heard, updates the language, which is also goes hand in hand with the parenting plans that were recently adopted by the court. And again, this language is child-focused as opposed to parent-focused. We've heard about custody implying possession, making these cases more contentious than they already are, and they really don't have to be. So we're trying to deflate that a little bit. And so, again, these cases are about the most important thing. They're about the children, not about parents. Although parental rights are incredibly important, denial of access is incredibly important, but the child's best interest is what's most important. And so for that, for all those reasons, Maryland Legal Aid would urge a favorable report on House Bill 1020. Thank you so much.
Delegate Grammer for question.
Thank you, Mr. Chair. Thanks for being here today. I've read through the bill. You've kind of talked broadly about what you're trying to achieve. Help non-attorneys like myself more clearly understand how these kind of situations would change practically. Can you explain that to the committee and give as many examples as you'd like? Any or all of you?
Could change, and I didn't hear the
Walk me through, instead of a custody battle, you want to start to talk about the best interest of the child. Can you give me a comparison of what it would change?
I'll start. We're all charged with deciding what is in the best interest of the children. Right now, we're told to read the old cases and get those factors, and the court's going to depend on those. The bill outlines child-focused things that the court should articulate in making their decisions, and the parents know in front of us the exact same factors that we are going to be using. As far as the naming, parenting time, as opposed to one party has custody. As opposed to legal custody, we have legal decision-making, the terms. So, but first and foremost, here are the factors that everybody can work from the same book and go to one place to look for them without all the other colorful language surrounding it.
Perhaps I could follow up on the judge and say that if you look at 9202, please, on page, an unknown page, but 9202, it's sort of towards the end.
Got it.
Okay. You see there the factors. Let me just offer you a side-by-side comparison in general terms. The factors from the antiquated case law are something like this, very short phrases. Fitness of each parent. Does that mean that they go to the gym? One doesn't know. The character of each parent. Also really hard to understand what that is. health of the child, age of the child, ability to maintain connections with other family members. They're very, very basic, and I understand why that is the case because of reasons I won't get into. But now we have much more flesh on the bones. If you look at these factors, even a layperson or a young attorney or a brand new judge for that matter can understand how to apply these factors to the particular facts of that child's life. There's so much more detail. There's so much more fleshed out. And there's more of them also.
Is this a problem with our case law, or are other states moving to this kind of model?
Oh, many other states have adopted custody factors.
Okay.
We are behind.
Thank you so much.
Thank you, Mr. Chair. Just really quickly, and this can go to whoever can answer. The Department of Human Services, I don't know if you can hear me, if that's better, sorry about that. The Department of Human Services had sent in a letter of information, but they cite a couple of concerns, and I'm just going to try to do the summary real quick about, with regards to parental rights of same-sex or disabled parents, the assurance of protections for legal parents, eliminating the right of the de facto parents whose rights have been terminated, elimination of those rights of those who've been terminated, and statutory protection of children from individuals who have abused or neglected children, including custodians and guardians, not just parents. And so if you haven't seen the letter, then, I mean, we can chat offline with regards to any responses you have to that. But I'm just trying to paraphrase really quickly what some of their concerns were. And if you need me to elaborate more, I'm happy to do so.
Before, I haven't seen the letter, but before I think our judge here can respond and do it in an eloquent and very detailed manner, I would think that we need to at least get a framework in place. And we have a problem, and we need to solve the problem. And we can nitpick from here to eternity because it's not perfection. But humans don't work with perfection. And I think that I'll use the example, if it's a same-sex family, okay, it's going to be what's in the best interest of the child for that child in that particular circumstances. So all of these things are just kind of we're not going to do it this year, we're not going to do it. But so the only thing it's doing is really making the domestic lawyers real rich, and we need a framework. So that's just my thought, and I mean, I know that's kind of like brutal, but whatever. Judge, I turn it over to you.
Well, I don't know the contents of the letter. I heard you mention de facto parent. Years and years ago, part of this proposed bill did have a provision for de facto parent. In the interim, our Supreme Court in Maryland has ruled and accepted, identified, and now we have case law for the last 3 or 4 years coming out of Conover versus Conover on de facto parents. But I'm ignorant of the letter, so I don't want to guess.
Okay. I mean, I can talk to the bill sponsor offline, but I mean, they did raise that they do have concerns about how this would affect other certain types of groups and communities and populations, and especially with regards to parents who may be neglecting their children and still allowing them the right to make decisions as it relates to maybe doctor's appointments, et cetera, et cetera. So.
Delegate Phillips and Conaway.
Thank you, Mr. Chairman, and Delegate McComas, thank you for this bill. Bringing some clarity to how we handle family law-related matters is important, so thank you. I do have a question, though, and it's probably more of a, maybe it's a technical nature, maybe it's not. How does this relate then to child support and child support enforcement? We have rules that say joint custody, so many days, this is what you pay, et cetera. And the language here, are there any unintended consequences as it relates to that particular piece of the law? And also, when we look at that, that's, kind of state by state, but it transfers with the child to the next state. You understand what I'm saying? So what are the potential unintended consequences as we redefine some of this language?
I'm going to turn it over to His Honor. But I would just say briefly, those decisions, okay, the court only looks at what it has at that moment. It doesn't project out into the future. And I know that we've had every so many years, they review the child support guidelines, and there is the shared custody model, and I think it's been modified, and I'm going to turn it over to some other folks that probably have more knowledge.
So I was also on the commission. I don't think it would impact it because it's not going to change if it's a certain number of nights. It's changing the terminology. So instead of saying you have visitation with your kid, you have parenting time. But it's not going to change whether you have the child for the certain number of nights. It changes the balance of the child support.
But don't we have that terminology somewhere else in the code?
Well,
so now we're changing. I'm just concerned.
I think we're trying to change it throughout the family law article to reflect. So like the judge said, it's not like being in prison. It's not like visitation.
So I understand. I'm just concerned that we're changing it here, but we may not be addressing it where we talk about those other things. And so there may be some inconsistency. Just raising that.
Okay, it's a good point. Well, we can look at it. Thank you.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing this bill and members of the panel. So I hope you can follow me. I'm looking at page 12, 15 through 18, joint legal decision-making to the parents. Then I come to page 11, number 12 through 13, to protect the child from negative effects of any conflict between the parents. So if we change it from custody to parenting time, how does the child know who is going to make the ultimate decision? Someone has to make the ultimate decision. If a child wants to go to, let's say, a black exploitation movie, and one parent says, well, I think you should see that because it's culturally enriching, and the other parent says, I don't want you to view that because it might influence your personality or character, who makes the ultimate decision whether or not the child can go, if you say parenting time versus custody?
I can take that. There's two different issues at play in your question, Delegate Conway. It is custody, legal custody, which is now going to be called decision-making, and custody, the overnights the child has with each parent.
I'm talking about the decision-making.
The first one. So that's called legal decision-making. So it's going to be very clear to the child who has the authority to make legal decisions for that child.
Thank you very much.
You're welcome.
Seeing no further questions for the panel, we thank you very much. I'm going to hear now from one person testifying in opposition, and that's Vince McAvoy for 2 minutes. Is he available?
Yes, thank you so much, Chair and Committee. I appreciate this. I am going to try and keep it brief, but I am available for questions. I've been testifying on this bill since its inception. Either me or my team, that is when I was heading National Parents Organization in Maryland affiliate, were at these meetings of the 2013 child custody hearings. The interesting thing that you haven't heard voiced here was that was an answer to consistent testimony around that time frame, well before most of you delegates on the horseshoe there, where fathers were coming in year after year explaining that Maryland courts were continuing to illegally and unconstitutionally favor maternal preference. Why do you delegates care about that? Because maternal preference was code in Maryland up till 1973 when Equal Opportunity changed that, and subsequent update to the Maryland Declaration of Rights. The disingenuousness that I hear with this bill it just seems to get worse every year. But I do want to echo what Delegate McComas said regarding the profiteering from family law lawyers. And so when they say we want to make this less combative, what they want to say is they don't really want to battle. They want to just be able to take the old forms, substitute names, and get their $250 billable. This bill does not do what they say. If they wanted to do that, they could have done what I suggested and created when I was at child support in the state's largest agency, which was create a parental rights list. I did proffer it to the lead attorney for child support. Unfortunately, it wasn't adopted. If they wanted to offer this information, they could do that. That still would not change the issue that we have in Maryland courts, which is a focus on maternal preference. What we can do about that in conclusion is to focus on fathers' rights as I do every year, offer to the number of delegates to take up some bills to cover that. And number two, 80% are pro se, create a localized court. I am available for questions. Thank you, Chair.
Thank you. Questions? Seeing none, thank you very much. That concludes the testimony on House Bill 1020. We're going to move along now to House Bill 1. Again, as I said at the beginning of today's hearing, we are going to hear testimony from a number of different people. Some of this testimony will be very difficult to hear and will be very challenging for the committee and for everyone here. We're going to ask everyone to, of course, we will be respectful. We're also going to be, lenient's not quite the right word, but we're going to be more giving with regard to time. Chairman Wilson is going to have as much time as he needs to talk through the bill. And we're going to allow certainly victims of past abuse to have the opportunity to talk about what happened and why they're here today, and give them the flexibility to be able to do that as well. So with that, ladies and gentlemen of the committee, just so that people are aware, there are 7 panels. We're starting now with Delegate Wilson, and we're happy to hear from you.
Good afternoon, Mr. Chair, Mr. Vice Chair. I'm Chairman C.T. Wilson here to represent to you House Bill 1. Seems like we've been doing this for a long time, Mr. Chairman. You know what I mean? House Bill 1, the overview of the bill is that it's going to eliminate the statute of limitations for victims of child sex abuse in the reporting in civil cases, as well as eliminate a statute of repose, which was something snuck into a bill in uncodified language that nobody here really knew about. It's create a permanent window for older claims, eliminate the notice requirement for public entities in child sex abuse cases, creates a cap per individual plaintiff. Why it's important is because child sex abuse remains an epidemic in this country. So will help arm these adults with the information needed to protect these children. Shifts the cost of abuse from the victim to those that cause the harm, and allows for some justice for victims when they are ready to come forward. A little context. I guess the reason this is of importance to me is, as I said earlier in one of my speeches, I grew up the oldest of 17 children, and unfortunately was placed into foster care and kind of bounced around looking for a home for years. It was a rushed adoption. There was no really oversight or background check, especially back then. The gentleman that adopted him was a kindergarten teacher. He was a Cub Scout leader, a junior pastor. He was a kids choir leader, and he was a pedophile. And after about 9 months before I was even adopted, things started to happen. And I was scared and unsure, but there really was nobody asking any questions, so there was no one to talk to. And then from the ages of 9 to 16, I was just the object of repeated physical and sexual abuse at the hands of my adopted father. So to be clear, this was never about the Catholic Church. I just had heard the cries of the victims of child sex abuse when I became a delegate, and I wanted to help. I was asked yesterday if I called all Catholics devils. I'm like, this isn't about them. I call people lots of names, as you probably know, but not like that. I don't generalize. But at the end of the day, even when I came up here, I never planned on telling my story the first time. I would just sit next to a young lady that was so scared, but she wanted to tell her story. And in the United States Army, the NCO creed is be the example. And so I just told people what happened to me. I couldn't imagine how many more times I would have to do that. And, even when we thought we succeeded, we were tricked. Even when I tried to work with the Catholic Church, there was a poison pill slid into a bill that nobody here that was here recognized or understood, or still don't understand how it got there. It had no legislative intent. So now I'm here today trying to fight not only to do the right thing, but undo what was illegally and unethically placed into legislation. You're going to hear from a lot of individuals today, and I just wanted you to hear it from a fellow legislator, how child sex abuse can impact you, not just as a child, but as an adult. As an example, I think when I first told my story, I kind of made a joke about how many times I've been married, and, I'm not good at it. Well, I'm not good at it. I'm sitting here on yet the eve of another divorce. My wife's, no, she's a good person, but she's tired. And who can blame her? You know, I guess I should have told her about my past before we got married, a little bit, but you know, I should have told her about the violent abuse by the only man who ever allowed me to call him father. I should have given her a choice, but I was selfish because I knew if I told her everything that happened, she would never have married me. Because, you know, love doesn't solve everything, and a lot of times it doesn't solve much at all. And that's just one of the debts that I have to pay, is another divorce that I'll have to pay for. Because see, when that abuse comes from somebody that's not a stranger, there's an emotional connection from a trusted person that maybe is supposed to care for you, protect you, that you provide solace. Someone who said that they loved you, how do you build on that? How do you establish a healthy relationship as an adult? You don't. Because you walk through life, you know, with a broken sense of reality. You know, when you have to spend a lifetime pretending that it didn't happen or that you could have stopped it, it's hard to really understand what the truth is. And then there's your self-confidence that's constantly bleeded because, you know, at the end of the day, you have to feel that either you end up falling like that you deserve what happened to you. But even worse, that you don't deserve any better. And when something good happens, you question it. You become hypersensitive because the best way to deal with rejection is never be rejected. So you always got one foot out the door. That way you can roll out and it won't hurt as bad. And when you're molested by someone who claims to love you, you realize really soon that it's only those that are closest to you that can cause you pain. So you make sure you keep everyone at arm's distance. Whether you're married to them or they're your children. There's depression, volatility, anxiety, fatalism, all these self-destructive behaviors that I carried throughout my life. Like I said, who can really blame her for being done? Because no matter how hard I try, these things seem to resurface at the worst possible times. Because when you're nourished by pain, destruction, anger as a child, what chance do you ever have of becoming a good man? Because the truth is, and I would tell her, this is me trying. I'm trying. This is it. But it's never going to be enough. Because when you're victimized, it removes your trust in people, but it also removes your faith in God. Why would he allow me to be such a damaged boy and turn into such a broken man? When you carry that shame around, that's a lie that you have to carry. And you have to keep people away from you lest they find out the truth of really what happened to you. But the worst thing is when your truth is exposed. Because I'm not just exposing my secrets, I'm exposing my sickness, the thing that causes me pain and injury. That's damaging mentally and physically, the thing that is going to destroy me and take everything from me. And I'm as sick as all my secrets. And that's why this hurts. I'm talking to you today because I know what it's like, and I know what these victims and these individuals that I sat in the hallway with deal with every day. I know what it's like to be that 8-year-old boy sitting in a doctor's office getting your eye stitched up, trying to explain what happened because the abuser's right in the room and you don't want to get hit again. Or being trapped in a Walmart change room being sodomized while there are people on both sides of you in other stalls and you have to keep quiet and keep the secret. Or when you finally tell the police when you run away and they just bring you right back to that person that abused you because they ignored everything you went through and don't believe you. I know what it's like to not dream, not have nightmares, because I don't. I just have memories of myself as a little boy, reliving that hopelessness and that pain with the mind of an adult. The visceral memories, the smell, the taste, the pain, those all come back to me. The emotional shame, fear, and hopelessness, those are my nights until I take trazodone and then I sleep that uneventful sleep. And I know about that internal monologue that plagues every one of us in all of our waking moments, and it is never a yell or a scream, it is a whisper. It is an agonizing and unexpected whisper that reminds you of your childhood in glaring and painful detail. But more than that, it raids you of your personal strength and self-confidence and your understanding and affection. It erases all the victories and accomplishments because it floods back in to steal your self-worth. Just when I think I am at the precipice of some success, it whispers into my head what I did, what I was forced to do. And it leaves me as a husk of a human being and utterly emotionally impoverished. And the older I get, it gets worse. I'm less inclined to fight it because I am tired. There was a time when I used to hear about friends and fellow soldiers that would take their lives, and I would be so upset. Now I just bow my head in understanding. We all get tired of trying to outrun our demons. And I think one of the greatest curses that everybody in this room is feeling today, no matter how hard they try, this is the devil right here, is hope. That one day my suffering will mean something more than just this pain and loneliness and loss that I have to deal with every day. It's my greatest torture that maybe God actually had a plan and a reason for my suffering. And something will happen to make it all worth it. Everybody I talk to outside today is terrified because they think that it might happen, that we might be successful. But in their hearts, they know that's never going to happen to them because they're not worthy. That something else is going to happen like it did in 2017 that tricks us, that has us thinking that we actually did the right thing when actually we did the wrong thing. And they're terrified, just like I am. Now, and I'm almost done, Mr. Chair. I appreciate the time. When I first came up here years ago, I remember I called myself a monster. And I guess that was a little bit of a misnomer because the internet went ablaze with me thinking I was a hidden pedophile, because why wouldn't they, right? But I know the rage and anger and pain that fuels my very core of existence. And those y'all know me, you know who I am. This is me at my best, and this is me trying, but I know who I am. But it was a misnomer, because you know what? I'm not a monster, but 69% of the abusers were they themselves victim of child sex abuse. Yeah, those monsters are real, and they're out there. And as bad as I am, I'm not the monster, and I'm not your worst nightmare. Because they're out there right now, and they're victimizing other children. And they need to be identified, and they need to be stopped. This bill would at least help them, help us identify these hidden predators, these monsters, before they create more victims like me and like the people you're going to hear from. Because there is no amount of money that will ever get me to right. I will continue to keep losing. No matter how much I build, how much success I have, it falls hollow. Not just when I sleep, but when I wake. I have to do these exercises every day just to keep my together. And I know one day I'm not going to be able to keep that up. And I hope my daughters are way too old to care. But I know one day I'm not going to be able to keep this up because I don't have the energy. And I've been doing it way too long. This bill creates an opportunity for, it won't undo what's happened, It's not going to help me at all. There's nobody I can sue. But one of the things I was at least able to take advantage of in this position is giving a voice. It's going to give other people voices too. It allows victims of child sex abuse to have their voices heard in court, to face their abuser in the institutions that allowed these things to happen, to possibly get justice and maybe find closure. I pray that for everybody that comes up and talks to you and for all those hearing, because closure seems impossible at this point. It's just a daily dealing and hoping that your demons don't catch you. So I just ask at a minimum that we send a message to the predators and to the institutions that harbored and protected these bastards, that their day of reckoning is finally at hand, that they are responsible for the pain and damage that these survivors live with every goddamn day, and that they share some of that burden. And that Maryland will no longer allow the voice of a child sex abuse victim to be silenced because of some legal loopholes or a lapse in time. I ask you to please move favorable on House Bill 1. Thank you.
Thank you. We'll hear now The instruction I'm going to give to staff is that we will run a 2-minute clock. I'm going to ask it to be stopped just before it hits 2 minutes, and I will signal whether to restart the clock or not. So we're going to give people time and flexibility, but we do want to hear from everyone, and we want to make sure that everyone is fairly heard. So that's why we will still be running the clock on the screen. I think more as a suggestion than as an order. All right, Catherine Robb now, please, followed by Kathy Hoke, former Delaware Senator Peterson, I think, correct? And then Kurt Ruprecht, please. So Catherine Robb, please.
Thank you, Chairman, and thank you, members. I, too, am a survivor of child sexual abuse, and my abuse did not happen in the church. It happened in the family, where most abuse occurs. I am also the Executive Director of Child U.S. Advocacy. We work on this type of legislation all over the country and also in Congress. The data tells us that 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. Most will be repeatedly assaulted. The data also tells us that according to the science of traumatology and the science of delayed disclosure, that the average age that a victim will come forward is somewhere between 50 and 70, with the average age being 52. I didn't speak publicly about my abuse until I was in my 40s. I think that you may hear sort of sky is falling types of exaggerations and alarms, and I'm just here to tell you that they're false. First, you'll hear that Maryland may be an outlier. Maryland is not an outlier. Maryland is actually in the back of the class. Presently, we have 24 states and 3 U.S. territories that have passed revival legislation. We also have 15 states, 2 territories, and the federal government with Senator Durbin's bill that has completely eliminated the statute of limitations for child sexual abuse. This year alone, we have 30 states that are passing this type of legislation. There are 22 eliminations, 18 revivals and windows, and 10 permanent windows. It is a national movement by legislative bodies across the country to respond to this epidemic. 0 states have passed caps on damages. Why? Because we know that caps really benefit the bad actors, the bad institutions. They do put plaintiffs at a very big disadvantage. Second, you might hear that the courts would be flooded, that courts can't handle this flood of cases. I'm here to tell you that that is wrong. It's not even close. We looked at 11 states, and of all of those states, we gathered the data, and 1/4 of 1% of the population overall filed claims. The courts were not flooded. The courts handled it just fine. You may also hear that this isn't fair, that public entities are treated different than private entities. So just a few things on that, and Chairman, I'll wrap it up. The state and the taxpayers already bear the financial burden of this epidemic. It burdens our educational systems, our social systems. It burdens our penal system, law enforcement. The list goes on and on. The state is bearing the burden of this problem every day, every year. The other thing I'd like to point out about that argument is that private entities don't give the services that the public entities give, right? They don't give, police services, sanitation services, public schools, right? Where the state already has that burden. I'd like to end it there, and I'm happy to take any questions about what's happening across the country and in Congress as well. Thank you, Chairman.
Mr. Chair, members of the committee, I'm Kathy Hoke, a professor at the University of Maryland Carey School of Law, here in support of House Bill 1 with the sponsor amendments, and I first want to thank Chairman Wilson and all of the survivors who have trusted me with addressing this difficult legal question that is before you, that I think has been rendered less difficult over time. So the question is whether the bill that was passed that amended Section 5-117 of the court's article in 2017 created a statute of repose. What even is a statute of repose? Whether that's just a statute of limitations. The real critical question being, regardless of if it's a statute of repose or of limitations, can you repeal that and revive claims that have been extinguished because of the passage of time? First, on the question of whether this is a statute of repose, despite language that you see in the bill, it does not meet the criteria for serving as a statute of repose. The most important part, the true characteristic of what makes a statute of repose, is that the triggering event for the running of the period of limitations is not injury, and that injuries, that claims that could accrue, that accrue after the period of limitations are extinguished merely by the passage of time. So we have 5-108, our court's article, the one statute of repose we have that relates to building construction, right? After 10 years, an architect, even if negligent in the design of the building, walks away with no liability. It doesn't matter if someone was injured or not, because injury is not the trigger for the running of the statute of repose. This really, you can call something a duck, but if it doesn't whack and waddle, it's not a duck. 5-117 doesn't meet the hallmark conditions of being a statute of repose. Injury has to occur for the limitations period to run. I have far more of that in my multi-page testimony here. But let's just say whether it's a repose or limitations, the big question for you, and I appreciate that you want to answer this question, it's conscientious legislating. Can we constitutionally repeal the statute of repose or limitations and revive those extinguished claims? That's actually a tougher question than the first one, because the Supreme Court of Maryland, or in its previous version as the Maryland Court of Appeals, has not answered that question directly. Eaten around the edges of it, but not answered it directly. I think the best answer comes from you and what this body did in 1991 with Section 5-108 that I just referenced. There was a change to the building statute of repose that allowed for certain claims related to asbestos, and that was applied retroactively. I looked through the entire bill file. Believe me, that was the intent. You can read the statute yourself, and it makes it clear. And there's a letter from the Attorney General's office at that time, Attorney General Curran's office, that said that was constitutional. And in fact, when the bill went for its AG review, the Attorney General again repeated that that repeal with retroactive application was constitutional. And today, our Attorney General has advised that this is a sticky question. It is not clear. There is not clear evidence from the Maryland courts as to whether this is constitutional, but he will defend it. I will defend it. You have done your due diligence on that question, and it is time for all of the strong public policy reasons that you have heard and will hear to pass this bill, and the courts can decide that question of constitutionality. Happy to answer questions when time comes. I encourage a favorable report on HB1 with the sponsor amendments. Thank you.
Mr. Chairman, members of the committee, my name is Karen Peterson. I am a retired state senator from the state of Delaware and was the lead sponsor and author of Delaware's Child Victims Act that we enacted 16 years ago. It's interesting to see that not much has changed in 16 years. All the arguments and dire predictions are still the same. Churches and schools will close, businesses will go bankrupt, courts will be overburdened, false accusations will be made, nonprofits won't be able to get insurance, and so forth. Same scare tactics, different year. 14 years ago, I wrote a letter to the Maryland Senate Judicial Proceedings Committee, 2009. What I said in that letter was true then, and it's still true now. Not one church in Delaware closed because of our Child Victims Act. Not one school closed. Not one charitable program was discontinued. Not one organization was forced into bankruptcy. And not one allegation was deemed to be false. In short, the sky didn't fall in Delaware or in any other state, and the sky won't fall in Maryland either. Please don't let the opposition scare you off with their dire predictions, and please don't let them gut the bill with amendments, as they tried to do in Delaware. Altogether, there were 7 amendments introduced to my bill, and we defeated all 7. Two things happened after we passed the Child Victims Act that you can expect to happen in Maryland as well. First, the Diocese of Wilmington filed for bankruptcy protection, which they do in every state that passes a bill like this. And second, they appealed to the Delaware Supreme Court to have the law declared unconstitutional. They lost. In the end, 177 claims were filed, and all of the victims who had the courage to come forward received compensation from those who caused them harm. But the real value of this bill cannot be measured in dollars and cents, because if this bill becomes law, Maryland's children will be safer, child sexual abuse victims can finally get justice, and those who molest children will find that they no longer have a safe haven in the great state of Maryland. I'm asking that you please be the voice for the children who had no voice in the past. Thank you.
I understand the sentiment, but I would ask members of the audience, we don't applaud, please, in the committee room. Mr. Ruprecht, please.
Thank you. I must say it's an unexpected honor to be here next to Senator Peterson today. Chairman Clippinger, ladies and gentlemen of the committee, thank you for this opportunity to speak on behalf of myself and those of us who suffered on the Eastern Shore of Maryland and suffered today at the hands of the Diocese of Wilmington. I'm speaking in support of the Child Victims Act. My name is Kurt Ruprecht of Forest Hill, Maryland. I am a survivor of childhood clergy sexual abuse. When 8 and 9 years old, I was groomed, sexually and violently assaulted by Father Joseph McGovern at St. Francis de Sales Parish in Salisbury, Maryland. Today, I can still feel and smell the polyester of his liturgical vestments, which he had me hold in my arms while in the church sacristy. He would open his pants to expose his genitals, then hug and press me against them. Alone in his car, I can feel his left hand squeezing and smashing my genitals, feel his right hand squeezing and choking my neck, see his enraged face, hear him screaming, "God wants you dead," in what I thought was my last breath before he killed me. In my written testimony, I provide greater context and detail of my events. If you are at all undecided on this bill, I humbly ask you read my full statement. We need you to know these predators are as savvy at winning the trust of the victims and families as they are savage at the child rapes they commit. The emotional and physical damage done to children can only be fully understood by a fellow survivor. Science and medicine now comprehend the depths of our damage and prove how our laws on childhood sexual abuse are vastly outdated. Our families also suffer with us every day, always on guard for our triggers and worried for our safety. If you remember one statement from me today, it is this: there is no true healing from this type of childhood trauma, only survival. Enough about me. When Joseph McGovern first arrived in Salisbury as a seminarian, his mentor was our pastor, Father William Irwin. Irwin was also a sexual predator of children. McGovern would eventually be transferred among 5 different parishes over the next 6 years, sexually abusing young boys in every location. The Wilmington Diocese had predator priests assigned in 85% of their parishes in the 1960s through 1990s. Fun fact, Wilmington is one of only 2 dioceses in the United States that crosses a state line. We know of the Wilmington strategy to focus their predator priest assignments in Maryland. We know of the gentleman's agreement between the diocese and Delaware prosecutors, whereby diocesan priests understood the colleagues who were accused of sexual abuse in Delaware were not investigated by the police in Delaware, but sent for treatment at St. Luke Institute in Maryland. After treatment, they were not allowed to return to Delaware and instead assigned to a parish on the Maryland side of the diocese. Analyze the Washington Diocese membership population versus locations of predator priest assignments, and Catholic children on the Eastern Shore of Maryland were 11 times more likely to be exposed to a predator priest than Catholic children in Delaware. Of the 59 Wilmington parishes, St. Francis de Sales in Salisbury, Maryland was the worst, with 10 predator priest assignments at that parish alone. How do I have all this information? Because in 2007, the Delaware General Assembly had the courage to pass their Child Victims Act. That movement began when the abuses by Wilmington were partially discovered by the 2005 grand jury investigation into the Archdiocese of Philadelphia. The survivors and citizens of Delaware demanded action. That law empowered survivors to drive the legal discovery, to bring the secret church files into the light, and require testimony from church officials. Today, in 2023, in Maryland, I do not have access to justice for many of those same documents. Joe McGovern is still alive and living on his diocesan-paid benefits. My parents are alive and are able to corroborate the times and places of my abuse. My abuse occurred 6 miles on the wrong side of the Mason-Dixon line. It occurred in Maryland, where my justice delayed is truly justice denied. All of you have the power to change that. I implore you to support HB 1. Thank you.
Thank you all very much. Are there questions for this panel? Delegate Cardin.
Thank you very much, Mr. Chair. Thank you guys for testifying. I'm sorry. I proudly voted in favor of legislation similar to this in years past, and it's making me proud now to say that I did that, even though this is a very tough bill, because as a lawyer, you want to make sure you're doing it right. You want to make sure it's constitutional, and you want to make sure you're not denying anybody's rights, even though you need to help people that need to be helped. Money was talked about in the past. That's not the issue. It's the issue is making sure that we give people the opportunity to get some, well, you talked about it. It's not closure, but some kind of results. I understand that. If you have an institution, and I think this maybe is for the gentlelady next to you, Delegate Wilson, if you have an institution that is clearly had people who were hurting children, and those people are no longer there, and that institution could actually it could be facing, I don't know if it's bankruptcy or facing some financial issues. And if the money is not the issue, but making sure that we right the wrongs, how do we make sure we protect an institution that has done its best to rid itself of all the wrongs that it's done, tried to make amends as best as it could, but faces the problem of possible closure, even though it doesn't have those issues with it at this point? That's what I'm trying. Do you understand my question? I'm sorry I'm not as articulate.
No, I do, and I do hear it all over the country. And I think I'm going to respond as an attorney, and my response would be that is very much a factual question that has to be answered based in terms of the agreements that the businesses had and all of that. So, I think it's going to be very fact dependent, right? If institutions have behaved well, they have nothing to worry about, right? And I think the other thing I'd like to say is, I believe in due process. I believe in our system, but I also know that we have, safety nets in place. We have the rules of evidence. We have our, civil court rules. Plaintiffs have to survive a motion to dismiss. So we have a lot of safety measures in place. And, if they can't prove that connection, then they can't prove it, and they don't move any further through the system itself. But I would say that it is very much case by case, factual by factual, and depending on the business entity transitions that they had, the contracts that they had, all of that, it's going to be very much fact dependent.
Delegate Kaufman.
First of all, thank you, Mr. Chairman. First of all, I texted a colleague, Chair Wilson, and it's true. I said, I wish I could give you a hug. So I wanted to see if you've had the opportunity to see Mr. Silverman's testimony with the Tort Association. And he talks about the importance of a statute of limitations, citing, how all these other like drunk driving cases, if you're injured in drunk driving, et cetera, et cetera. And he talks about how important the statute of limitation is. And so I just wanted to give you an opportunity, Mr. Chair, or somebody else on the panel to rebut that, in the sense that, can you talk a little bit about the consequences? You talked a little bit about it with your failed marriage, Mr. Chair, but can you talk a little bit about the consequences of the failed statute, of the statute of limitations? Because, they're raising a lot of cane about how important it is, but what are the consequences?
And thank you for the question. Before Ms. Robb steps in, I just want to say kind of what I was saying. The damage is still tolling. And again, this is something, as you heard, that most people don't even start talking about until they're in their 50s, because this is always the worst day of the year for me. I dread this. I'll be messed up. This destroys my family every time I do this. And I have to live with myself every day. These people that are going to come and speak with you, most of them don't have great lives. And this is the one thing I guess they're holding on to. So when should it kick in? When would the statute of limitations start? When does my damage stop tolling? When can I say the cost is finally over, so now here's the receipt? That's never going to happen. And I think that's the problem with the statute of limitations in this bill, is when the injury happened versus when you even acknowledge. Like, as I said, denial it's a part of my survival. You think if I thought about this every day and didn't pretend it didn't happen, I couldn't exist. So for people that go years and years, there needs to be that time to acknowledge. And what the statute of limitations in this specific circumstances does is it says, it doesn't matter what that abuser did to you. You better square your shoulders and you better deal with it. You better come out and you better let everybody know what happened. You better put your most embarrassing secrets out before you're ready, because we're ready now.
Thank you, Chair Wilson, and it'll be my honor to support this bill.
Thank you. And I think briefly.
Yeah, if I could just respond to that as well. These are not typical torts. These are not a slip and fall. It's not even a breach of contract. We're talking about the rape, sodomy, and sexual assault of our children, right? This is a very, very different type of tort. And I'll just say this to everyone in this committee, and I thank you for hearing us. And that is, you don't have to be an attorney. I'm not sure how many are attorneys or not. You don't have to be an attorney to know what common sense looks like, to know what justice looks like, to know what fairness looks like, to know what sound public policy for our children looks like. So I would just respond that these are very, very different torts and should be treated accordingly.
Thank you. Are there further questions for this panel? Seeing none, Chair Wilson, they need you through there.
Thank you.
Otherwise, thank you all very much, and we're going to move on to the second panel. These are going to be in panels of 5. I think they were listed as panels of 4, but we're going to go ahead and put panels of 5 up there. Meg Venton, Dr. Wendy Lane, Mary Mueller, David Lorenz, and Judy Lorenz, please. The Vice Chair is going to take over for just a few moments.
Sorry, we're missing two people here. Meg Benton, Wendy Lane, Mary Mueller, David Lorenz, Judy Lorenz.
Wendy Lane has the flu. She won't be able to make it today.
Okay. Frank, what about Meg Benton? All right. Mary Mueller? No. Do we have Frank Cross? All right. Buddy Robson?
He wasn't able to make it either today.
Okay. Jean Wenner? Okay. All right. Whoever would like to begin. Yeah, whoever would like to begin, just start. You can start with your name.
Hello, my name is Megan Benton. I strongly support HB 1 with the sponsors' amendments. I'm not going to talk about what happened to me. It's a matter of record. Washington Post, August 19th, 2018. I'm going to get through this with my dignity intact. I will say that when I told my guidance counselor about this perpetrator, when he was trying to determine why I seemed to be psychologically and academically crashing, his reply was, "I know, baby. I've got eyes." So many perpetrators, dozens of victims, were involved at this school. Only one person was fired to my knowledge, and it was done quietly. I will say that what happened to me has had a profound influence on my life, on my relationships, decision-making, emotional and physical health, and my ability to trust anyone to not be a predator. I have to work every day to minimize its impact with many hours of cognitive therapy, and I am coming up on being a senior citizen. It's tremendously difficult and frightening to report sexual abuse at any age, but when one is somewhat older, one has a better chance of withstanding the tremendous emotional fallout, the horror, pity, disgust, isolation, the excruciating feeling of exposure. Please help us shift the burden of this sort of damage off of the taxpayer and rightfully onto the shoulders of the institutions that used us with such impunity. Let's also expand the threat against future pedophiles and the institutions that shelter them. Let's save some lives. For these reasons, I respectfully urge a favorable report on HB 1 with the sponsors' amendments. Thank you.
Just for those of you who are testifying, it's not necessary for you to press any of the buttons, to touch the microphones. It'll pick up. Just make sure it's pointed towards your mouth. Okay, fine. Okay.
Thank you. My name's David Lorenz, and I'm a survivor of clergy sexual abuse at the hands of a priest at the age of 16. And I am the Maryland Director for a Survivor Support Group. At the Senate hearing for this bill, multiple survivors and experts testified that nothing in this bill allows for unsubstantiated claims. Survivors only want the doors of justice to open to them so they can present their case before a judge and a jury. They do not want to be the judge and jury. But imagine my surprise when the Catholic Conference written testimony states, quote, "The devastating impact that the retroactive window provision will potentially have by exposing public and private institutions to unsubstantiated claims of abuse cannot be ignored," unquote. Numerous independent investigations of the church around the country reveal how the church obfuscates and obscures. These reports show that the church will declare an allegation unsubstantiated when the perpetrator tells them they didn't do it, when the perp is deceased, or they perform an investigation but don't bother to interview staff, colleagues, or even the victim. This isn't the only way they do redefine words. They will say inappropriate touching or boundary issues, when in fact the victim was raped orally, anally, or vaginally, including a 3-year-old girl. My own abuse took place when I was 16 by my priest, who had 50 allegations against him before being assigned to my high school as the guidance counselor. The recent revelations from the Maryland Attorney General shows that the church is still using this practice. when they make public statements. Bishop Laurie claims that 30 of the newly identified perps were not identified by the diocese because they were deceased. The claims that the church has changed their ways is demonstrably false. They still say deceased means unsubstantiated. Another tactic the church uses to keep victims and families silent is to threaten them. One victim I know was told she would go to hell if she told anyone. In November of 2021, in response to an abuse allegation concerning a teacher and a pastor of a church in Silver Spring, the pastor posted a full-page letter in the Sunday Bulletin suggesting that the accuser was, quote, devil himself. He said this even while there was an active criminal investigation and yet did not notify parents of the allegations. My written statement contains references to the AG reports that I talked about and the full letter from the pastor. And one more thing. Bishop Laurie used his pulpit to condemn the facts presented in the Keepers as fictional, but as yet has to provide any evidence to refute any of those facts presented. I want to thank you, the committee, for supporting this bill in the past, and I urge you to vote favorably on HB 1.
Thank you. Good afternoon. I'm Judy Lorenz, asking for a favorable vote on House Bill 1. Here are my testimonies from past years, some of them anyway. I recently stared at my computer and keyboard wondering, what can I say this year to make a difference? I couldn't think of a thing. So this year I'm giving you highlights of the past testimonies because I realize it's up to you to make the difference. 2015 testimony. My husband tried to tell me of his abuse before we got married. His attempt was convoluted, which often happens when survivors first tell their story. From the little bit he was able to share, my horrified reaction shut him down. 10 years later, he was forced to tell me as his perp was publicly accused. 2016 testimony. I come here again imploring this body to vote yes. I begged Chairman Valerio to stop stuffing the drawer and allow a vote to happen. I shared with a shaky voice the reasons why victims cannot come forward with their stories until much later in life, if at all. I sat with stomach churning and blood pressure rising as the opposition makes up stories about how harmful this legislation will be. So I ask, what are you going to do about it? I hope with all of my heart that I will not have to testify again next year. 2019 testimony. Survivors have been in this chamber for decades seeking this type of legislation. We need a look-back window so past victims can finally be heard. The law will not guarantee survivors a big cash reward, just the opportunity to be heard and perhaps receive just compensation if a judge or jury deems it appropriate. Give them that chance. 2020. I'm here to say enough. 2021. This I submitted on behalf of survivors due to COVID rules. It starts with the survivor, quote, he then put a gun to my head and pulled the trigger. I quoted 15 more survivors and ended with this one. And then I am blamed for not speaking out earlier. 2023. You see the pattern. You were voted in to make a difference. Please vote yes to HB 1 this year and make 2023 my last appearance. I am so grateful to this House for passing this in the recent years, and I urge you to do so again. Thank you. And tell your senator friends to do the same.
Good afternoon. My name is Frank Cross. I'll do my best to speak without notes because I think I'd quaver through most of them. I may be a little different than the others who have testified so far. I've been an adopted Marylander since 2000. My background is I'm a social worker. I'm a lawyer. And for 40 years, I've worked primarily with kids who have suffered trauma, such as much of the sexual trauma that you've heard talked about. My undergraduate degree is from Creighton University in Omaha, Nebraska, a well-known Jesuit university, at least in our region. My law degree is from the University of Notre Dame. I was recognized by this governor's office in Maryland for my efforts on behalf of children who've experienced traumas, particularly around the issue of suicide, and the State Council on Child Abuse and Neglect also received recognition from them for the work done on the Adverse Childhood Experiences Trauma Act. And I tell you all that beforehand because I too am a survivor. It just didn't happen in this state. Probably my neighbors can see I'm shaking pretty good right now. My heart's pounding. I haven't done this before. I did not disclose until age 58. It was to my daughter almost by accident because I feel safe with her. This is the first time I've made any public disclosure. And I do it for a lot of reasons. You have my written testimony. That was mostly from my lawyer hat, providing the written testimony, maybe responding to some of the questions earlier. Coming down here was by far the hardest thing. But here's why. I wanted you to see me. I really wanted you to see me. I wanted to look in your eyes. Because the statute of limitations is designed when people aren't responsible. It's designed for predictability when there's a car accident, when there's a slip and fall, when there's a contract work. But it was never intended for children who experience the worst kind of betrayal of trust. And even if you say, well, those children had adults that should have been looking after them, often those adults didn't know what was going on. My parents, now both deceased, never knew because I never told. And I wanted you to look at me because I'm not an irresponsible person. In fact, this body passed the law that created Maryland's first trauma-informed care commission. I was appointed to that commission. So I serve you. Because I wanted you to look at me and see I'm not irresponsible. I'm not lacking knowledge about the law. All those reasons that the statute of limitations was created. Way back in English common law. None of those apply here. But mostly, I wanted to make sure you were aware that delayed disclosure is normal. It's not unusual. It's normal. And in my written testimony, I provided you all those citations. The science is overwhelming. The science. No one that could be accused of being biased, but the science. And most of it puts the average age of disclosure somewhere in a person's 50s. I'm a little later on that scale. So it is not some unfairness. It is not an uneven balancing. It's only fairness. Because if I'd have named your act, if I'd have named this act, it would have been named the Access to Justice Act. Because that's all that's being asked here. Access to justice. But we don't get access because we didn't disclose early enough. And that is what's not fair. Because all of the protections of the judicial system apply to both sides once access is granted. Every one of them, and several of them have been outlined already. The rules of the court, the rules of evidence, the rules of the procedure, the right to be represented. Each side gets that. But we don't get even the access to justice. And so I wanted you to see me. I wanted to look you in the eye. I had a mentor who told me, Frank, when decisions are difficult, when they're really, really tough, and most of life is like that, what you got to do is you got to lean toward the light. Lean toward the light. And so I wanted to look you in the eye and say, please lean toward the light. Because access to justice is the least that we deserve. The least that we deserve. And why would anyone want to protect the people who did this or the organizations that supported them? And I'm no anti-Catholic church person. That's why I told you where I went to school, even as an adult. But that's not an excuse. We just want access to the gates of justice. You can provide that. And I support your support for this bill.
The next person who would testify, I'm going to need you to switch seats because we have to have you on the camera. Whenever you're ready.
My name is Jean Hargett Wayner, and I strongly support HB 1 with the sponsors' amendments, as it would abolish the statute of limitations for child sexual abuse. I was sexually abused and raped at Archbishop Keough High School by Joseph Maskell and others between the years of 1967 and 1971. These predators could not have been that mean, evil, hateful presence in my life and just be showing up at Keough. They had to be doing this in a lot of places. And you know what? They got away with everything they did. Accomplices to these crimes are the institutions that allowed innocent children to be left in harm's way. I'm going with more of a timeline because I have a lot I could say, and I know this is not the time to do that. The trauma I endured during those years was so great that in order to survive, I had to sever from the young victim and bury her deep within my subconscious. This is called dissociative amnesia, otherwise known as repressed memories. I began remembering the abuse 20 years later in 1992 at the age of 38. I met with archdiocesan representatives and gave 2 formal statements. Following the first one, Joseph Maskell, who was in his 50s, was removed from his parish and sent for evaluation. In 1994, Teresa Lancaster and I agreed to file a civil suit against Joseph Maskell and others. I said yes, not to bankrupt the church, but because the Archdiocese returned Maskell to work as a pastor at a neighboring parish. The thought that he was in the area and knew that I had said bad things about him terrified me. I had visions of him shooting me and my family with the gun he threatened me with at Keough. We lost our case and were held to the 1971 3-year statute of limitations due to the court's decision that repressed memories were not scientifically proven. Today, the science behind the effects trauma has on the brain has grown, allowing dissociative amnesia to be understood and accepted. Like any physical ailment, our mind and spirit cannot be forced to heal in order to comply with the courts. I respectfully urge a favorable report for HB 1 with the sponsors' amendments. Thank you.
Are there questions for this panel? Seeing none, we thank you all very much for coming and testifying today. I'm going to call 5 more names: Susan Karen, Teresa Lancaster, Paul Zadunek, Gemma Hoskins, Donna Vandenbosch.
Good afternoon, members of the committee. My name is Teresa Lancaster. I'm an attorney, I'm a survivor, and an advocate for victims of childhood sexual abuse. I come here every year to speak for the victims that have not yet found their voice. I was abused in 1970 through 1972 at Archbishop Keough High School by the counselor there, Father A. Joseph Maskell. You may know me from the Keepers documentary, which exposed a powerful sex ring at Keough. I was unable to come forward about my abuse in the 70s because Maskell convinced me that no one would believe me, and he threatened me with his gun. I feared for my life. This is common among survivors. Why? The severe nature of the trauma coupled with the often high social position of the abusers, are factors that prevent survivors from coming forward earlier. Other factors are depression, substance abuse. I struggle with the fact that my abuser was someone I trusted, a Catholic priest. Father Maskell was assigned powerful positions by the Archdiocese of Baltimore. He was a police chaplain, as well as a military chaplain for young recruits. He always had access to young victims. Through my work helping other survivors, I learned that Maskell abused kids as young as 3 years of age. Cardinal Keeler knew my case and Jean's case in 1994, the Doe Roe case, was credible, but used a statute of limitations to make it go away. As a direct result, Maskell was given free rein to continue abusing children. The church has a long history of hiding their pedophile priests and shipping them from parish to parish. This bill will provide a path to justice for victims ready to come forward. It will help identify hidden predators and disclose facts of the sex abuse epidemic to the public. For these reasons, I urge a favorable committee report and passage of House Bill 1, the Child Victims Act of 2023. Thank you.
Hello, and thank you for allowing me to testify today and tell my story. I'm in favor of HB 1. My name is Paul Jans Dunik, and I was abused by a troop leader in the Boy Scouts of America. I was only 8 years old, and this abuse lasted for 3 long years through 5th grade. Every week, I was abused and raped several times. This abuse included forced masturbation, oral copulation, penetration, and other unimaginable acts. To make me feel special, I was plied with alcohol, rum and coke to be exact, and shown porn magazines and porn videos. My abuse, one of the worst cases in the 82,000 cases of the Boy Scouts of America class action lawsuit, had a devastating and long-lasting effect on my life personally, emotionally, physically, and destroyed many of my personal relationships, as many have talked about today. While the Boy Scouts of America has been found guilty and is paying a $2 billion fine, many of us are now finding ourselves re-victimized because of the statute of limitations in the state our abuse happened. One of those states is in Maryland, where I was raped. These children of sexual abuse shouldn't be punished again just because of the state they grew up in. The state they were abused in was beyond their control. In addition to my abuse by the Boy Scouts, I was abused by an adult male in the Catholic Church choir between the ages of 12 and 16, and psychologically and sexually abused by a Catholic school teacher from 6th grade through 9th grade, all in Maryland, where I can't do anything about it, even though my literal nightmares continue still to this day. On behalf of these victims, I'm here to shed light on the statute of limitations technicality that might be re-abusing your own son or daughter, your mother or father, or even your own spouse. There is no cap on my suffering. There should be no cap on the damages. All of us grown-up children are depending on you to help us. Thank you.
Good afternoon. My name is Donna Vondenbush. I'm a certified nurse practitioner with a master's degree in nursing. I am here today because of 2 priests, Joseph Maskell and Neil Magnus, sexually abused me. Because of that abuse, I suffered a trauma-induced brain aneurysm and 3 heart attacks. And I live with herpes. I know you are aware of my communication difficulties, so please be patient with me. But I survived. Some of my friends who were also molested did not. They committed suicide, had eating disorders, and drug and alcohol addictions, and were not able to have children because of the physical damage to their genitals. Many had illegal abortions performed by Dr. Christian Richter at St. Joseph Hospital in the middle of the night, brought there by Maskell. The Archdiocese of Baltimore has always had a representative on the board at St. Joseph Hospital. Heinous and violent crimes were committed. I often wonder, how many children did these pedophiles father? We need your help. I need your help. Our injuries are profound and impact our families, our employers, our friends, and all our relationships. It took a lot for me to come here and expose myself like this. I hope you find the same courage to stand up for me and others doing the right thing. Pass the Child Victims Act. None of us want to be in mental, emotional, spiritual, physical pain anymore. What are you going to do? Thank you.
Good afternoon. My name is Gemma Hoskins. I am a retired school teacher and a former Maryland Teacher of the Year. I also had the honor of participating in the Netflix docuseries, The Keepers. But today I'm here in a different role. I'm here as an advocate for those survivors who are not yet ready or able to tell what happened to them. One of them has given me her permission to tell you what happened to her. So I'd like to ask everybody in this room that has a family member under the age of 5 to please raise your hand. Many precious children. At the age of 3, this young woman, this toddler, was taken from a daycare center by the parish priest to the basement of the center. She was blindfolded. The daycare providers gave permission and they knew what was going on. She was blindfolded and the priest told her they were going to have fun making a movie. As he filmed, young teenage boys, also groomed by him, molested her. At one point, she thought she was holding onto an umbrella handle. It wasn't an umbrella handle. On another occasion, the priest told her father was going to take her to lunch at the Cross Street Market. So he walked her down Warren Street, and her father, of course, was not there, but he tried to sell her to men in passing cars. Nobody took him up on that, but nobody reported a priest with a 3-year-old prostitute on South Charles Street in Baltimore City. Because she was so young and so tiny, this priest, Joseph Maskell, was not able to penetrate her sexually. So he put her on a dining room table and he raped her with a crucifix. If the Child Victims Act is not passed, this woman and many others will have no recourse, there will be no accountability, and there will be no justice. So I am begging you to please make sure that this is a favorable vote for her and for all of the adults, many in this room, who have a wounded child living inside them that will always be there. Thank you.
If you would please switch seats with the person to your right so that we can put her on the camera, please. Thank you. Go ahead.
Good afternoon. My name is Susan Karen, and I'm the Executive Director of Maryland Catholics for Action. We were founded after the Pennsylvania grand jury report came out about clergy sex abuse there, and we offer an alternative narrative regarding this scandal. That narrative is that many lay Catholics want justice for survivors of child sex abuse and protection of children. I have submitted our written testimony, but I want to focus on a key point from a witness who could not be here today but spoke at the Senate hearing. Her name is Jennifer Gross. She is a licensed certified social worker as well as a certified sex offender treatment provider. She speaks to the issue of false claims. Data shows that this is incredibly rare. The Leadership Council on Child Abuse notes that when 4 states did a review of Child Protective Service records to determine the extent of false reporting, they found intentionally false reports to comprise much less than 1% of unsubstantiated cases. Actually, children tend to understate rather than overstate the abuse. The NGO Darkness to Light noted that some of the fabricated reports were made by adults involved in custody disputes. Sadly, the real issue is that most survivors never come forward. That is, they do lie. They deny that the abuse has happened or try to cover it up. This is due to stigma, society's tendency to not believe the survivor or to judge them harshly. And of course, it's painful. They also realize that evidence may not be as strong as some other cases. This speaks to the importance of civil suits. HB1 will give survivors access to disclosure and also help them to identify other survivors. On behalf of Maryland Catholics for Action, I ask that you bring darkness to light on the epidemic, it's an epidemic, tragedy of child sex abuse by issuing a favorable report. Thank you.
Are there questions for this panel? Seeing none, we do thank you very much for coming here today. Frank Schindler, Lisa Jordan, Davion Perry, Sarah Conway, Vanessa Milio. Start with Ms. Jordan, work our way across, and thank you very much. Ms. Jordan, please.
Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, the coalition of the rape crisis centers across the state of Maryland. As you've already heard, and you'll hear more of, this is a survivor-oriented approach to help survivors of sexual assault seek justice, and MCASA is in strong support of House Bill 1. MCASA has supported expanding the statute of limitations for many years, and we continue to support this expansion and all of the survivors advocating for it. We also have to express our appreciation for Delegate C.T. Wilson and his willingness to share with his colleagues the horrors of his story and to reopen his scars. Rather than repeat the testimony you've heard, let me ask the committee to consider this. These efforts to expand the statute of limitation they've dragged on for decades. And at this point, the reality is there are many cases that theoretically would fall into the 2-year look-back window, and there's no tort attorney in Maryland that's going to take this case. There are perpetrators and collaborators who have died, businesses, schools, churches closed, memories faded, likelihood of winning a lawsuit is low. And there are not as many perhaps as there were a week ago, but there's still some real concerns about the constitutionality of reviving claims, and certainly any ethical attorney would advise a client of these risks. And some survivors will choose not to endure the rigors of litigation given the constitutional concerns. MCASA asks you to consider the survivors whose abuse falls within the look-back window, but who will not have meaningful access to private tort cases. We ask you to consider authorizing the Attorney General to file suit for survivors when the potential recovery is too low to attract the private bar, or may simply prefer public representation. Penalties could be imposed instead of attorney's fees, similar to the process proposed in the civil rights bill you heard yesterday. And I am almost done, Mr. Chair. MCASA fully supports the choices of the adult survivors of child sex abuse to pursue civil law suits if House Bill 1 is enacted, and we urge this committee to prioritize this bill and to move quickly. We also support the many survivors who will not benefit from private lawsuits, and we urge the committee to take steps this session, next session, at some point to support them as well. The chair started this bill hearing saying there were 7 panels, and I just would like to remind you that there used to be like 20, 25. People would be in the hallways. They'd fill the hallways, and people have died. They've given up. And it's because the legislature has not been able to get this done. So the Maryland Coalition Against Sexual Assault asks you to please finally give these survivors access to justice and issue a favorable report on House Bill 1.
Good afternoon, Chairman Clippinger, members of the committee, fellow survivors and advocates. My name is Dr. Frank Schindler. I'm a survivor of child clergy sexual abuse and a member of SNAP. I'm speaking in support of HB 1. In 1954, a 5-year-old boy climbed a dark staircase and entered a room in a Catholic school to start kindergarten. A short time later, this boy was escorted into a room where a Catholic priest waited. The boy had been taught this priest is a representative of God on earth, and to question his actions would be to question the actions of God. Shortly thereafter, the boy was subjected to repeated and painful sexual abuse occurring 2 to 3 times a week over a period of 5 months. The basic right of a powerless 5-year-old not to be abused was repeatedly violated for the gratification of this Catholic priest. I was that 5-year-old. I'm now 73 years old, and for close to 70 years and for whatever remains of my life, I will suffer the consequences of that abuse. As a psychologist specializing in neurocognition and neuroscience, I know how trauma results in the long-term dysregulation of brain regions and brain systems, and how this dysregulation distorts emotions, interpersonal relationships, and self-perception. It contributes to the reality that most survivors only fully recall their abuse years after it occurs. Neurobiologically, the locus of the memory of trauma in the amygdala means it bears no time stamp. It is not recalled, it is relived. The lives of those subjected to sexual abuse and trauma are never the same, biologically, emotionally, or socially. For decades, the Roman Catholic Church has fostered the systematic, institutionalized sexual abuse of children. This morally bankrupt institution continues to put forth baseless excuses for their repeated re-traumatization of survivors by refusing to accept responsibility for their reprehensible behavior. I consider the Child Victims Act both a moral and a civil rights issue. The Child Victims Act will send a strong message to all survivors and to their abusers that the gross violation of the basic right of children not to be abused will no longer be tolerated in Maryland, no matter how powerful the source of that abuse. For these reasons, I respectfully urge a favorable report on HB 1. Thank you very much, Mr. Chairman and committee.
Good afternoon, Mr. Chairman, Vice Chair, respective members of the committee. For the record, Davion Percy, and for those of you in committee leadership and several members of the committee who are familiar with me, this is the point where I'll let you know what client I'm representing in our position on this bill. Well, unfortunately, I'm not here representing my firm, nor its employees, nor any of its clients. I'm not being paid to be here. I'm here as a taxpaying citizen, a resident of Maryland, who is a victim of child sexual abuse. Over a period of about 7 years, and please apologize, this is the second time I'm speaking publicly about this in 1 week, and I did not realize how traumatizing this second time would be. Over a period of 7 years, I was molested by 3 different men. 2 were close family friends who were entrusted with my care, and 1 was associated with an institution that was entrusted in my care. The final incident that I remember is being restrained physically in a car in front of my family home while I was being molested, and I had to fight my way out of that vehicle and run into my house. And it was years before I was able to come to grips with this and tell my family about it. You know, I can't seek justice for several reasons for my perpetrators, because all 3 of them have passed away. So I'm not speaking on behalf of myself. I'm speaking on behalf of someone who's come before this body and others before, under a contract, under an engagement, being paid. However, today, with that influence, what good is my word if I don't stand up for what's right? Children leave our homes at times whole, and they return home broken. And I was one of those. I've watched this bill for every year that it's been introduced. I've sat in the background in my office and watched it via my laptop, et cetera. But today, I decided to come forward just to implore you on behalf of the hundreds of thousands of Marylanders like myself to pass this bill. I applaud our proponents that have come here year after year, because I've only been here twice in 7 days and I can't take it. So I applaud them. And with that, Mr. Chairman, I won't take too much more time. I urge your favorable report. Thank you for allowing me to speak today.
Thank you, Mr. Chairman and the committee, for this opportunity to testify in support of HB 1. I'm a survivor of sexual abuse from the Key School. I was abused by 2 teachers for about a year. I was 14 years old. An independent investigation concluded that 10 teachers at the school in position of authority sexually exploited at least 16 students, and that members of the board, teachers, administrators were aware of it and remained silent rather than intervene or report it. It may be hard to conceive of how hostile the environment was for victims at that time. Even now, when we report, we may face tremendous blowback from our communities, from our school community, from our church community, and law enforcement prosecutes only a tiny number of our cases. When my parents confronted the school about it, about the abuse, the school just kind of shrugged. They'd already silently kind of dismissed that teacher. And when my mother reached out to the Anne Arundel County State's Attorney at that time, who was Warren Duckett, looking for advice on, going to the police or how she should deal with it, he actually advised her not to. The quote I remember was, "She'll be destroyed on the stand." He was letting them know how harshly victims were treated at that time. The civil statute of limitations expired for me at 21 when I still had few words for the pain and confusion I felt. In 1993, I did speak out publicly. The school held a memorial service for that teacher who was notorious for abusing students at that school and was let go for that reason. And I was met with a wall of victim blaming. In 1997, and the school denied that they had any institutional responsibility. Even then, they were saying it's ancient history. We've been hearing that it's ancient history since almost the moment that it happened. In 1997, I was interviewed by Anne Arundel County Police. I was interviewed by them again in 2018. Again in 2019, the detective took and I met with the state's attorney in Anne Arundel County, and they say they're looking into it. They're saying that we're not sure that even though you were penetrated every way that imaginable, that is actually a felony in Maryland at that time. And that's one of the things that I hear that the opponents to the bill bring up, that we have the option to bring these cases in criminal court, that they're felonies. Why don't you just bring them to criminal court? I, as a survivor, do not have that authority to prosecute cases. And I and others have met with the police, and nothing's happened. So, in conclusion, being turned away, silenced, and shamed by one's school and law enforcement over decades is devastating. It's the very definition of institutional betrayal, which research shows magnifies the harm caused by sexual abuse. Institutions are causing real, measurable harm, not only by allowing the abuse to occur, but by silencing the victims. HB 1 would allow me that voice, would allow me to bring my case, would allow me a chance at justice. And for those reasons, I respectfully urge a favorable report on HB 1 with the sponsors' amendments. Thank you.
I'm going to need one of you to switch places, please. Thank you very much. And whenever you're ready, please.
Yes, thank you. You've listened to some gut-wrenching, punching, heartfelt testimony today, and I've been working with survivors on legislative issues for 5 years now. Hearing their stories gets me every single time. I know that it is so much easier to focus on intellectual discussions around the legal implications and fiduciary responsibilities than it is to address the social and moral impacts of what you've heard today. I come at this work after a long career in the nonprofit sector. My expertise areas are organizational development and communications, which means I've spent a good deal of time crafting policies and procedures, spinning talking points, and training staff in prevention measures. What this work has taught me is that we tend to approach things from a single lens. We focus on the issue in front of us and not the dominoes that created it. I'm sure you've all heard the story of a child on the beach throwing the starfish back in the ocean, and the adult comes up and says, "You'll never save them all," and the child says, "But I saved this one." I have hated that story since the first time I heard it, because my question is always, how did all the starfish end up on the beach? With this issue, we have the tendency to listen to the story and focus on the experience of the individual. And I'm not asking you in any way to dismiss their stories or to relegate them to things that happened years or even decades ago. What many of them did not fully share with you today is the impact their abuse has had on their spouses, their friends, and their children. The impact of childhood trauma is intergenerational. We know this both anecdotally and scientifically. Our brain chemistry changes when we experience extreme trauma as children, and that change is passed on genetically. Families will often talk about how diabetes or breast cancer runs in their family, but they don't mention depression, autoimmune disease, or rage control. Society, all of us, are already paying a price for the impacts of child sexual abuse. Research shows correlations with eating disorders, substance abuse, sex trafficking, and incarceration. We collectively pay for those impacts directly in our families or indirectly in the services our state provides to mitigate the damage. We also know that there are proven prevention strategies that minimize the impact of childhood trauma and foster resilience in all children, but we are a long way from funding and implementing those strategies in a widespread interdisciplinary manner. What does this all mean for the legislation in front of you today? I ask that the conversations that you have and the decisions you make be grounded in the solid foundation of justice for those whose voices that you've heard today and for those who cannot speak about their trauma. I am not naive to the fact that there will be financial repercussions if this legislation passes. I am saying that I believe that needs to happen in order for us to collectively heal. My name is Vanessa Emilio, and I support the passage of HB1 with the sponsors' amendments.
Are there questions for this panel? Delegate Erica.
Thank you, Mr. Chair. Thank all of you for being here and everybody in the audience for sharing your stories. My question's more on the financial side of things. I know, Vanessa, you just touched on that. Can you please just tell the body what are the caps? You know, and I know there's been some ideas about having a fund set up. Can you just talk me through all
Sure.
the financial sides of this so that I can understand what's happening?
Absolutely. I'm going to reference my notes because I don't want to misquote the legislation, if that's okay.
Yeah.
And I am not a lawyer, so bear with me as I attempt to do justice to something that is heavily legal.
Do you need someone else to talk a little while you check your notes?
Just
Maybe
give
just
me
a little bit to
give me
give
a
you some more
second.
time.
I can find it. I'm so sorry.
Can I help
take
you out
a
in
breather,
any way?
Take a breather. I think everybody needs a fresh breath of air here.
Probably. So,
Somebody hand me the bill.
I'm very happy to help you if you just
Okay,
need
you
a
can
little
tell
bit
me.
of. No,
Tell me the
I'm
caps.
just.
Tell me the caps and
no,
I'll explain
I'm
them.
just giving you some more time to
buying you time.
find the bill.
Perhaps, Mr. Chair, if I could you?
Ms.
yes,
Jordan, please.
Just give me the numbers. Thank you.
Yes, the caps proposed are 1.5 million for private entities and 850 for public entities.
Yes, so there's a different level. I can explain the reason why. I know that. I just didn't want to get the numbers wrong. My apologies. So it's $850,000 for public entities, which matches the police reform cap that was passed last year in civil litigation there, and 1.5 for private entities, and that is retroactive, not prospective. I'm hoping I'm saying that right.
Okay.
So that is the difference there.
Okay, and then, so tell me a little bit about the concept of a fund and how that would be different from this situation.
Sure. So I respectfully, to my colleague, I have some apprehensions about the setup of a fund for a number of reasons. I approach this legislation from a prevention mindset, and the prevention piece of this comes out in disclosure. Right? We need that disclosure to be able to say who's still working with kids, who's still the scout leader, who's still the youth pastor. And so I want to know that information, right? Because I want to make sure this doesn't continue to happen.
And Delegate Erican, that the fund would actually require all of that as far as my understanding of it. So I do think that there's been a lot of chatter about a fund that is not based on what was discussed before. I know yesterday you heard the Attorney General's bill that talked about him going after civil rights violations. Well, as you've heard, this is really a type of civil rights violation.
Right.
So he would still undergo litigation. But I would be hard-pressed, and I do this work all the time. We try to find someone who will file a tort suit against someone who doesn't have much money.
Right.
There's nothing to attract the private attorney to
Right.
that case. An attorney general could go after that case, could get all of the disclosure you're talking about, could get that sort of information, that sort of public airing. That would not change the HB1 provisions. It would just be a second way for survivors.
Okay, so
to,
like a second bill that we could introduce.
it would certainly could be this bill,
Okay.
but not if it slows it down.
It would slow down the nature of the bill, and the reality is setting up a fund sponsored by the state with the Attorney General's office would require a significant, I believe $10 million was the startup that was mentioned at the Senate hearing last week, in addition to the administrative costs for setting up a fund. And I would imagine that that would take several years to get rolling.
Yeah.
So we would once again be looking at delayed access
Yeah.
for our survivors, and that is certainly concerning. I'm not, again, saying it's not possible, but it's certainly something to look at.
Yeah.
The other piece of the puzzle is, and again, having worked with survivors of child sexual abuse now for 5 years, I have never heard one say to me anything other than I want my day in court.
Right. Yeah.
I want to be
yeah.
heard by a judge and jury.
Yeah.
I want to be able to plead my case. And if someone says it doesn't meet the merits, then someone says that. But I want the opportunity for that to happen.
Yeah.
And my job sitting here today, I'm not a lobbyist, I'm a volunteer, I'm an advocate, and I'm just trying to use my voice to speak for those who don't have the ability to sit here at the table and use theirs. And that's what I'm hearing. So that's my apprehension about the setup of a state-funded fund.
Yeah.
I know that there's also some concerns about just one of the survivors who wasn't able to testify today said, so my tax dollars are going to go into a fund that I then apply to, and then my tax dollars come back to me, right? And so it feels like we're not holding accountable the organizations and institutions who harmed these individuals. And I wish I could say that institutions have a long history of doing the right thing when we ask them to, but unfortunately it typically takes legal action for them to then clean up their act.
Yeah, well, thanks for explaining that. Yeah, there's been funds on the other topics that have been suggested here before, and there was a lot of issues with people feeling like they were actually getting justice with the fund set up. So that does clear things up for me. Thanks again, all of you, and to Mr. Percy, thanks for sharing your story for the first time this year. We really appreciate it. I know how hard it must be.
Thank you, members of the panel, for coming in to testify. I was wondering, does anyone know if the dissociative amnesia is an officially accepted medical term?
I can respond to that. The Diagnostic and Statistical Manual of Mental Disorders has actually classified that the term is called dissociative disorder, not dissociative amnesia, and it's called dissociative disorder because there are other
types of disorders. It's about four.
There are other types of disorders, but there's also other types of dissociation that don't necessarily involve amnesia, but dissociative amnesia is part of the diagnosis of dissociative disorder.
And about how long does it take before the amnesia might be able to be breached where you can remember what you're suppressing? Would that, I mean, you're looking to repeal a statute of limitations, so how long should we open this up for? 20 years, 30 years, lifetime? I'm asking, based on the medical term.
Based on the science, indefinitely. I mean, there is no timetable for the recall of this, and the reason for that is because the way the brain operates.
Right, and you said something about the memory might be suppressed in the amygdala, is that right?
Memories of trauma are stored in the brain differently than other kinds of memories. The amygdala is the brain. I don't want to go too much in it, but the amygdala is the area of the brain that judges whether a sensory input is dangerous or not. If it's judged as dangerous or life-threatening, the amygdala takes immediate action rather than passing the memory on to the next stage, which is the hippocampus.
Sure. Thank you very much. Thank you very much.
And one more, and it's the hippocampus that designates it as an explicit memory, and that's where the timestamp and the date and the location, all of that get attached to the memory. Otherwise, it stays in the amygdala with no timestamp.
Yes, I'm very much familiar with what you're talking about.
Okay, thank you. Sorry.
Are there further questions for this panel? Seeing none, we thank you very much. I have now what I believe will be the last panel, and it includes the three people who are on virtually with us, so we're going to hear from them. Jenna Cochran, David Chappelle, Claudia Remington, Emily Rose, who's on virtually, Elizabeth Lee Turneau, who's on virtually, and Matthew Wolf, who is on virtually. So we will see who comes to the table. See who comes to the table here. They will begin, and then we will hear from those people who are on virtually. Okay. From my right, your left, please. If you'd like to begin, sir, that would be fine.
Thank you, Mr. Chairman, members of this committee. Thank you for the opportunity to speak with you. Thank you, Delegate Wilson, for being such a strong supporter of this. My name is David Chappelle, and I strongly support HB 1 with sponsors' amendments, as it will provide an outlet for some closure, healing, and assurance for the safety of our children. I invite you to please reference my written testimony, which has more details about my story, but here's my 2-minute version. I hope will respectfully share with you. I live in Ellicott City, Howard County right now, with my wife of 20 years, our 5 kids who are ages 5 to 16. My wife is raising them Catholic at St. Louis Parish in Clarksville. I'm a UMD alumni. I'm the director of HR at a government contracting company headquartered in Columbia, Maryland. I'm 45 years old right now. I'm the youngest of 3 brothers, and I'm the survivor of child sex abuse and rape. I don't like saying that, but it was only 4 years ago, in spring of 2019, when I began to recall horrific, repressed memories of being sexually abused repeatedly and raped by a Catholic priest during the fall of 1986, when my family had just moved to Gaithersburg, Maryland, in Montgomery County. I was 9 years old, starting 4th grade at Diamond Elementary and religious ed at St. Rose of Lima Parish, which is where my abuse occurred, and that's under the Archdiocese of Washington, D.C. My abuser was then Father Waylon Brown. He was visiting from the Archdiocese of Savannah, Georgia. He was in Maryland at St. Luke's Institute in Silver Spring, which is a Catholic-funded treatment facility for pedophile priests. Yet he continued to have unchecked access to children like me. He died in 2019 while serving time for raping other children back in Georgia after he left Maryland. He was never cured, but rather he was protected and enabled. I wonder, and it is really scary to wonder, how many other pedophile priests were treated at St. Luke's Institute and then were allowed to leave and pray at our neighboring parishes in Maryland or DC. A few months ago, I recalled a stark memory of a bedtime, the night after I was raped at gunpoint during a church picnic for kids. By the way, do you know why a priest has guns? And there's no punchline here. I asked him. He said, because even men of God need protection sometimes, and because I need to make sure you're not going to tell anyone what is about to happen. So that night, I laid in bed looking up at the ceiling. My 9-year-old inner self was trying to figure out what happened. My rear was still sore. I was too embarrassed, too confused, too scared to tell anyone what happened. I remember I told myself that night, forget everything. Just try to live a normal life like everyone else. I don't want to be different. I don't want this to hold me back. I just couldn't confront this as a 9-year-old, and even now, barely managing. These past 4 years, I've been reliving this trauma as I remember new things. People around me have seen the intense effects on me. My family, friends, my coworkers, even members of my family are dealing with serious collateral damage. I lost 30 pounds in about a month after I started this. I'm now managing my PTSD, anxiety, and depression through ongoing therapy and medications. It's totaled over $60,000 so far. Closure to me means getting answers, acknowledgement from parties involved, financial help to pay for my family's ongoing therapy, and importantly, to have assurance that this is not still happening today. For these reasons, I respectfully urge a favorable report on HB1 with sponsors' amendments. Thank you very much for your time.
Can you hear me? I'm speaking in support of HB 1. My name is Jennifer Kohler-Cochran, and I am 51 years old, and I am an incest survivor from childhood rape and molestation. I was 12 when I was first attacked by my stepfather, Steve Dwyer. He would sneak down and do unthinkable things to me in the middle of the night. He made me pinky swear that I would never tell anyone, and he said that no one would ever believe me. He was right on some of that. That's me at that age. Did you ever wonder why survivors and victims don't take so long to come forward? The reason is they really don't want to be me. Unlike a lot of my fellow survivors who testified here today, I had my day in court. I put my stepfather, Steve Dwyer, behind bars when I was in high school in 1987. I came forward because he was beating my mother, and I wanted him to stop. I was trying to protect her. But the price for speaking my truth was a lifetime sentence of family destruction. I lost everything, and I really do mean that. I lost my mom, I lost my siblings who will not talk to me, and I lost the love of my very close-knit Italian family. Childhood sexual assault is like a hurricane that destroys everything in its wake. No one wants to believe that a nice man like my stepfather could do that to his stepdaughter. And no one wants to believe that my mother, their own flesh and blood, could actively be involved in covering it all up. My telling the truth destroyed the ability of everyone to have a nice Christmas. Because of this, I have basically been shunned, and I really don't get to go home. At the end of the day, I learned that families work a lot like organizations, corporations, and churches. They just want to keep the status quo. Before I go, I just need to tell you a tiny bit of history. In my teens, my mother drove me to a notary public at a bank to retract my statement, and then she dropped me off at a police station. This type of stuff still happens today, and 2 years ago when my grandmother died, my mother told me that she hopes that I will die alone. She followed that up with saying that this would be the last time that I ever saw her. and she asked me to apologize to her. After that, my sister-in-law gaslit me, and now my brothers won't talk to me. All this, despite the fact that my stepfather went to prison for the crime. This is the type of pain that victims and survivors are afraid of. But the uncomfortable truth is that I do exist, and so do all the people who testified here. If victims are brave enough to come forward, then I ask you to be brave enough to give them a forum to tell their truth. It's time to let victims speak. It's time to shift the burden to families, corporations, churches, and all the people who do that type of stuff to cover up. And most importantly, it's time for them to say they're sorry. Please support HB1. Thank you for your time.
Chairman Clippinger and distinguished members of the committee, my name is Claudia Remington. For close to 20 years, I served as the chair and executive director of the State Council on Child Abuse and Neglect. I'm here with survivors today, many of whom have become great friends too. I'm here on behalf of SCAN and Maryland Essentials for Childhood and the many members of Justice for Maryland Survivors Coalition. In my written testimony, you have a copy of a joint letter signed by over 50 organizations that strongly support HB1, the Child Victims Act, with sponsor amendments. I'd like to highlight a few. Religious organizations like the Episcopal Diocese of Maryland, the Maryland Episcopal Public Policy Network, the Delaware Maryland Lutheran Synod, city ministries, and Catholics for Action, those concerned with social justice like the NAACP, for those that focus on public health like the Maryland chapter of the American Academy of Pediatrics, the Greater Baltimore Medical Center, Pro-Med Health, and the Moore Center for the Prevention of Child Sexual Abuse at Johns Hopkins Bloomberg School of Public Health. Those that provide services to children and will be directly impacted by this legislation, like the Maryland Out of School Time Network and Maryland Panda and Boys and Girls Clubs of Harford and Cecil County. Organizations who respond to families impacted by the aftermath of child sexual abuse and other childhood adversity, like the Maryland Coalition of Families and the Hartley House and Housing Authority of Frederick County. And lastly, many organizations that work to prevent and respond to child sexual abuse, like the Beau Biden Foundation, Child USA and U.S. Advocacy, the Maryland Children's Alliance, the Center for Hope, the Maryland Family Network, and the Family Tree. This bill is important for two reasons. First, that it will provide an opportunity for survivors to seek justice and healing for proving their cases in a court of law. And equally as importantly, to ensure that our children are safe and we prevent child sexual abuse before it happens by holding perpetrators and institutions who enable them accountable. For these reasons and many others in our written testimony, we ask for a favorable report on HB1 with sponsor amendments only.
Thank you very much. Now we're going to hear from people who are who are testifying virtually. I'm just going to ask one more time, Dr. Wendy Lane, I don't think was here to testify.
Dr. Lane was the chair of the council. She was ill today and
I
could not
see.
testify.
Okay, I'm just making sure. And Buddy Robson? Is he here? Oh, he's ill. Okay, that's fine. So the people who are here to testify virtually will be the last four to testify in favor. And we'll let them begin. Let's begin with Emily Rose. You need to, there you go. Off you go.
Okay, I'm shaking. Hi, you've already heard the moving testimonies of many adult survivors of childhood sexual abuse. Sexual assault at any age and under any circumstance is traumatic. This trauma never ends, and speaking as a victim myself, this trauma resurrects over the years and takes on a life of its own. My personal trauma occurred in 1994. I was 16 years old. I was a victim of date rape. This was someone whom I met through a trusted group of friends and started dating. After dealing with the shock for a while, I shared the information with my mother. I reported the rape to the local police station, which is no longer open because that was so long ago. Their report included the fact that I had bruising on my thighs and being physically restrained during the attack. 2 police detectives later came to our home after confronting my assailant at his home. They dissuaded us from pressing charges, stating that his family had so much money and that a trial would probably be another traumatic event for me. I was in high school, an already challenging time for teenagers, and quickly found myself in a deep depression, consumed by my sadness. I attempted suicide, started seeing a psychologist and taking antidepressants, and eventually dropped out of school. I got my GED. I developed PTSD and trust issues, and I'm still on antidepressants. Every single day, I'm reminded of what happened because my assailant is an attorney, and I see his advertisements all over town. I'm currently unable to consider filing a civil lawsuit. I can't even leave my house without taking Valium. My PTSD is emotionally paralyzing. The truth is, the trauma of that event is still with me almost 30 years later. Remember, trauma has no statute of limitations. We the people deserve justice. Thank you.
Ms. Letourneau, please.
Thank you for this opportunity to testify in support of House Bill 1. My name is Elizabeth Letourneau. I am a professor and I direct the Moore Center for the Prevention of Child Sexual Abuse at the Johns Hopkins Bloomberg School of Public Health. I must note that the views expressed here and in my written testimony are my own and do not necessarily reflect the policies or positions of Johns Hopkins universities. I have 35 years of experience as a clinically trained researcher focused on child sexual abuse prevention, practice, and policy. I've advised the National Academies of Science, the World Health Organization, and other state, national, international, and big tech governance bodies. The provisions proposed in House Bill 1 are critical because published research by myself and others shows that most survivors of child sexual abuse delay disclosing their abuse until years and even decades after it occurred. Many never disclose at all, and even when disclosures do occur, they are most typically to friends or family and not to the authorities. Approximately 1 in 4 girls and 1 in 13 boys in the United States will become victims of child sexual abuse. Abuse increases survivors' risk for health problems, many of which you've heard already. These include, but are not limited to, PTSD, heart disease, cervical cancer, and smoking, thereby increasing morbidity and mortality and reducing quality of life. My research also found that child sexual abuse costs our country about $9.3 billion each year, and it costs each victim more than $280,000 in lost earnings and other economic impacts. House Bill 1 provides survivors with one avenue for seeking justice and redress. This bill also serves as a motivator for others to avoid engaging in or shielding abusive behaviors. History has shown that many institutions invest in preventing and addressing child sexual abuse only after being held accountable for shielding the actions of their members. For these reasons and others, I respectfully urge a favorable report on House Bill 1 with sponsor amendments only. Thank you for your time and your consideration.
Thank you very much. Ms. Mueller, are you in some way, and if you're not, I apologize, I can see you reading notes there and holding them up to your face. Whichever way you would like to give your testimony, if you're sight impaired and you need to keep the notes close by, of course, that's absolutely fine. But it's your time for 2 minutes now, please.
I am Mary Mueller of Greenbelt, Maryland, and I strongly support HB 1 with amendments, since it would restore decades of denied justice to us survivors of religious, public, and institution and family abuse. You have copies of the complaint I sent to former AG Brian Frosch. It summarizes the Catholic sexual dogma-based Munchausen by proxy medical torture inflicted on me as a child in Towson. Adding physical torture and resulting medical injuries in amendments would also address the forced medical exams and abortions by Father Maskell's collaborator, Dr. Richter, and the abuses in Baltimore's Good Shepherd Home. The late Orioles chaplain and Towson Immaculate Conception priest who directed my mother to disfigure me as her abstinence-only birth control may also have ties to Father Maskell, Were his victims also threatened with disfigurement? It wasn't possible for me to complain to authorities since I hit the abuse trifecta of abuse from clergy, family, and doctors. My mom was desperate to avoid birth control damnation and to distract my dad from noticing that their last child was fathered by an Indian priest. Her deceit triggered years of withheld medical records and bullying by everyone. Mom claimed I had a genetic skin disease from dad, but her toxic home concoctions combined with x-ray lamp burns severely spread a mild rash from radium-painted rosaries. In 2019, I learned that St. Peter was the first recorded Munchausen by proxy perp. He demonstrated forcing lameness on his own daughter to keep her a virgin. This inspired centuries of sin-preventing mutilations like castration and facial disfigurement by saints, and persists today in genital mutilation, denied cancer treatment for pregnant women, and Nazi-like experiments on Catholic orphans. The public deserves to know that the pro-life church that protects abusive clergy also secretly excuses their own abortion while forcing imprisonment, disfigurement, disabilities, even death on us lay women as prevention or punishment. We survivors of childhood sexual, physical, and medical abuse deserve restitution, so I respectfully urge a favorable with amendments report on HB1. Thank you.
Thank you very much. Mr. Wolf, please.
My name is Matthew Wolf, and I am a survivor of childhood sexual abuse. Such a simple sentence to share, only 14 words. You'd think it would be easy to say, but it has taken me nearly 30 years to find the courage to share my experiences. Sadly, the abuse I endured is not unique. As you've heard others testify, estimates may vary across studies, but we know that 1 in 4 girls and at least 1 in 13 boys experience sexual abuse at some point in childhood. I can't speak for all survivors, but I know that for many adults like myself, my abuse is a secret that weighs heavily. For many survivors, our abusers walk free, or the institutions that enabled the abuse are not held accountable. Ultimately, I waited to my 40s to speak publicly about my abuse because it is re-traumatizing to talk about what happened. And the idea of being vulnerable and opening up about the abuse is terrifying. But the simplest explanation is I just was not ready. My abuse happened at the hands of a Gilman School teacher and coach, Dr. Martin Malloy. I was tricked into believing I was his only victim. I had to watch friends and my school community memorialize his memory at his passing. And even after 30 years, I'm still a kaleidoscope of emotions on the topic. Anger, disappointment, embarrassment, and fear. Now imagine holding all those emotions in for 30 years, finally finding the strength to come forward and hold accountable those responsible, only to be told, you waited too long. We're sorry, too much time has passed. Why didn't you bring this up sooner? Reforming the civil statute of limitations is critically important for survivors of abuse like myself, because we all heal at different speeds. This isn't like a broken leg where there's an understood timeline to repair. Sexual abuse impacts us all in different ways, so allowing men and women to make the transition from victim to survivor at their own speed when they are ready is the compassionate and morally just course of action. For these reasons, I respectfully urge a favorable report on HB1 with the sponsors amendment. Thank you.
Are there questions for this panel? Seeing none, we thank you all and for the people, not just on this panel, but on every panel for coming here and testifying today. We have 2 further people to testify. One is Corey Silverman, who is opposed to the legislation. And I'll give you some latitude on time, but we're trying to do what you need to do, but okay, Mr. Silverman.
Thank you, Mr. Chairman and members of the committee. My name is Kerry Silverman. I'm here again on behalf of the American Tort Reform Association. First, I want to say that I have the most respect for the survivors who have testified today and the advocacy of the sponsors and the courage of everyone here today. I can't fathom what they have gone through and what they continue to go through. I'm an attorney in Maryland, and my testimony today will kind of reflect back on, stepping back and talking again about the general principles of statutes of limitations and why ATRA has concerns with the type of approach that this bill is taking. We don't oppose having a lengthy statute of limitations for childhood sexual abuse. It's the approach that we see in this bill that we have concerns with, as we would have for any type of civil case. The first concern is the bill's complete elimination of a statute of limitations. That's something that is unprecedented in Maryland law. While some may view statutes of limitations as arbitrary, they do serve a critical purpose. They're there so that judges and so that juries can evaluate liability before records are lost and witnesses disappear. Every type of civil claim in Maryland law must be filed within a finite period. I'm not just talking about your minor slip and fall claims. I'm talking about cases with catastrophic lifelong injuries, cases that involve exposure to a toxic substance where there are issues of the length of time before the injury is observed. But we have ways of dealing with that in the law, whether it's through discovery periods, through tolling, through fraudulent concealment. But we don't just ordinarily and haven't ever eliminated a statute of limitations. I'll just make my second point and wrap up and leave it for questions from you. Our second concern, which exacerbates the first, is the retroactivity. When a statute of limitations is extended or even eliminated prospectively, organizations at least have the ability to prepare for that. They can save their records forever. They can meticulously document what they've done in hiring and training and everything else to make sure if they are sued 40 or 50 years later, they have those materials available to them. When you do it retroactively, there's no ability to do that. And so you will have situations where the perpetrator is dead, where the records are gone, and there's just no way, there's no question in these cases that the abuse occurred. That's not the issue in the cases. The issue is whether 40 or 50 years ago the organization did what it was supposed to do to protect from abuse, and that will be a very difficult question to ask you. Thank you for your time, and I would take any questions you have.
Are there questions for the panel? Delegate Williams.
Thank you, sir. You mentioned the concerns that your organization has with the statute of limitations. The other aspect with regards to this is the repeal of the statute of repose. And I was wondering if your organization has any concerns with the possible repeal of the statute of repose.
No, I don't think that we do. In our view, as my written testimony has been submitted, whether this is a statute of limitations or a statute of repose, however you phrase it, we believe that Maryland law already firmly provides that it would be unconstitutional to revive time-barred claims.
Even if we modify the statute of limitations, you think that's also unconstitutional?
Even as a statute of limitations, and I could explain that more, or you could look at my written testimony on it.
Okay, thank you.
Seeing no further questions, we thank you very much.
Thank you.
Is Mr. McAvoy on? No, he's not? All right. That concludes the testimony for House Bill 1. Ladies and gentlemen who are here and members of the committee, this has been a very challenging bill hearing. We have many more bill hearings to have yet this evening. I think for the benefit of the committee and for the benefit of all of us, we're going to have a brief break, and we're going to come back at 4:40. 4:40, back in chairs, please, members of the committee, so that members of the committee can take a break after this, and then we will begin with Delegate McComas's bill. Thank you very much for your patience. Okay, we're going to get back started again. It's a little after 4:40. We are now back to the stricter enforcement of 3 minutes, 2 minutes. Sorry, everybody, but we're going to go now to House Bill 1069, 1069. Delegate McComas. We'll hear from her. We might have Darlene McLaughlin on virtually. No? No, okay.
I told her you were starting out on phone, and so to be available, but if she is, she isn't, she isn't, she isn't.
Is Jessica Nachman here?
Yes.
Come on up if you want.
Come on up.
Okay, so we'll hear from the two of you, and let's go ahead.
Okay. Mr. Chair, this is testimony in support of 1069, Protective Orders Coercive Control. The Duluth Domestic Violence Power and Control Wheel, which is right here, and if the committee wishes, we'll get some smaller ones and pass it out to everybody later, is a great tool to help victims of abuse to understand the power and control dynamic. Although the perimeter of the wheel represents those forms of abuse, physical and sexual, which seem to be the most often in the public eye, the inner workings of the wheel outline the many forms that abuse can take. For those suffering from coercive control, control is at the core of the abuse cycle. More to the point, the strategies and methods abusers implement are among the spokes that represent the victimization of those who have lost their ability to live without fear of reprisal, domination, intimidation, isolation, and economic and emotional abuse. Hammering out a definite meaning for coercive control has taken the input of many legal professionals, ultimately resulting in the legal definition as recorded in the Maryland Rule 9-205 in December of 2022. Their definition is a pattern of emotional or psychological manipulation, maltreatment, threats of force or intimidation used to compel an individual to act or refrain from acting against the individual's will. Our judges now have the criteria as outlined in the newly promulgated definition they need in order to issue a protective order on behalf of a domestic violence victim in such a controlling situation. Coercive control robs the victim of their power to make decisions about something as simple as what to wear, how to talk, and what time to go to and from daily activities. Life for the coercively controlled abuse victim gradually becomes so confining and manipulated that the abuser has all the power over them. The victim has no personal freedom whatsoever. The home, in fact, becomes a form of confinement and isolation from others, a prison for the victim to keep them under control. Victims of coercive control often have no physical signs of abuse. They frequently do not have bruises, cuts, or broken bones. They are told when, how, and why to do something. Sometimes their food is withheld because they did not comply with some controlling edict. Their activities on the phone or computer are thoroughly scrutinized and sometimes cut off completely. Email, text, and social media are often forbidden as it represents an avenue of communication with the outside world the abuser cannot fully control. They simply have no autonomy. Imagine living that way day to day. Someone tells you how, when, and where you can go. If you fail to follow the edicts, there are severe consequences. Control is the key here. No freedom of expression, freedom of thought, or self-determining actions. The very civil rights we have as individuals are stripped from the abused and replaced with the agenda of the abuser. Personal freedom belongs to the abuser alone. HB 1069 recognizes the domination and control of the victim through coercive behavior that strips the abused of their ability and freedom to make self-effectuating decisions. Thank you, and I hope you support 1069. With that, I turn it over to my witness here.
Hello, everybody. My name is Jessica Nachman, and thank you guys so much for letting me tell my story. After marrying my ex-husband in 2008, his behavior began to feel off, but it was never anything that glaring, at least at first. He needed to know where I was at all times in case there was an emergency. I had to ask permission before spending any money because he was helping me become more financially responsible. He didn't understand why I wore makeup or nice clothing if I wasn't seeking attention from other men, so to avoid arguments, I stopped. He'd pick a fight whenever I wanted to see a friend or family member, insinuating that I was selfish for leaving our children. It became easier not to fight, so I stopped and eventually lost all my friends and rarely, if ever, saw my family. In 2014, I found a recording device in my pillowcase, a spy pen in my car, and discovered he'd been reading my emails for years. That was when I finally decided to leave him, and things got worse. He was verbally abusive to me in front of our boys. The surveilling intensified, and he emotionally abused me in ways that I'm still dealing with today. He delayed attending mediation for months so I couldn't move out, and I was living in our guest room. One night, he broke into my room, and over the course of 2 hours, I asked him more than 40 times, I kept track, to leave me alone. He refused, said it was his house and he could do whatever he wanted. I ran to my car, locked myself in, and called 911. When the county police showed up and I told them what was going on, they said while they didn't agree with his behavior, they weren't the language police. They handed me a pamphlet for a women's shelter and said to call if it turned violent. My therapist at the time said many other women who were victims of physical abuse had it so much worse than me. My lawyer said the family courts didn't care about the illegal surveillance, so it wasn't used during my divorce case. Currently, I'm back in the court system fighting for legal custody of my 2 boys. I've been told they need to grow a backbone and speak up if they're being coercively controlled by their father, which they are. The problem is I am a strong, intelligent woman. It took me years to recognize what he was doing to me. The law has yet to catch up, so how can anyone expect more from a 12 and 14-year-old boy? Please pass this bill and support victims by not allowing their abusers to control the narrative. Thank you so much.
Are there questions for this panel? Seeing none, we thank you both very much, and we'll now hear from people opposed to the legislation.
Thank you, Mr. Chair.
Thank you. Well, we're going to hear from Maria Dorflinger, Lori Ruth, Melanie Shapiro, and Vince McAvoy. Ms. McAvoy is virtual. Ms. Dorflinger is supposed to be virtual. But we'll hear from the people who are here now, and that is Ms. Ruth. So go ahead. We'll start with you.
Good afternoon, Mr. Chair, members of the committee. Ms. Shapiro had to leave to go to another committee. She is with the Maryland Network Against Domestic Violence and is also opposing the bill. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland, and I am also a member of the Family and Juvenile Section Law Council for the MSBA, who are also opposing the bill. I want to say thank you to Delegate McComas, despite the fact that we are opposing, because she has this year presented a bill that was responsive to opposition that has been put in the past of this bill. And so it pains me a little bit to still be opposing it, but the community as a whole is opposed to this. I have just a couple of reasons. The first thing is that the protective order statute is very serious, and it's an emergent way to get to the court for emergency and safety reasons. And I think the community is very worried that if you add coercive control to the definition of abuse in the protective order, it's going to dilute the sense of urgency in protective orders that are brought. We already face some perceptions by the bench and whatnot that cause problems with judges granting them, even in what I would call very serious safety situations. And adding coercive control may add to that perception by the bench and others that people are just using this when, you know, somebody's being mean to them. I do not mean in any way to discount the testimony you just heard. We have hundreds and hundreds of cases where there is coercive control as an element of what's going on, but we're really worried about what's going to happen if this gets added. In addition, the relief that's granted in protective orders is really serious. And I've been down here for 16 years now, and some of the pushback from members in the past has been, you're vacating people from their home. You're telling them to stay away and have no contact. You're awarding custody to another side. It's very serious relief that may not be appropriate for coercive control. I have other reasons, but for those reasons we oppose.
Maria Dorflinger, please.
Good afternoon. My name is Maria Dorflinger, and I'm an attorney at the Office of the Public Defender. We oppose House Bill 1069 because it would be impossible to enforce fairly. It would victimize the abused and unfairly subject more people to criminal sanctions. To illustrate, in 2016, I had a client I'm going to call Alexis. Alexis was married to a man who subjected her to every kind of abuse imaginable. She began using drugs heavily, drugs that he had introduced her to. She started to retaliate against her abuser in, I would say, petty little ways of property destruction. He destroyed her psychologically, emotionally, and physically, and she started to do things which might be considered coercive control under this statute. He got a protective order. There's no right to counsel during a protective order hearing, so she was alone with no one to help her present her story to show that she was in fact the one being abused. Anecdotally, it appears to me that people who have an attorney are more likely to prevail. She did not have one. She found herself homeless and unable to have contact with her children. She had no support network. She began texting her estranged husband, begging him to give her another chance. She was convicted of violating the protective order. At one point, the protective order was amended so that she could have contact with her estranged husband, but regarding the children only. He belittled her parenting skills. He called her a bad mother. She responded via text, "Oh yeah, like your father of the year." And once again, she found herself in the criminal legal system, convicted of violating the order. Protective orders are very narrowly tailored for a reason. By widening the net with vague language, the system are going to catch more people like my client Alexis, people who are doing the best they can in a bad situation. There is no perfect victim. Protective orders can push people out of their homes, away from their children. Thank you very much.
Mr. McAvoy.
Thank you so much, Chair, and I do appreciate you calling my name on the previous. That was for information only. On this bill, I am against this bill and have been down to Annapolis a number of times to explain that though, like I've said before, Delegate McComas is that's a real mess. But that's not worthy of creating a bill. It has been spoken of by different family law people and different people from defenders' offices being too vague, the doctrine, vagueness doctrine, too broad, lack of definition. And though our team contacted Judge Bryant regarding this issue of coercive control being put in the rules late last year, that doesn't mean it's a cause of action, and that vagueness will still apply. So whatever could be created, and I'm against what the appellate court did on that. That doesn't change the issue that some of the issues brought up in previous testimony is buying aspirin, overeating at the dinner table, where they're going to go for dinner. These things just don't rise to the occasion of wasting the precious time of our courts when we have real issues, child safety issues. This bill was offered, I honestly think at this point now, out of vindictiveness. And we should not be having this time taken, and we shouldn't have a bill like this. Because again, though it's been massaged and worked with a little bit, it's still not to the issue of getting courts involved when we have serious safety issues. Thank you for your attention.
Delegate Kaufman for a question, then Erica.
Yes, just very briefly, Mr. Chair. I want to direct this person to the question to the one person at the table. What's your name and organization?
It's Lori Ruth.
Lori Ruth. So, Ms. Ruth, I respect you and I appreciate your testimony, but with all due respect, what Ms. Nachman seems to have gone through is really bad. Like the thing under the pillow, not being allowed to wear makeup. And she did try and contact the police without success. So, I mean, I respect the fact that you're opposed to the bill, but, you know, what alternatives do you propose or for somebody in that situation? Because, quite frankly, it's easy to say no to something, you know, but do you have amendments? Or, I mean, what could you do to help people while still holding true to your position?
So I think that's a little bit of a two-part question, which is fine. In terms of how to help somebody, I mean, this is what we do for a living at the Women's Law Center, is we help people who are trying to get out of a difficult situation. When it rises to the level that they are in danger, that they meet the existing definition of abuse, then they have the mechanism of going to the court. But when it doesn't, it is very difficult, and we try and work and counsel and make proper referrals so that they can excise themselves from a bad situation, short of the really serious relief that's offered in a protective order. And that can be through, you know, divorce or other, you know, family law means, but sometimes it means, you know, leaving, trying to get divided from that person in some way, you know, sometimes before it escalates to something. So in terms of how to make the bill better, quite frankly, the sponsors never asked us that. And so I think I did speak with Ms. Shapiro about that. She's, does a lot of research when she's getting ready for a bill hearing, and she talked about a Massachusetts bill that she thinks is a better example of what a bill should be. I don't know whether she was saying that's what we should do here, but I have the same question. Is there something that we could do? And so I offer that to you from Ms. Shapiro. I have not read the Massachusetts bill, but she thinks it's a better approach if you were going to add it. And I'll just add, too, that I think she makes reference and we make reference to this report from the Battered Women's Justice Project, and I'm happy to leave this document with somebody if they want it, but you can also look it up, that talks about the states that have been enacting it in their protective order version, whatever their bill is, and that there's some unintended negative consequences to it, which is the misuse of it by the actual abuser, which I think Ms. Doflinger, if I am pronouncing your name right, suggested, that the abusers can manipulate the process to use coercive control against their victims more easily when coercive control is an element of the definition of abuse in a protective order than they can with some of the other definitions of abuse.
Thank you, and I would appreciate you leaving that document behind because I'd love to read it.
Happy to do that.
Delegate Kaufman actually asked my questions. Thank you so much.
Thank you, Mr. Chair, and thank you for coming in today. I do have a question about adding this element, maybe making a final protective order hearing a little more difficult. Is that what I'm understanding, is adding this one element? Is that just at final protective orders, or are you seeing those type of difficulties at interim hearings and temporary hearings?
Well, I mean, you have to meet a burden of proof. Granted, it's lower at the interim and the temporary, and so I suppose it might be easier at that time. But at the final, you have to prove by a preponderance of the evidence, I guess, coercive control. And I do think it's going to be hard to prove. I think that if you read this report, there are, states that are saying they hear testimony. It's often going to be he said, she said testimony, which we already have a problem with, even when the abuser has punched her or something. If there are no marks, if there's no objective evidence of it, they don't know what to do. I think that's going to increase if you add coercive control. So yes, it would. I mean, since you have to testify as to facts at each one, you'd have that problem at least somewhat in each one.
Thank you.
Further questions for this panel? Seeing none, thank you very much. That'll conclude the testimony on House Bill 1069. We're going now to House Bill 1019. Delegate McComas, and I believe this is just you. Yes, just you. Go ahead for 3 minutes.
Yes, sir. This is child abuse and neglect, reports and records. There's also a Senate cross-file, and I hope we're trying to get them conformed. 1091 is a very simple bill that clarifies Maryland's obligations under federal law to release to the public DHS, Department of Human Services, records when a child who has history with the department suffers a fatality or a serious near-fatal injury. Under the Federal Child Abuse Prevention and Treatment Act, CAPTA, every state is required to ensure that the public is informed about cases of child abuse or neglect that result in the death or near death of a child. The state must make public the child's age and gender, the cause of the fatality or near fatality, information describing any prior reports of child abuse or neglect involving the family, information regarding investigations pertinent to the child abuse or neglect that led to the child's death or injury, and services provided and actions of the state on behalf of the child. The problem with the current Maryland law is that while it provides for release of this information, it has an exception that swallows the entire rule. Under the current law, the state's attorney of the jurisdiction can block the release of the required information merely by stating that the release of the information would harm any related investigation or prosecution. Of course, there will always be an investigation into child abuse-related fatality, and the presence of an investigation should not allow the agency to duck or avoid its legal duty to the public. DHS contends that releasing this information will infringe on the privacy of families. Privacy must not be the determining factor when the very life of a child is at stake. In 2011, Federal Government Office of Accountability issued an extensive report to the chairman of the Committee of Ways and Means of the House of Representatives. The title, Child Mistreatment Strengthening National Data on Child Fatalities Could Aid in Prevention, speaks volumes. The report analyzed the deaths from maltreatment involving a failure on the part of the adults who were responsible for protecting them. Prevention is the key word here. Arizona has a website that provides the public with notice about the incident at the time of the initial report. The site is updated after investigation with a subsequent report that provides the findings of the agency indicating the persons responsible. By making such preliminary reports, the public is on notice and alert to make subsequent reports should they observe further alarming evidence of abuse or neglect. Thus, the public becomes an active participant in the prevention of child fatalities in aid of the already laden caseload of DHS. While I have complete confidence in the work of the Fatality Review Board, keeping these reports from the public only hurts the children, as the vigilant eyes and ears of the public are not utilized to protect our greatest legacy to the future, our children. Federal law requires such disclosures, and failure to follow that law may result in the federal government withholding our state's captive grant while opening the door to future litigation. The GAO report on child maltreatment asserts a powerful conclusion. Without the collection of routine data sharing child mistreatment fatalities, opportunities are lost to develop prevention strategies and to learn the risk factors associated with such maltreatment. As a society, we should be doing everything in our collective power to end child deaths and near deaths due to maltreatment. The collection and reporting of comprehensive data on these tragic situations are an important step toward that goal. Where is it that it takes a village mentality? You must hopefully pass this bill. Thank you very much, Mr. Chairman. And I apologize for running a tad over.
Questions for the delegate. We'll start with Delegate Simpson, then Delegate Eric.
Thank you, Delegate. I completely agree with you that we definitely need to end child fatality. So what I don't see in here is, and you reference, I guess, the attitude about the Department of Human Services, but I don't see their information or anything. Is that from prior times that you've had these conversations, or?
Actually, it is. If you look at line 15 on page 1 of the reprint, it says Article Human Services, because originally we had it as Anderson's Law, and that does not conform with the Senate version. And the reason it was Anderson's Law, and I'm kind of, that child was the 300th child that died last year in Baltimore City, and that was kind of dedicated to them. And then when we did a lot of research, that child, we don't know if they were a foster child or if they were in the original jurisdiction of DHS, but they were killed, and there is a trial that's going to be in June, hypothetically, because it might get bumped. But the person, anyway, it's already, and they have a public defender, and we were going to try to get a hold of the prosecutor, but they probably didn't want to talk to us so anyway, that was deleted. But it is the Department of Social Services, or the DHS Social Services is under them. So,
right,
and that's this section.
The Fatality Review Team is actually not a part of the Social Services.
Well, this is the response. No, we don't. No, we recognize that there is the Fatality Team, and they have a separate job to go over these things. That's like months down the line. This is just to say, and in the bill, it gives the state's attorney 30 days to look it over and say, hey, we don't, and redact any kind of disclosures. And this is what the federal law requires. And that bill is also in the Senate, and I know Senator James did a lot of research on it, and she's good at that.
Can you get us the response of social services on this? Just
I
at
don't.
least?
I only have last year's, and whoever I'm working with some other social workers. They said that Rachel Sledge was okay with it. So I don't know. I haven't seen any paperwork on it. All I have is last year's stuff where they kind of this is information. But then we found out that they may not be abiding by CAPTA. We also ran it by the State's Attorneys Association, and they're Mr. Kroll is out there, and I think he's just has no position on it. And if he does, we'll hear from him. So that's all I can tell you.
Okay, I just will be curious to hear what the current department
position and also, yeah, the state's attorney,
But they haven't sent you anything yet. They may shortly. I don't know. Because I don't have in other words, in the old days when we used paper.
Right.
Yeah.
It's
I
not
love
in
paper.
here. It's
And,
not in here.
We don't get that. Only if you're on the committee. If I was on Judiciary, I would get that information, but I'm not on Judiciary, so I don't get the opposition paperwork.
Yeah, it's not, and also the medical examiner, which has the fatality review team. I'd be interested in there.
But that team is actually, I think Delegate Grammer sits on that, or did, and they don't get into that until way down the line.
I mean, as a former Child Protective Services worker, the time frame just seems so quick, particularly when you're looking into this. I'm not saying that eventually it wouldn't, but it just seemed really fast.
Well, that's why we talked to the state's attorney's office, because originally it was 10, and then we upped it to 30, and we talked to them, both Senator James and myself. I mean, as I said, she's very thorough, and they had a long discussion. She went back and looked at the federal, and the concern was we're not adhering to CAPTA. So it's all about the money, when you're not in compliance with the federal government.
I hear you. All right, thank you.
Delegate Erican.
Thank you, Mr. Chair. So yeah, I was sort of along the same lines as my colleague. I noticed there's no opposition testimony, and I think, being on this committee for so many years, you and I both know, the department doesn't usually shy away from sending negative testimony if they're opposed to something. I would imagine that we would probably see something by now, or at the very least, they would have emailed us. So it looks like you did a great job bringing stakeholders together at this point, and there's nothing in opposition at all. So isn't that so, Delegate McComas?
Well, as I said, I don't get the memos.
Well, I would let you know, and there is nothing in here, and I've gotten no emails.
So if you see anything, let me know, and hopefully the good chairman, I hope he misses me, would let me know.
All right, are there further questions for the panel? Seeing none, thank you very much. That concludes the testimony for House Bill 1019. Delegate Simpson, is there someone related to you here? Someone? Is today your anniversary, I think? Is that correct? Really? Are they
you
here?
notice that really cute guy in the audience? Yeah.
Oh, well, let's make him stand up for a second and congratulate the two of you.
27 years worth on a day that we're already running into.
All right. Well, where to go on your anniversary. It's where you go on your honeymoon, apparently. Everything. Everybody's always coming to the Judiciary Committee. It really is. That's what everyone says. House Bill 758, though, is next, and Delegate Bartlett has two bills, apparently with the same panels, I think, more or less on each bill. So if they're here, we can have them both come up. The representative from the Attorney General's office is, Ms. Hurley is favorable. Oh, she is virtual as well. There she is. Ms. Hurley is favorable with amendments on this first bill on 758, but we'll go ahead and take her as part of this larger panel. But Lisa Jordan, did she have to go across the street?
She is, yes.
Okay, that's fine. So we'll hear from you and your panel and go from there. Thank you.
Okay. Thank you, Mr. Chair. And for the record, I'm Sandy Bartlett. I represent District 32 in Anne Arundel County. And I am so proud to be able to sponsor this bill, these two bills. I serve on the Sexual Assault Evidence Kit Committee of Policy and Funding with these fine individuals you will be meeting today. And we have worked together over several years to create policy and to do all that we can and more to make sure we have a streamlined method with respect to the testing and treatment of sexual assault evidence kits. So, but with that said, there was someone who was even more advanced than we are. So we formed in 2017, I think it was, or so. It was before I got here. But someone even brighter and dare I say intelligent than we are, or forthright, Dr. Rudiger Breton-Necker. He was a pathologist in Cockeysville, Maryland, and he saw women sitting in the emergency room who had sat there for 8, 10, or 12 hours, and he said, wait a minute. And he thought to himself, this is atrocious. So, and he said, women deserve better than that. And with that said, he started saving sexual assault evidence kits. Now, they weren't called that back then. They weren't called rape kits back then. He just knew that this forensic science would one day be needed to prove or to at least help facilitate in proving or the implementation of helping individuals who might have been subject of a crime. So he is now on my hero list because of that work that he did, and we can learn a lot from that, and we have learned a lot. So therefore, we bring to you House Bill 758, and we also bring to you House Bill 759, which we'll talk about in a moment. But we want to extend the time frame in which the storage is required, because we now know that this evidence, and the folks with forensic science backgrounds can even get into it deeper, but we now know that this evidence needs to be preserved a lot longer than what we thought. So 75 years is what we're asking. We're also, there are do-it-yourself kits now that are being advertised, and so we wanted to include that in. Now, some people may say, well, what about the custody and control? All of that we are reviewing in our committee, and we will continue to review and figure out ways to streamline. Thank you, Mr. Chair, and I turn it over to my esteemed panel.
Sure. Good afternoon, members of the committee and Mr. Chairman. My name is Jane Krinke. I'm here on behalf of the Maryland Hospital Association and our 60-member hospitals and health systems. So we've been a member of the committee since the inception, and it's been a wonderful collaborative process. And we are here in support of this bill, which you're seeing is a lot of result of many hours of discussion, and including with Greater GBMC and Dr. Breitnecker's team now. So they're full support. They're looking forward to working together with the committee to develop a process to safely transfer these slides from the hospital to labs where they can be tested, so that these women can have their justice. And so with that, we are here in support. So thank you for your time.
Good evening. Nice to see you, Chairman, members of the committee. Thank you so much. Scott Schellenberger, State's Attorney for Baltimore County. I'm also a representative for the Maryland State's Attorneys Association on the Maryland Sexual Assault Kit Policy. Several years ago, we were down here and we passed Criminal Procedure 11926 that required sexual assault kits to be saved for 20 years. Well, because time has moved on and the DNA testing has gotten so much better, we need to lengthen that time. So let me give you an example of the kind of time we're talking about in some real cases. In 2002, Alfonso Hill was convicted of raping a woman from back in 1983. These were slides that Dr. Breitnecker had saved and kept before DNA was even, or the testing of DNA was even invented. What's more remarkable, Hill was also convicted in 2010 for a rape that occurred in 1989, 21 years before. But of course, the longest one, unfortunately, was a Goucher student who was raped and murdered in 1979. 30 years later, we analyzed Dr. Breitnecker's slides and were able to convict Alfonso Hill again. He's now been convicted of 15 crimes, including the murder. These kits are not that large. I brought the size of one. So I know somebody was writing in saying that, how are we going to keep these for 75 years? This is the size. They would be a little bit thicker, but they can sit on a shelf in a property evidence room in the Baltimore County Police Department or anywhere, and they can actually be put on top of each other. The swabs, when they're taken, are put on not slides like Dr. Breitnecker did, but they're put on a swab, and then the swabs go into envelopes, they're labeled, and then they go into here. The police department then takes it from the hospital, goes over to the property evidence room, and puts it in the property evidence room. The reason we grabbed on to 75 years was just looking at the fact that now we're doing things 30 years later with Dr. Breitnecker slides. Why shouldn't we hold the best possible evidence to convict people of rape cases and sexual assault cases for as long as we possibly can? And that's how we came up with 75. In addition, there are a number of amendments. I had signed up before all the amendments got put in. I'll defer to my Assistant Attorney General, my counsel, Ms. Hurley, who's on Zoom. She has been working hard on the amendments, particularly to adapt so that the GBMC-type slides, wherever they may be, not necessarily Baltimore County, but anywhere, can also be preserved. Thank you so much.
Then let's hear from her. Ms. Hurley, please.
Hi, good afternoon, Mr. Chairman and members of the committee. I'm here today on behalf of the Office of the Attorney General, as well as the Sexual Assault Kit Policy and Funding Committee, which I currently chair as the AG's designee. This session, the committee has two legislative priorities. The first, of course, is this bill as amended, and I hope that you will consider the amendments to be sponsor amendments. They do significantly rewrite the bill. And we'll make sure that you all have those if you don't already. But the amendments in the bill essentially seek to make 3 improvements to the law governing sexual assault evidence kits, or SAKEs. And each of these is driven primarily by our desire to bring some level of state oversight to the sexual assault evidence that my colleagues and fellow committee members have discussed. These slides that Dr. Breitnecker collected while he was working at GBMC. So what we're asking for, we're asking that you add a definition of SAKEs to the law to ensure that the GBMC slides and any other similar evidence out there can be identified, tested, tracked, and retained consistent with recent reforms. And what we do is we borrow the definition that's used by the Department of Justice in their Sexual Assault Kit Initiative program for this purpose. Excuse me, House Bill 758 also seeks to increase the SAKE retention, as you've heard, from 25 to 75 years. That's really more appropriate when we're talking about crimes that largely have no statute of limitations under state law. And of course, if the GBMC slides had been transferred to the Baltimore County Police when Breitnecker retired back in the late 90s, they could have been lawfully destroyed by now, and we don't want to do that. I do want to thank GBMC for its continued commitment in working on this issue. The bill also, as amended, addresses these self-administered do-it-yourself kits. I'm happy to answer questions about how it seeks to do that since I'm out of town, but I certainly will welcome questions about the bill. The committee and the Office of the Attorney General are in full support, and we urge a favorable report.
Thank you very much. Are there questions for this panel? Delegate Cardin.
Thank you, Mr. Chairman. Just real quickly to the state's attorney, assistant state's attorney on Zoom. Can you explain how we would be able to retain and keep the self do it kits as well?
Sure.
Assistant Attorney
General's office. Yes. Okay. So essentially, the creation of these self-administered, do-it-yourself at-home kits, whatever you call them, is relatively new and quite controversial because they have obvious chain of custody and credibility issues that would make it very unlikely that they could be used in a criminal proceeding. That said, we do also understand, based on the perspectives that our sexual assault victims advocates brought to the table and our forensic nurse examiners, that these kits were largely created to fill a void for victims who are in underserved communities or who, for whatever reason, have distrust of the law enforcement or healthcare, professionals in their areas. And so to the extent that they are used, what the bill would do is simply require that they be retained by a law enforcement agency so that they could be evaluated at some point by a prosecutor to determine whether they had any value, could any way help obtain justice for a victim of sexual assault. We just don't want that evidence destroyed. It doesn't require any other of the reforms, the testing, the tracking, doesn't require any of that to be applied to the at-home or self-administered kits. What the bill also does, taking into account the significant concerns that our committee members have about the proliferation of these kits, is require us to issue guidance to the public educating them about the pitfalls of the kits, and also to work with members of our Consumer Protection Division to determine whether it's appropriate to provide some additional regulation of these kits in the marketplace, such as requiring labeling, et cetera. So that's what the bill does around the as amended around the at-home self-administered kits.
Any further questions for the panel? Seeing none, thank you very much. That concludes the testimony for House Bill 758, but stay right there. Here comes House Bill 759. Again, Delegate Bartlett.
You're much faster than I am, Mr. Chair, but I'll get there. Well, thank you all. Thank you, Mr. Chair, and members of the committee. Thank you, Mr. Vice Chair, as well. So this legislation, House Bill 759, essentially has two purposes. It establishes a rape kit reporting system, and it also clarifies the rape kit testing grant fund. So House Bill 759 will explicitly define that the grant fund can be used for equipment, supplies, personnel, and necessary outsourcing to test sexual assault evidence. As you heard with the last bill on House Bill 758, there are a massive amount of backlog sakes, and now we have the do-it-yourself kits. In order to ensure that we are doing our best to serve and to support victims of these crimes, we need a reporting and tracking entity. House Bill 759 establishes that entity for that sole purpose. This legislation requires that any sexual assault evidence kit or SAKE be entered into a database that will record location, status, and chain of custody. The do-it-yourselves are not included in that group currently, but I just wanted you all to know about that when we testified on House Bill 758. As it stands now, only the sexual assault evidence kits that are currently within statute or currently defined in 758 will be a part of this reporting system, as Ms. Hurley testified. So that's what the bill does, and I'm excited about this one as well, and thank you. I would appreciate a favorable report. This came from the committee as well.
Is Mary Corzine here? No? No? Okay. We had her signed up as well, and I just was making sure. Sorry about that. We'll go right ahead.
Sure. Thank you, Mr. Chairman, members of the committee. Again, Jane Krinke with the Maryland Hospital Association here, and happy to support House Bill 759. So this bill is also the result of many years of conversation the committee has had about a tracking system, and we received as a state a federal grant to support development of a tracking system, and we spent many hours thinking about the components needed. And hospitals across the state have sexual assault forensic exam programs, or specially trained forensic nurse examiners care for survivors of all kinds of violence, and they are committed to participating in the kit tracking system. We've seen from other states how beneficial it can be to have a statewide tracking system, both to have accountability for the kits and also, most importantly, to allow survivors to know the status of their kit in the process. And so we are happy to support this bill, and we ask for a favorable report. Thank you.
Thank you so much. Scott Schellenberger, State's Attorney for Baltimore County. I'm not only a member of the KIT team, but I am actually on the subcommittee that is currently looking at contracts for vendors. I can't talk too much about the procurement process, but I can tell you I'm extremely excited about the products that we are now currently reviewing. It's a team of 4 who are reviewing each of the products. And what it would allow us to do is we would put a barcode on the kit, and then the kits would go out to the hospital. When the slides and swabs are taken, they would all be returned back to the kit and returned back to the envelope. Then they would scan the barcode. It would go to this system that we are going to hopefully purchase and buy into that would say when the kit was collected. It would then go to the police department, who would then have to hit the barcode, and you would be able to find out when it went to the property evidence room. And more importantly, the barcode would be hit when it went to the forensic lab to be analyzed, or to the outside lab because they had to outsource it. The very exciting part about this is that the victim will actually get access to that system. This will not be a public system. Nobody else can see it, just hospitals, police, my office, and the victim. The victim, from the privacy of their own home, will be able to go into the system, put a number in and a code in, and find out where in the process their kit is. Well, I don't say this too often twice. It's very exciting to see how much progress we've made in this area over the last several years, and I'm extremely interested in hopefully being able to roll this out at some point and you all being able to see it. So, and not only does it require us to do the kits going forward, but we have a time period in which to do our kits backwards. And as was said, there's a huge backlog. I get a monthly report. I currently have somewhere in the area of 200 plus kits and or Brightnecker slides down at Bodie, which is a company that does outsourcing, and they call us every month and say, stop sending so many. So we're trying to get caught up, and this will help.
Ms. Hurley, please.
Good afternoon again. My fellow committee members have covered most of the high points. The only thing that I'll add, just a couple of points. One is that in addition to this tracking system being consistent with the federal SACI grant that we received, and in fact the grant is really funding the bulk of the startup costs here, hundreds of thousands of dollars set aside for that purpose. This tracking system is also consistent with the directive that you all gave the committee back in 2018 to develop recommendations for establishing a statewide tracking system. And Scott mentioned the fact that we're not just looking, prospectively, but we're also asking agencies to add in all the kits in their possession. And I just want to make the point that this is critical because it's going to provide more transparency and accountability in our efforts to ensure agency compliance with all of the many reforms that you all have enacted over the past 5 years with regard to how we handle rape kits in the state of Maryland. Just so you know, our office did promulgate regulations requiring annual agency reporting, but agencies have been really challenged to submit timely and accurate reports. And it's our expectation that once this tracking system is fully implemented and operational, that it will be able to generate most, if not all, of the data that we currently require by regulation, which would give us a more accurate picture of the current state of SAKES in the state of Maryland. So for all these reasons, we urge a favorable report.
Questions for this panel? Delegate Conaway.
Mr. Chairman, thank you, panel, for coming in to testify, and delegate for bringing the bills. Mr. Schellenberger, are you still, do you know if the attitude towards testing the kits is still that if there was a conviction that the kit doesn't need to be tested in that case?
So the standard is that if the defendant's DNA is already in CODIS, and that's the system that we would compare other cases to, that if it's already in CODIS, you would not necessarily have to test that kit for identification purposes. But if that individual had committed another rape and the person didn't know who the person was, then we would still test it and compare it to the actual CODIS. So if they're already in CODIS, you don't have to do it twice, but if it's an open case, then you would do it because you want to prove who did the sexual assault.
Okay, and as far as the transparency is concerned, how come the data won't be available to the general public if it's just numbers?
Well, I don't think a sexual assault victim would want her assailant to know where the sexual assault kit is in the chain of command. Or if he's in jail, his family, who could then tell him in a phone call. We do have different transparencies. If you're
well, you didn't say that the perpetrator would necessarily know the victim number, the number that would be on the test kit.
That's correct.
So as a part of the charging, well, I don't want you to make me seem like I don't know what I'm talking about.
No, I'm going to answer your question.
Okay.
So Baltimore County has just launched several months ago a website that tells you how many kits we have and what the status is. So while we don't put up, the sexual assault that happened on Charles Street is in this place, We are now being more transparent by putting up where it is in the process. How many are untested? How many are tested? How many are not being tested because the person wanted to remain anonymous? So we are putting that up now, and it's our intention to get that information out there.
And so since that's just numbers and data, how come that information isn't available to the general public for statistics purposes?
I'll answer that. So sometimes sexual assault victims are so guarded, as you heard today. And I know a person who once they were in therapy and they were paying for their therapy session with a check that had some flowers on it. And the therapist said, you know, most of the sexual assault survivors that I work with have decorated checks. That may not seem like a big deal, but it's something that automatically makes you go right back into your shell. So we're trying to help people, and we don't want them to ever feel like, oh my gosh, somebody might ever find out, you know, who I am and where I am and what I'm doing or anything. So this is new, relatively new. 2017 was the statute. This committee, and so we have listened to various victim right advocates, and at this point, yes, first of all, for a victim to even be able to track their rape kit is huge. That's huge. So it's going to take some baby steps. It really is. It's going to take some baby steps. And not all victims want any type of connection with themselves for the public. I will tell you that person whose therapist said all my sexual assault people, right, colored, you know, have these flower checks, got rid of those flower checks and won't do it anymore because of that very reason. So the association, while it may not always be something that a non-victim would understand, it's so much trauma that goes with it that we want to do everything that we can to keep the anonymity as possible.
That was a beautifully eloquent answer, but my question was, if you just have raw data, for example, if you just have 0759, how does somebody know who that is? So if it's just
the same thing with the checks.
0759,
the same thing with the checks. When you're
how?
working, I'll tell you, because
generated.
When you're working with victims of trauma, you do not want to, at this level, where we are now, perhaps we'll get there one day, Delegate, we're not there right now. We are just now working with victims of trauma and getting their trust. Because what happened was there were so many rape kits that were thrown in the trash, period. And so we're working with gaining trust. And the last thing we want to do is give any victim any fear that there could be any association. And yes, while it is just a number, it may not be a logical fear, but it could be a fear. And we don't want to give them anything to feel uncomfortable about.
Well, then to answer that, they should have fear even if you don't publish it, because if a number is issued somewhere, somebody knows the name that's associated to that number, and it could be in law enforcement, and the law enforcement could connect A and B together. But respectfully, I understand your answer. Thank you very much.
All right, that looks like the end of questions on this bill and the end of the hearing on House Bill 759. We're now going to go to House Bill 800 from Delegate Phillips. And we have one person joining you. Caitlin McDonough, does that sound right?
No, Bert,
Bert Randall.
Bert Randall. And it was,
okay, that's favorable with amendment?
Yes, and I think, I believe Caitlin was here earlier, but may not be here any longer.
Okay.
Mr. Vice Chair.
All right, whenever you're ready.
So give me a minute to get myself together, Mr. Vice Chair. This has been an interesting day. So let me begin. Mr. Vice Chair, to the members of the Judiciary, Scott Phillips, Delegate District 10. I'm here today, really, this is a simpler bill, folks. And it really is to clarify a matter dealing with child support enforcement and workers' compensation. This is, interestingly enough, something that has been going on for a very long period of time, and there's been no answer to it. And so hopefully this bill will bring some clarity to a number of people. So if you think about this particular matter, there are a number of stakeholders. We've got the injured party, parents, children, defense attorneys, child support enforcement, workers' comp, the judiciary, and insurance companies, maybe more. What takes place, and I'll give you a scenario. Individual gets hurt on the job, goes out, is out for 6 months to a year. Workers' comp claim, and it takes him a while to get that workers' comp claim heard. In the meantime, he's got a child support, or she has a child support enforcement order. And so they're going to build up arrears because there's no money to be taken out of a check that you don't get. They build up those child support arrears. All of a sudden, they now get their award. The courts are unsettled. Child support is unsettled. Workers' comp is unsettled as to how much of that award they can take for their arrearage. This bill attempts to address that issue. It caps it at 25%. And I'm going to turn to Mr. Albert so he can tell you why, from a technical perspective, this is needed. Thank you.
Thank you, Delegate. Thank you, Vice Chair Moon, members of the committee. So I'm an attorney and president of Franklin & Prokopic, a mid-sized firm based out of Baltimore, where I head the firm's employment practice. As part of that practice, I've conducted workers' compensation defense for nearly 25 years, but prior to that, I also represented injured workers for several years. So I've faced this problem for nearly 30 years on both sides of the V. As a housekeeping matter, I do understand that there's going to be an amendment that's going to remove the reference to federal law, which will also allow it to mirror Senate Bill 71, and that's not going to be a meaningful change. You know, this certainly seems to be a rather simple and almost innocuous bill, but its importance is underscored by what Delegate Phillips said, as well as all of the stakeholders that seem aligned on this issue. Since workers' compensation is not noted in the existing statute referencing personal injury garnishments, it's allowed wildly inconsistent results, wherein I've seen countless instances where 100% of the money that's awarded under workers' compensation is taken for child support. I've seen 0%. And I've seen everything in between. Just to give you one anecdotal instance of this, I represented a client that was ordered to pay monetary benefits, very straightforward, and they're ordered to pay those benefits within 15 days. There were 2 child support enforcement agencies and 1 injured worker represented by counsel. None of them could agree. My client had to pay the order within 15 days, otherwise face regulatory penalties, but then they were threatened on both sides as to how that payment would take place with ongoing litigation. It left my client in a legal quandary, and it's something we face regularly for those practitioners in workers' compensation. By including it in the statute, as Delegate Phillips noted, it's going to provide clarity to all of the workers' compensation stakeholders so that there is an equitable and fair payment and enforcement. For those reasons, I request a favorable report. Thank you.
Delegate Kaufman.
I just have it'll be very brief, but I do have a question for you, Delegate Phillips. I appreciate the fact that you, my dear friend, are bringing the bill, but let's assume, and it would cap what somebody has, that somebody only has to give 25% of their child support from 25% of their workman's compensation award, their monthly payment, to in child support, correct?
That would be correct.
So let's assume that that the 25% I receive, that I pay, amounts to less than what I would normally pay on a monthly basis if I hadn't busted my kneecap or something. So when I'm healthy again, do I owe the custodial parent the monthly child support plus what I couldn't pay her because I only had to pay 25% of my child of my workman's compensation check to her.
So that one I'm going to turn to Mr. Randall, but if I could, Delegate Kaufman, but I failed to say something else, and I think it's important. This actually passed, House Bill 650 passed last year. It was sponsored by then Delegate Brooks, who's now Senator Brooks. That bill passed one very similar bill, except for the amendment that we're now going to put in regarding the federal statute. That bill passed 131 to 0. It is this time it is being cross-filed in the Senate and in the House. But I'm going to turn to Mr. Randall to give you that answer to that hypothetical.
Thank you. If I may, the reason why, and that's why there was an initial reference to federal law, but the amendment will just take away, in that federal law still remains controlling. There's the Federal Credit Consumer Protection Act, which is very specific and provides certain guidelines as to garnishments. So therefore, there is already a cap in place when it comes to garnishments under federal law. And what we don't want by this bill is to be inconsistent or exceed the federal cap, which would be then preempted, would preempt Maryland state law. So in answer to your question, Delegate, is that this 25% helps mirror federal law, but it also makes it consistent with personal injury garnishments and personal injury settlements that are already referenced in the statute. So this just simply clarifies that workers' compensation will be treated like personal injury. But to further answer your question, I'm sorry for a more detailed answer than perhaps you were expecting. But we've got the federal law component. Once it's satisfied and the garnishments are then conducted lawfully, then the existing child support order would go into effect. But candidly, because of the Consumer Credit Protection Act under federal law, there are still going to be caps on the amount of money that, even aside from the workers' compensation claim and monetary benefits, there will still be a federal cap in place.
Thank you.
All right, Delegate Conaway and then Tolles.
Mr. Chairman, thank you, Delegate, for bringing the bill. Thank you, witness, for being here. So if the person's making $1,000 a month and they're supposed to pay $300 a month, under this bill, they would be capped at $250 basically a month that will come out of the workman's comp settlement?
Yes, they would be capped at 200. They would be capped at the 250.
So now the person is supposed to pay $300 a month, and they haven't been paying their child support because they've been sick, they've been hurt. In the meantime, isn't a flag put in at DMV against their driver's license because they haven't been paying their child support?
Depends on how long, and it depends on the enforcement of child support, the aggressive enforcement of child support. So they may or may not.
They may or may not. So if it has been, and it says that they were supposed to pay the $300 a month, but when they make the settlement, it comes out to they pay $250 a month, and they owe, let's say, another $150 for 3 months. Would that satisfy DMV, you think, to remove the suspension and work it out, or that would be a totally separate issue?
That's a totally separate issue outside of the realm of this particular bill.
Okay, thank you so very much, Delegate.
Delegate Tolles.
Thank you, Mr. Chair. I just wanted to say that I think this is a good bill because I believe it will have some, let me see how to summarize this. It's late. It will go a long way in ensuring that particularly, minorities who can experience, issues in terms of child support payments that are, whether it's overdue or has some issues that, it's not taking away folks' sole income or allowing them to, go further in arrearages. Isn't that so?
Isn't that so? And statistically, unfortunately, African American males are affected at a higher rate when it comes to child support enforcement related matters than others in the state of Maryland. And so it does have a direct effect on a particular population.
All right, thank you very much. We've got one opponent signed up on the bill. Here he is. Vince McAvoy.
Thank you, committee.
2 minutes.
Thank you so much. I'm against this bill, and I want to ask, this is really pertinent, especially for new delegates, to picture exactly who this bill is going to affect. You sort of got at it tangentially. This isn't for actuaries who broke their thumb in the office kitchenette. These are for people like who I work with, like somebody who got their finger cut off in a batch feeder, somebody who had hydrofluoric acid spray in their face, hit their eyes. And what a dad should do, and incidentally, Maryland doesn't really pursue women too often, owing child support. What the dad should do is immediately submit a motion to modify that outstanding obligation. The thing is, you get a finger cut off, you get acid in your eye, you can't go to work, you break your knee or something like that, you fall from a ladder. This is probably not the first thing on your mind. The first thing on your mind might be calling your kids, telling them you're okay, and saying, look, to the ex, well, it might be a moment till I'm financially sound. This bill basically is for, as if you can read between the lines, is for this industry. And I said the same when now Senator Brooks brought the bill last year. To put it in perspective, everybody got COVID checks. Everybody got these incentive checks. I only know of one group who had them snatched by the government that was sending it out to everybody, even people that weren't residents, and that's fathers for child support cases. So this is going to further hamper getting that parent back on course with child support payments and whatever arrearages come up. And what it's going to do is basically make it easier for workers' comp lawyers. Again, picture this dad. He's worried about food and also child support. This bill is just going to make lawyers' lives easy. Please vote this bill down. I'm available for questions.
All right, no questions for you, unfortunately. But that means we're going to end the hearing on House Bill 800, and we are going to move on to House Bill 1191 from Delegate Pasteur. All right, we have a few people signed up. Zach Shirley, Jake Schrader, Sarah Meeke, and then virtually William Steinwiedel, sorry, Zach Shirley, Amanda Rodriguez, Allie Anderson. And we have a couple favorable with amendments, but we'll take them next. All right, whenever you are ready.
Good almost evening, Chair, Vice Chair Moon, and the members of the Judiciary Committee. For the record, I am Cheryl Pasteur, and I'm here to testify in support of House Bill 1191, establishing the Task Force on Preventing and Countering Elder Abuse. Is cross-filed with Senate Bill 797. In 13 years, we can expect to have more people older than 65 than younger than 18. The United States Census estimates that the number of Marylanders 65 or older is expected to double by 2030, about 1.2 million people. The fastest growing population of people 85 and older, people at greater risk of a variety of illnesses and dementia, and vulnerable to abuse and exploitation. Every year, an estimated 5 million older Americans are identified as having fallen victim to some form of abuse or exploitation, unfortunately, usually by someone they know and someone on whom they should be able to trust. This task force will study existing laws and policies and practices related to elder abuse and other crimes commonly committed against older adults, make recommendations regarding changes to state law, policy, and practice that would aid in the prevention of elder abuse. This task force will present a preliminary report of its findings and recommendations to the governor and General Assembly by December 31st, 2023, with a final report due by December 31st, 2024. We must be forward-thinking about protecting our elders. None of us, when we were young, or still young, think about being at the mercy of someone else and definitely not being abused. How we prepare and care for our elders reflect our humanity and our future. So, colleagues, I'm asking favorable vote with respect, with love, that we vote for 1191 to create this task force on preventing and countering elder abuse.
I think it's good evening now. I don't know. Good evening, Vice Chair Moon and members of the committee. I'm Sarah Mirsky-Mickey. I'm the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all of its agencies, including Jewish Community Services, HI, our low-income housing organization, and HANA, our domestic violence, elder abuse, and trauma organization. You guys have been here for a long time today, so I'm going to give it to my colleague, Jackie Schroeder, who runs our program for our preventing elder abuse at HANA, to talk about the importance of this bill, but I'm here to answer any questions about the makeup of the bill or the reasoning behind it if you have after. Thank you.
Good evening, Mr. Chairman and committee members. My name is Jackie Schroeder. I'm the director of the Elder Abuse Awareness Program at HANA, the Abuse and Trauma Agency of the Associated Jewish Federation of Baltimore. Since launching our program in 2013, we've been providing comprehensive response, including legal, clinical, and shelter services, prevention education, advocacy, and consultation to victims, families, and professionals. To date, we've served approximately 900 community-dwelling victims in Baltimore and other jurisdictions who were being financially, physically, sexually, and emotionally abused and human trafficked. The vast majority of our clients did not meet the definition of Maryland's Criminal Law Code, Section 3, 604, and 605, abuse or neglect of a vulnerable adult, nor did they meet the criteria for investigation by Adult Protective Services. Both the laws and investigative criteria are defined in limited ways related to a victim's lack of competence and capacity. Most of our clients have had the competence to meet their own daily needs and the capacity to make their own decisions. Whenever a crime is committed against an older adult, elder abuse should be considered. Therefore, now in Baltimore City, over 5,500 police personnel have been trained about elder abuse. To further everyone's understanding, we co-authored with the Circuit Court for Baltimore City the Maryland Elder Abuse Judges Bench Card, which now is located in the Judiciary's digital library. In 7 years, almost a quarter of our population will be older adults. There's an urgent need now for all our laws related to older adults, abuse, unlicensed assisted living, etc., to be reviewed through an elder abuse lens to enable looking beyond what appears on the surface to ensure that victim safety is enhanced and abusers are held accountable. We urge you to vote for House Bill 1191. Thank you very much.
All right, let's take our online witnesses, starting with William Steinwiedel. I hope I got that right.
Hello, my name is William Steinwhittle. I'm the supervising attorney for the Maryland Legal Aid Bureau Foreclosure Legal Assistance Project. I just wanted to add a little bit of context on the experiences that I've had dealing with elder abuse. I've been a lawyer for 13 years, and I've been legal aid nearly 9 years, and I have seen some of the most egregious things done to seniors that I've ever seen. I had one client who received a large settlement that allowed to keep her home, but her daughter stole it and bought her an apartment instead. I represent another client whose son and girlfriend were living free in the house, and when the mother asked for assistance, they simply moved out of the house, and she lost her home. I also represented another client who was so scared of his son that he refused to force him out of the home, which prevented him from being able to sell it for substantial equity that he would permit to do. I represented another client whose family had taken out a reverse mortgage, and she didn't even know that it had happened. I luckily got to her about a week before the house was sold, and I was able to file a motion to stop the sale, and we were able to get the sufficient funds for the sale. But I know that there's more seniors out there who I cannot get to before these horrible things happen. I've had so many clients give away money for prize scams, son scams, romance scams, that it's become too much to count. So I very much urge this commission to be formed. It's desperately needed. We need to come up with better solutions, and we need to make people more aware of what's out there. Because, again, as the other members of this panel have stated, our population is aging, and they're becoming more and more vulnerable by the day. So I strongly urge a favorable report on House Bill 1191. Thank you for your time.
All right, next let's hear from Allie Anderson.
Good evening. Thank you for the opportunity to testify in support of House Bill 1191. My name is Allie Andreessen, and I am the Long-Term Care Assistance Project staff attorney at Maryland Legal Aid and co-chair of the Aging and Law Task Force. Legal Aid is a statewide law firm providing civil legal services to Maryland's low-income residents. Sadly, we encounter older adults experiencing abuse often. If a client comes to us, we normally discover or begin to suspect abuse during our investigation process. Sometimes the client is able to vocalize the abuse and the trauma they have experienced at the hands of a caretaker, whether that's a family caretaker or those charged with their care in an institutional setting like a nursing home. Sometimes the client is unaware of the abuse or exploitation, financial or otherwise, that's occurring, and is only discovered while our advocates are investigating and reviewing records. Abuse suffered by older adults affects their physical and mental well-being, causing irreparable, often life-altering harm. But the abuse can also impact their ability to access health care, make their own life decisions, and it complicates accessing their income, assets, housing, or public benefits. When older clients face abuse or neglect, Legal Aid works to help fulfill the client's goals, which includes, but is not limited to, exploring options through public benefits, long-term care, securing their income sources from abusers, changing or removing a power of attorney, and notifying parties like financial institutions about the changes so access is terminated, and supporting clients while working with survivor advocacy groups. Central to our work is prioritizing the individual's ability to make their own decisions. There is not enough time to go into all of the complaints of neglect and physical abuse I have heard from residents of nursing homes across the state, but the abuse and neglect of elders in institutionalized settings is one of our biggest concerns. You can't read the news without seeing some of the terrible things happening. Older adults deserve to age safely and with dignity, and for the reasons stated above, we support the creation of this task force and House Bill 1191 and urge a favorable report. Thank you so much for your time.
All right, next we're going to hear from Zach Shirley.
Good evening, Mr. Vice Chairman and distinguished members of the committee. My name is Zach Shirley, and I'm the director of the Maryland Medicaid Fraud Control Unit in the Office of the Attorney General. Since its inception in 1979, the Medicaid Fraud Control Unit has been charged with investigating and prosecuting the abuse, neglect, and exploitation of the vulnerable adults in this state. At present, our unit's attorneys have a combined 45 years of criminal prosecution experience working with vulnerable victims. The abuse, neglect, and exploitation of the elderly population in Maryland is an emotive and disturbing topic. The stories of these victims cry out for justice, and that justice is what our office seeks to provide. Over the years, however, our office has seen examples of cruel, callous, and exploitive conduct for which the law did not provide appropriate or sufficient tools to address them. Overly vague or overly specific definitions, blind spots in the law for new or emerging types of abuse, or rules that prejudice the ability of the elderly to seek recourse because of the natural consequences of aging, such as fading memories and failing health. Our office has noted these issues and we have sought solutions, and we would welcome the opportunity to be included in the proposed task force because we know that while prosecution of those responsible for the abuse, neglect, or exploitation of vulnerable adults is part of the solution, it is only one perspective of what must be a larger conversation, one that is multidisciplinary and addresses the root causes of abuse in order to create a system that prevents abuse as well as punishing it. House Bill 1191 is an exciting opportunity to formalize the conversations that are already taking place in multiple stakeholder forums, task forces, and community groups, and to formalize the results of those conversations into concrete recommendations for change. As such, we urge a favorable report. Thank you.
Delegate Cardin and Williams.
Thank you. Thank you very much, Delegate Pester. What a great bill. And I just want to know, since it seems like financial abuse seems to be one of the key issues here, I would love to see somebody from like the financial institutions or banking institutions on the work group.
Absolutely. In fact, I received an amendment. I've received, I think, about 9 amendments, and each one was asking to be on it. And one comes from the Bankers Association because they are so now integrally involved in the investigations of fraud.
Well, welcome to the world of work groups.
Yes. Thank you for that question.
Okay. Thank you so much, Delegate Pester, for bringing this bill. My question was somewhat similar to Delegate Cardin's bill. I was looking at the letter from the Alzheimer's Association, which is an association that's near and dear to my heart. And again, they had an amendment where they were recommending the Maryland's long-term care ombudsman on the task force. So I'm assuming you've seen that one as well. Okay.
Absolutely. And that's in the forefront as well.
Good. And then secondly, in the years past, I don't think we ever passed this bill, but I know one of my colleagues used to have a bill that was at the request of my county executive some time back with regards to creating, let me make sure I'm getting the language right, a registry, a vulnerable adults registry. And so if this bill were to get passed, I just hope that that's also something that the work group would look at because as you mentioned, and it has been testified today, just the concern of the targets that elderly people have been facing, but more importantly, vulnerable adults as well. When I think of vulnerable adults, I think of someone like my dad who had Alzheimer's and dementia, and just, you know, his later on in his life, his inability to be able to make those coherent decisions and things like that. And so I hope that's something that would be considered.
Yes. In fact, as the bill states, what will be included will be the role of the state, how funds will be expended, how things, just as you just mentioned, but really important, public transparency, that folks see and get to articulate some of those issues that make it more than a government task force, but one that speaks really to the heart of the community and those people, not only who need support, but those who are the caretakers very often, those in the family, and just also looking at ways that we may prosecute folks. I mean, we tend right now to wait until someone is dead or there's something that is massive that happens to the person.
Right.
But there are all sorts of things leading up to that. So hopefully that task force will take all of that into consideration as well.
Thank you.
Delegates Taylor and Conaway.
I'm struggling with whether to ask this question or not, because really it's been answered, but you did mention community agencies, different foundations that might be added than they've already asked. You know, and the reason why I brought it, I was going to bring it up, is because these seniors are very different now, and these perpetrators are using more creative tactics. And in our seniors, for instance, I am the last of the baby boomers, and next year every single baby boomer will be over 60 years old. So we are not suffering with Alzheimer's. We are not. I have a little dementia maybe, but not, you know. So, but my point is that I am even subject to these calls, and if I could be victim. So, isn't it so that we should potentially add to the list of the task force participants that we should have an organization maybe like Juanita C. Grant Foundation, who deals from the community level with seniors every day, at every age, and every income level as well? Isn't that so?
It is so. It is so. And when you look at the list, you will see people from every walk of life, every organization that's involved. And, okay, so I'm going to just step in to say I think senior housing should be included. I've watched one facility where they raised the rent, gave them 2 months' notice, raised the rent exponentially. And when I spoke to the person, his response was, well, there are plenty of places coming up. They'll be able to find another place. So they had 2 months to be able to do that. So you're absolutely correct. I don't think there are any limits, any boundaries to who should be on this task force.
We'll have to figure some process for that out. Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill, and panel for coming in. In reference to your last example, the housing situation, was that a senior citizens
Yes.
housing complex? Okay.
It was.
And the amendments that you're talking about, do you have those amendments that you'll have it before we vote on the bill?
Yes, I have.
All righty. And my last question, on page 1, lines 17 and 18, it talks about an abuse occurs every 5 seconds in Maryland, but this report is from 2015. Do you know if any current data is available?
I would imagine, yes, I'm sure there is. I don't have it. Do you have something else?
Well, even if it's not, that's a very, I was pointing out, is a very high number, and everyone should see that it says every 5 seconds in Maryland, an older adult is abused. Would you agree with that?
Yeah, and I think that your question is so important, and that number is important because it sounds large, but I think what it really speaks to is the breadth of what elder abuse really is. That it is not just taking something, slapping someone around. It's all of those things about which everyone has spoken. And just as an example, and this is elder abuse, I have a person that I know whose mother was always just a very classy lady. And this woman said that she went in to check on her mother, and when she looked at her mother in her bed, the bed was full of mouse droppings.
Thank you very much, Delegate.
So you see why that number is important.
All right. It looks like the end of the questions on the task force bill. There are no opponents. We do, however, have some favorable with amendments. I'm going to guess I know what they're going to ask for, an amendment, but they're here to tell us in person how bad they want this. Bob Enton and Joyce Lombardi.
Bob Enton is over in the Senate, but
He doesn't care that much then.
Well, he pulled me out to say that he wanted to make sure I said that.
Okay. All right, when you're ready.
Good afternoon, Joyce Lombardi. Chairman, members of the committee, I am one of the 9. So I represent Center for Hope. We have among our programs an elder justice program that applies national best practices and forensic interviews to elder justice. Yes, we wholeheartedly support this bill. We thank Delegate Pasteur, and yes, we would love to support it with very friendly amendments, and I will tell you why. What this bill does is it convenes the right people in a coordinated way to look at elder justice, and from the Child Advocacy Center, one thing that we have and do is it is a coordinated response to abuse. It's not because we know children, it's because we have a legal framework that's already codified in law, criminal procedure, and the family law. And that comes from 40 years of research and refinement around the country. Mandated reporting, definitions, how do you work with these social services? Again, it's not kids, it is a framework. It's linkage agreements, it's MOUs, something that we already know. Make sure the right people at the table. Second, it does it in a way that protects sensitive records and evidence, custodian of records. I had a lot of subpoenas, so that's something that's important. Also, the forensic interview. It's a gold standard of witness interviews. Without one, a victim has to provide multiple statements to adult protective services, law enforcement, medical, which can re-traumatize the victim and tarnish the court case if there is one. Many advocacy centers also provide forensic interviews to vulnerable adults. Some are on the leading edge of learning to interview older adults. You're not going to ask a 60-year-old the question that you would an 80-year-old, and yes, you can do a forensic interview with someone who has Alzheimer's or dementia. And we urge a favorable report. Thank you.
All right, doesn't look like any questions. That's going to end the hearing on House Bill 1191. We're going to move on to House Bill 753 from Delegate Kipke. This is the final 6 bills here.
Thank you, Mr. Chairman. In the interest of time, I'd like to ask a few people to come up on my panel.
You've got 2 people, does that sound right? Schellenberger and...
That sounds right.
Mr. Majewski. All right, whenever you're ready.
Thank you, Mr. Chairman. In Anne Arundel County, recently a 12-year-old boy brought to MacArthur Middle School on January 5th a firearm, a loaded magazine, and additional ammunition. Fortunately, because of a tip, it was confiscated by the SRO and the Anne Arundel County Police Department. They sort of harangued the legislature for excluding illegal possession of a firearm from the list of possible charges of minors under 13. Other law enforcement agencies throughout the state tagged on to the Anne Arundel County Police Department, giving a long list of concerns related to the enactment of this bill. Additionally, there was widespread public outrage in Anne Arundel County. If you're from Anne Arundel County, you heard a lot from parents about this. This includes people of all political beliefs, and they demanded that this bill be corrected this session. While this bill does not address all of the concerns raised by the community and others, it does one very important thing. In the list of crimes a juvenile may be charged with delinquency, it adds a crime involving the use or possession of a firearm as defined in the public safety article. In my testimony, which you should have in your laptop, I've included links to the news reports about the situation that I referenced in Anne Arundel County. Also, I've included a link to the Baltimore Banner report titled "Nearly 1 in 3 people shot in 2023 so far were 18 or under as violence flares near schools." I encourage the committee to read and consider this report, as it's very interesting, and as you deliberate this legislation. And Mr. Chairman and members, I urge you to report HB 753 favorably. Thank you.
Good evening, Mr. Vice Chairman and members of the committee. My name is Christopher Majewski. I'm a detective corporal currently assigned in a criminal investigations division, major case unit with the Harford County Sheriff's Office. I come here in front of this committee to speak favorably in regards to House Bill 753. Through my research during the first half of the previous school year, at least 426 students under the age of 18 across the nation brought a firearm to school. During the same period in the 2021 school year, 338 children were found with firearms on school grounds. Additionally, in December of 2022, located in North Carolina, a 12-year-old boy brought a gun to school. For reasons unknown at this point, the 12-year-old shot out a classroom window, causing it to shatter. When asked by the teacher who confiscated the gun why he did what he did, the child said, because I hate this school and everything in it. Currently, under Maryland law, we couldn't charge this boy with any crime. January 2023, as previously mentioned, I'll just kind of gloss over that. Again, the 12-year-old brought a loaded handgun to school. Thankfully, in that incident, there was no additional thing, and it was confiscated without incident. With this said, with the Maryland current law, this 12-year-old cannot be charged, held accountable, and law enforcement is not permitted to interview and investigate the incident to determine if there are any additional concerns or greater threats. These are just a few of the serious crimes that are being committed by juveniles with firearms under the age of 13, while not meeting the requirement of being a crime of violence as defined in Maryland Criminal Law, Article 14-101. Thankfully, in Harford County, we haven't had any instances of students bringing firearms on the school grounds, which I feel is a direct result of our strong officer resource program. House Bill 753 will allow for law enforcement to take action against this dangerous trend, allow for students to know that their learning environment is safe from fellow students possessing firearms. There needs to be mechanisms in place to ensure that we cannot keep our community safe. This will ensure that if early interventions or resources are not successful with the troubled youth, that there are consequences for the juveniles that continue to violate the law. The criminal justice system will ensure that the juvenile gets counseling, attends meetings, or has the proper resources to make better decisions. For this reason, I strongly encourage this committee to report favorable on House Bill 753. Thank you.
Good evening, Mr. Vice Chair. Thank you so much. Members of the committee. Scott Schellenberger, State's Attorney for Baltimore County, here in support of House Bill 753. In Maryland, currently, only those who are 13 to 17 of age are permitted to be charged in juvenile court. The legislature, in its wisdom, made an exception for those who commit crimes of violence. So if you commit a crime of violence, then even at the age of 10, 11, and 12, you may be charged in juvenile court. And as everyone Googled, young person charged with a gun offense, we found our person in Fort Meade who just this year, this is an article from January 6th, where he brought the gun to school, and right now, under the law, because of how old he is, we could do nothing about it. Only thing that could happen is the principal can punish him. And please remember, you know, I'm the one that's always up here saying, put him in adult court. I'm not asking for that. We're talking about juvenile court, confidential, nobody's going to know about it. But if you don't do that, if you don't bring the 10, 11, 12-year-old who has brought a gun to school, if you don't intervene in that young man or woman's life or get involved in that family through the juvenile court system, then you are looking at bigger problems when they're 16, 17. And so that's all we're asking is you already use the wisdom that if you commit a crime of violence, that you can be charged at the age of 10, 11, and 12 in juvenile court. Why not add handguns to that, particularly with this proliferation of guns that we're seeing and young people bringing them to court? We think this is a very logical extension. We're not trying to put them in jail. We're not trying to charge them as adults. All we're trying to do is get them in juvenile court so they can get some help. I urge a favorable report. Thank you so much.
Delegate Bartlett.
Thank you, Mr. Chair. And my question is directed directly to Mr. Schellenberger. I know we were just on the same side, but we're not on the same side now.
You'll turn around.
Or you will. No, okay. So here's my question. You said, why not add handguns to that list? A couple of questions. You said that, you know, we can get, you know, if we add them, if we add possession of a firearm here, they can get help that they need, et cetera, et cetera. So are you saying that there's no intervention under JRA currently? There are no programs? There's nothing available to a child now?
Well, what you would have to do is file a SINA petition, a child in need of assistance. And so theoretically, yes, you could go to the Department of Social Services, bring them involved, and say, this child needs assistance under a SINA petition. But that's not a lot different than going to juvenile court. because at least in my county, they go in front of the same masters.
Right, but you know, I'll tell you I respect your opinion. I do respect that, and I'm sorry to cut you off.
No, we're fine.
But I'm just going to ask you another question, and that is, actually, this question is for the bill sponsor, my fellow Anne Arundel County-ian. Did you receive what I received, and that was, when that incident happened at MacArthur, what I received were not parents who wanted this. What I received were parents who were very concerned about how did the child get the gun, and what are we doing about the parents. Did you receive that type of communication?
Well, we may have both heard what we wanted to hear, because I heard both. I heard both, and I think the problem with some approaches to this is it lacks real accountability. And without there being the ability to have an investigation with law enforcement, I think that's a failing on our part. I think that's dangerous. Without the ability to have a master hold someone accountable for treatment, bring in the parents, have an organized approach to counseling and treatment for the individual, figure out what's really going on there, I think it's weak. I think the way we have it set up right now is weak as it relates to firearms. I think it's very dangerous. I agree with what you're saying. I think that needs to happen. We need to find out how that kid got that firearm.
And we would pursue that. I mean, we would pursue both sides of it. No doubt.
Right, and you can pursue both sides of it currently without having, with JRA as it stands, you can still pursue the parent. You can still pursue the investigation as to how that child got that gun, right?
That is so.
That is so. Okay, just wanted to check. Thank you.
Delegate Carden.
Thank you, Mr. Chair. Real quick, I happen to be intrigued by this bill. I'm on the fence here, but Mr. Schellenberger, in the last 30 days, we've had 27 auto thefts just in the Pikesville precinct. And one of them, one example is that a group of 3 people stole a car from Queen Anne's. They were caught and then jumped out of the car, and it went across a 4-lane Reisterstown Road to the other side at 6 o'clock in the afternoon, and luckily did not hit anybody because they left the car. They ran away. They were caught. They were 11, 13, and 16. The question is, next year, do you come back and say we need to put auto theft in statute or not? And that's, I mean, I'm just wondering if we're going to start doing a laundry list, or is this a one-over?
Obviously, the 16-year-old, we have jurisdiction. The 14-year-old, we do. The 11-year-old, we don't. And, I just don't think, and I know you'll remember I say this when you see me next year, I just don't think stealing a car is the same as bringing a gun to school. I mean, that is a whole different level. So I do see a difference there. But you'll have to remind me when I come next year.
Okay.
All right, looks like that's it for the proponents' questions. We have a couple people signed up in opposition to the bill. We're going to bring them up. Marlon.
Thank you, Mr. Chairman. I have a meeting with my chairman for my committee. So not out of disrespect, but I don't want my chairman mad at me.
See you later. We have Marlon Tillman and Michael Gross. Whenever you're ready.
Good evening, delegates. Reverend Dr. Marlon Tillman. King David lamented to God, "How long, Lord, will you forget me forever? How long will you hide your face from me? How long must I wrestle with my thoughts and day after day have sorrow in my heart? How long will my enemies triumph over me?" In the last 2 years, it felt like Maryland lawmakers were listening to the citizens that the dehumanization of black people in a long history of Maryland's judicial racism was coming to an end. The Human Rights for Kids shared a study that this country violated more human rights violations against children than any other country, and that Maryland was one of the worst in America. I'm happy to say that when they conducted the study again in 2022, Maryland went from the worst state to the most improved state, and perhaps the best state in how we treat our children in the judicial system. And lawmakers that would entertain HB 753, which rolls back the clock on a progress that is yet to be revealed, is saying to the faith community that perhaps you weren't listening at all. It's time for the faith leaders to speak truth to power. And I want to say, if any of these bills if this bill leaves this committee, it's telling the citizens of Maryland that you've not given this law its time to be passed to heal this state. We've made this scientifically, theologically, and sociologically clear. HB 753 wants to reclassify children as adults so they can punish them like adults. They use terms like large, strong, and highly intelligent as triggers in your mind to justify treating children as adults. Don't believe the hype. Instead, trust the science and listen to the citizens who voted for you and vote against this bill. How long will the enemy of righteousness triumph over the most vulnerable population? Our children need care and not cages. I ask for that you vote unfavorably on this bill.
Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland and take cases around the state. And I'm here today testifying in opposition to HB 753, which proposes lowering the age of juvenile court jurisdiction for children, allowing them to be charged for mere possession of a handgun. When children come into contact with guns, we, the adults, are at fault. We have to ask ourselves, how did we fail this child? Those of us who are lawyers will remember the attractive nuisance doctrine from law school. If swimming pools and sand pits and construction sites are attractive nuisances for children, if we hold the adults liable for not taking the right precautions with those three things, shouldn't we do the same for guns? The Office of the Public Defender opposes this bill for three reasons. It is inefficient, it is unjust, and there are better options. This bill is inefficient if public safety is the concern. Research shows that children under the age of 13 are not likely to be competent. And the data is the same nationally, and the same is true in Maryland. If the goal is to get services for children who are found in dangerous situations with access to guns, delinquency is the least efficient way to do that, because the long and drawn-out competency process means that they're not likely to become competent in time for meaningful services, and they're not receiving services while they're incompetent. This bill is also unjust in that 11-year-olds don't know about laws. They don't know about their rights, and they don't understand the adversarial process of court. And they cannot make long-term decisions that are necessary for that court process. The third reason we oppose this bill is that there are better options if providing care and services are the actual goal of this bill. In situations like what was discussed in Anne Arundel County, or those that were discussed in other parts of the nation, we have other options in Maryland besides charging very young children who are still in elementary school, besides for putting them in handcuffs and crying in the back of a police car. Mr. Schellenberger said we could do nothing about it, but we can do something about it. We can refer them to the Department of Social Services, we can refer them to Maryland Department of Health, the local care team, SINS petitions, CPS, SINA. There are so many other options. We urge an unfavorable report and ask that this committee provide better care for our children.
There are questions for the panel. Delegate Bartlett.
Just a quick question. This is for Ms. Gross. Could you just go into what you mean by the competency process? I just want to make sure that I understand that as well as my colleagues.
Yes, so my written testimony went through this a little bit, but I will elaborate a little bit more. So what research has shown in studies about children and competency has shown us that very young children involved in the juvenile court system are unlikely to be competent to stand trial. What that means is that when you have a youth who is charged in juvenile court and they're 11, 12, or 10 years old, which could happen in this bill, with this bill, they are unlikely to understand what it means to go to court, understand the consequences of going to court. They're unlikely to be able to meaningfully assist their counsel in their defense. And so what happens is the attorneys must suggest incompetency. What happens when the attorney suggests incompetency is that the Maryland Department of Health does an evaluation. That process takes 45 days. Then we come to court for a competency hearing. If the child's found incompetent, the court can order, can either close the case or they can order competency attainment services. The competency attainment services aren't actual services like what we discuss in juvenile court. It's just lessons that the kids go through to see whether or not they can memorize terms like judge, prosecutor, defense attorney. And then we go through this whole process again. They get reevaluated after 90 days. We come back to court with that evaluation and see whether or not the child has attained competency. So all throughout that process, which can take months, until the child either attains competency or we get to a point where they're not going to attain competency, that child is receiving no services through the juvenile court system. Whereas if that same child who is 11, 12 was referred instead to the Department of Social Services, if that's appropriate, or to the Maryland Department of Health, if that's the appropriate referral, or to the local care team, which will take any referral, that child can receive services immediately. I know I've personally made referrals to the local care team, and they've reached out to my clients' parents within days. And they can provide so many of the same services that the Department of Juvenile Services could have provided, and more age-appropriate services, as opposed to waiting for that entire period of competency to see whether or not the 11, 12-year-old will actually ever become competent.
Further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 573. There she is. We're going to House Bill 698 with Delegate Shalega, Scott Schellenberger, Will Reiber, Sean Kennedy, please, up to the table. I think it's just Mr. Schellenberger. I don't see anybody else. All right, that's fine. Delegate Shalega.
Thank you, Mr. Chair, members of the Judiciary Committee. Don't worry, HGO is still in too, so you're not alone. For the record, my name is Delegate Kathy Shalega. I'm here today to present to you House Bill 698, Juvenile Law, Juvenile Court Jurisdiction, Age of Child. This is a very simple bill. Last year, the law was changed to move the age of a child that could be brought to juvenile court to 13. This puts it back to 11. You have a lot of testimony against this bill that is saying this will move a child to adult court, which it will not. So when a 12-year-old took a loaded handgun to school in Anne Arundel County, many were shocked, but they should be outraged when what happened next? Nothing. Along with that, which your last bill hearing brought that same situation up. Last November, a 12-year-old and a 14-year-old were arrested for a crime spree in Ocean City, including a series of robberies and armed carjackings. They were both referred to their parents. In August, a 12-year-old stabbed a gas station attendant to death in Clinton, Maryland. So that we know there are juveniles that are truly involved in some dangerous crimes. Unfortunately, one of our panelists, Will Reiber from Aberdeen, was not able to stay as late as this bill hearing. Recently in Aberdeen, there was a 12-year-old at a Valentine's Day dance at the middle school that had been allegedly physically assaulting girls at the dance, and the police came, but they could do nothing. Currently, the parents are outraged. There have been protests and all kinds of civil actions by parents and students who were just simply outraged that nothing could be done with this 12-year-old that was physically assaulting his classmates at school. And unfortunately, oftentimes the victims of juvenile crime are other juveniles. So I think this is a reasonable request to just move it back to 11 and let the kids get the services they need. Let them go to juvenile court. Let them, they and their families, get the services they need to know that antisocial behaviors are not going to be something that society is going to allow them to do. With that, I'll turn it over to my panelist, Scott Schellenberger.
Good evening. Scott Schellenberger, State's Attorney for Baltimore County. Well, Delegate Cardin, you didn't have to wait a year. So what this does, obviously, is it opens up the juvenile court for all crimes for 11 and 12-year-olds. When you combine the two of these, and that is House Bill 698 and 753, when you combine both of these, you have to look at the fact that we can bring the juvenile court to court for anything if they're 11 and up, but for the serious stuff, it's 10 and up. And I think those things combined certainly make a lot of sense. The thing that I need to reiterate, as I said before, is again, we're bringing them to juvenile court. We're not asking for adult court. Juvenile court, confidential. When you hit a certain age, it doesn't follow you even as an adult. You know, there are cases where I'll know a defendant, an adult defendant, has a juvenile record, and I'm not even allowed to bring it up with the judge and let them know that. So, again, we're trying to expand the services that we need. And everyone is correct. We can bring in DSS, and they can do something. We can bring in, you know, I guess the health department, and they can do something. But it's the juvenile court that is uniquely set up to deal with these type of cases. That's why they exist. So I think this is a reasonable approach, and these two bills together does expand the reach, but I don't think it's an unreasonable reach.
All right, questions for the panel. Delegate Conaway.
Thank you, Delegate and witness, for coming in. Mr. Schellenberger, what is it that the juvenile court is going to provide that the child wouldn't get? What kind of service is the juvenile court going to provide that the child couldn't get without going to juvenile court?
So if you, to continue the conversation we had during the last bill.
No, I want to just talk about this bill.
I understand. What I'm saying is, if you sought a child in need of assistance, a writ, then the Department of Social Services could offer you some of the same services that may be provided in juvenile court. I believe juvenile court can provide you more because they can put you on probation. Where a juvenile...
You as in the child?
As in the child, yes. They can put the child on probation, and therefore they can keep an eye on the child and their family to make sure...
So that's supervised probation now?
It would be, yes. That currently happens all the time. Juveniles are put on probation. And sometimes it's to get them, making sure they're getting mental health treatment. Sometimes, unfortunately, it's to make sure they get some kind of a drug treatment. But obviously in this case, it would be all the panoply of possible treatment options that would be available to the juvenile court, and the child and the family would understand the seriousness of the offense because they have to come to juvenile court.
So you think the family doesn't understand the seriousness of the offense? If the principal calls them and tells them that their child came to school with a weapon, is that what you're saying?
I'm thinking that there are some families who would take it very seriously and understand how serious it is. There are some families who may not. And what I'm saying is, when you go into a courtroom in front of a judge with a delinquency filing against you, it has a certain amount of impact on you, and I think it makes a difference.
Do you evaluate the educational level of the child?
Oh, yeah, you have to do all that.
So if you find out that the school may have failed the child, then what happens?
Well, I think you could then talk about getting tutors and people who can bring the child up to their education level that they're supposed to be at.
Okay, thank you.
All these things are dealt with in juvenile court all the time.
Thank you very much.
Delegate Young.
Thank you, Mr. Chair. Mr. Schellenberger, is it correct that you served on the Juvenile Justice Reform Council in 2021?
I did.
I was just reading the Department of Juvenile Services testimony, and they stated that it was unanimous that the minimum age would be 13. Does that align with your recollection?
That's not my recollection.
Right.
I remember there were a lot of votes that were 28-1. But, you know, the other thing is, now looking back on it, if I did vote that way, I don't necessarily think it was the right thing to do.
Understood. Thank you so much.
Are there further questions for the panel? We talk about, just for a moment, the SINS process, because as the Department of Juvenile Services said during the Juvenile Justice Reform Council, they repeatedly said that the SINS process would be an adequate solution for some of these kids who were younger than 13. They could go through that process and, if necessary, potentially go before a juvenile magistrate anyway. Is that the case in the SINS process?
I do remember them saying that. It's just my experience is that the SINS process is not as robust as juvenile court. I do concede that you can offer a lot of services in the SINS process, but in my experience in my county, I don't think we see as robust services offered in SINS as we do in the juvenile court. But I do remember them saying that. That is true.
So, but again, one of the other issues that came up was that in more serious cases for that group between 10 and 13 that did not rise to the level of being the 10 and above where they had truly committed some of the more serious crimes, but that this universe that you're talking about in the bill, is it in part because the Department of Juvenile Services doesn't really have the engagement in the SINS process that it needs to across the state, or what's been your experience in Baltimore County?
I don't think they have the engagement because they're not really brought into that case because it's a child in need of assistance. Usually DSS, Department of Social Services, is taking the lead on that, unlike in the delinquency case where Juvenile Services is taking the lead and can bring DSS in for assistance, or the health department.
So you don't believe that DJS really? Okay. So it's not just a problem that DSS doesn't have enough people. It's that DJS isn't really part of that process at all, even tangentially, as what was referred to in that.
I don't think they're certainly not nearly as robust as you would be if you were in the delinquency system.
Yeah, I do recall in the conversations that that those services were supposed to be there from all of those places, and I am beginning to wonder whether those services are nearly as robust or involved or available as was advertised.
I do believe that Juvenile Services is stretched pretty thin right now. I'll say something shocking. Please put as much money into the Department of Juvenile Services as possible. I absolutely would say that anywhere, because if you can help the 11, 12, and 13-year-old and their families when they're at those ages, then I won't see them when they're 17 and committing a carjacking. So I know I'm a little out of touch there with the topic, but
well, I'll just say I think that the Reform Council put the age where it did because it seemed to fit with what's going on literally in the rest of the industrialized world. So so to that point, that was, I think, why the council landed where it did. I am beginning to wonder about, again, those services, not only at the Department of Social Services, but also at DJS generally, that don't seem to be up to snuff right now. For that, I'm going to stop. Are there further questions for this panel?
Mr. Chair, I'd like to add that additional, what I've heard, the difference between the SINA and a juvenile going to court is that the judge has the authority to bring them back, where with the social worker, if the child and family don't accomplish the goals set before them, there's really little they can do. And coming back to court and requiring those services, I think, will bring a level of accountability that's missing. And Scott Schellenberger's absolutely right. Let's take care of these kids and get them to understand their antisocial behavior is not okay when they're young, so they're not back when they're 16 and 17. Thank you.
Further questions for the panel? Seeing none, thank you both very much.
Thank you very much.
We'll now hear from Marlon Tillman, Mikhail Gross, Evelyn Walker, Lucy Portera, Jenny Egan, all in opposition.
I'm going to reserve comments and just here to answer questions, Your Honor, if there, or Chairman, sorry. I'm in a habit.
Good evening, delegates. Reverend Dr. Marlon Tillman with Bridge Maryland Incorporated. My oral testimony is very similar to that which I just gave for 653. However, I would like to reiterate that 698 would roll back the clock on progress that is yet to be revealed. Therefore, I ask that you vote unfavorably on 698, with the reminder that just before the break, there was an orange army behind me in support of this bill being voted down unfavorably. They're here now with me in spirit. Thank you for my time.
Good evening, Mr. Chairman, Vice Chairman, and members of the committee. My name is Evelyn Walker, and I'm a juvenile defender with the Maryland Office of the Public Defender right here in Anne Arundel County. Every day, I have the privilege of working with children involved in the juvenile justice system. Last year, we made the right decision by passing the Juvenile Justice Reform Act and raising the age of juvenile court jurisdiction to 13. Taking a step backward would be a disservice to our state's children without having any practical effect when it comes to public safety or child welfare, and therefore, Maryland Office of the Public Defender strongly urges the committee to issue an unfavorable report on House Bill 698. As a public defender who exclusively works with children every day, I witness firsthand the damaging effects that involvement with the juvenile justice system can have on our state's young children. And although our juvenile court is designed to provide guidance, treatment, and rehabilitation, many children, especially very young children, are confused and frightened by the process and often wholly misunderstand why they're involved in court at all. I urge you to imagine yourself as a child, 11 years old, a fourth grader. Imagine the games you played or the friends you had and the trouble you may have gotten yourself into. Maybe you didn't get caught. Maybe you got a lecture from your parents. Maybe you didn't realize you were committing a crime at all. Maybe you got grounded. But now imagine, based on the trouble your 11-year-old self got into, the police were at your front door or in your classroom. You are handcuffed with handcuffs that barely fit over your small hands. You have to talk to lawyers, judges, have a trial, or be faced with the fear that you could be removed from your home and from the world that you know. That would likely be a terrifying experience for you that would stay with you for the rest of your life. And this is a reality that can happen to the children in our state. To revoke this provision of the JJRA is to revoke the rights of our young children in Maryland to simply be children. I believe that children under the age of 13 are deserving of being children, of making mistakes, of getting help from adults without the fear that comes along with prosecution, and we urge an unfavorable report. Thank you.
Good evening, Mr. Chairman, Vice Chairman, and members of the committee. My name is Lucy Portera. I'm Chief of the Juvenile Division with OPD here in Anne Arundel County. HB 698 ignores the founded research on adolescent development, ignores international human rights standards, and fails to address its damaging and disproportionate impact on Black children. It further doesn't address what's in the best interest of our young children or of the public. Therefore, the Maryland Office of the Public Defender strongly urges the committee to issue an unfavorable report. A police officer issuing a citation to an 11 or 12-year-old is simply not an effective means to intervene and provide services to that child. In my practice as a juvenile defender, I've seen citations issued for children of this age for throwing a fruit snack in school, damaging a mailbox, coloring on a jacket, or taking a bag of chips from the cafeteria. I was 11 once, and perhaps some of you were too. Perhaps some of these behaviors sound familiar to you because they're a normal part of childhood. When citations such as these were issued, we know that they almost never resulted in children being removed from their home. By and large, these cases never even made it to court. And when they did, DJS is extremely limited in what services and placements it has available to 11 and 12-year-olds. What would actually be effective is referring children to the robustly available world of community-based resources outside of the juvenile system, but most importantly, immediately. Right at the moment of a behavior that rises to the level of concerns, a child can be referred to the Department of Social Services, local care teams. They have access to free clinics for educational resources in the school setting. They can be referred to the SINS process. They can be a child in need of assistance. An emergency petition can be filed to get the Maryland Department of Health involved. These services are available without having to expose a child to the court process that they demonstrably do not understand at that age. We need to treat 11 and 12-year-old children as exactly what they are, which is kids. We strongly urge an unfavorable report. Thank you.
Questions for the panel? Seeing none, we thank you very much. Oh, I'm sorry, Delegate Bartlett.
That's okay. The last person who testified, you got me. I wasn't going to ask the question, but you said something that's important, and that is, you all said something important. Don't get me wrong. Oops.
It's a long day.
So you said, let kids be kids. I think that's what you said, or these are children. I want to know, I don't know if anyone said it yet, but can you touch a little bit into what happens, or anyone on the panel, when you are 11 years old and you start and you get in the system and you go before a judge, and just tell me what your experience has been with life before we pass JRA.
In my experience practicing in this county for 10 years and representing what I will say is a very small percentage of my clients were 11 or 12 years old because of this very reason. The cases generally do not make their way to court. But when they did, I can think of maybe a singular case in which I did not raise competency. Because of adolescent development, because of the brains of a 10, 11, 12-year-old, they simply don't possess the capacity to understand legal proceedings. And this has been demonstrated in virtually all of our cases. These cases are oftentimes resulting in lengthy competency proceedings. During that period of time, the cases stayed. And as was referenced earlier, attainment services provided through the Maryland Department of Health don't provide meaningful intervention services, which would...
I want to know, what is life like 10 years later, 5 years later, or whatever, once you start in the system? That's what I want. And before, we had this bill that we passed just last year.
Yeah, so the data that we looked at on the Juvenile Justice Reform Council that met for more than 2.5 years went through what happened on probation. And before the law, we had 9, 10, 11-year-olds on probation. The thing is that a 9, 10, and 11-year-old don't really understand the standard probation conditions listed in a court order, nor can they comply with most of the requirements. So the requirement will say that you have to go to any services ordered by your probation officer. Most 9, 10, and 11-year-olds cannot transport themselves to appointments. They cannot get there on their own. And so what we saw with young people who were 10 and 11 years old, the very, very few who ended up under supervision by DJS, because most of those cases are dismissed, and most kids go through the trauma of arrest and court without ever being put on probation or committed, because of how minor their offenses are, how young they are, how not competent they are. But those who did were often drawn very deep into the system very quickly because they could not comport their behavior, and they cannot meet the requirements that even a 13-year-old, or especially a 15 or 16-year-old, are more able to do. But also remember, this is a time of identity formation. And when you take a 10, 11, or 12-year-old child and put them at a table and say, we are going to treat you like the criminals, like a criminal, like someone you see on a court show on TV, that affects how children think about themselves, their own possibilities, and their own futures. It is an extremely damaging thing for a child to come through. And what we know is that a single school-based arrest doubles the probability of dropout, and a single juvenile court appearance quadruples the risk of dropouts, school dropout for children.
Thank you, Mr. Chair. Thanks for being here, y'all. So I hear what you're saying about the victimhood of the perpetrators, but I'm wondering what's going to be done for the people that are the victims of their actual crimes?
So I understand some of the committee's worry and critique. And I think what we need to remember is that when you do something, and when systems especially do something the same way over and over again, you get into ruts, right? Where people only know how to deal with a problem one way. And that is what we're dealing with after 30 years of a mass incarceration movement that everyone says, we don't know how to refer kids to local care teams. Some of the local care teams had stopped meeting in the last 5 years prior to the law going into place. And what we see is that when you rely overly on arrest and punishment, especially for children, the overall support structures that otherwise we would be building up and relying on wither, right? And so that's why we want to give this law time. One, to build up those support systems so that there are supports for people who are harmed, right? Children harm people in accidents all the time. Children harm people in ways that are not criminal intent. And we want support systems, and we want those local care teams, and we want victims' funds. All of those things are accessible for anyone who suffers harm. The answer is just, how do you correct the behavior, and how do you make sure it doesn't happen again? And when you put a 10-year-old in a prison cell or on probation, we know that it makes the future outcomes and their future recidivism worse, not better. And so I want to make sure that we get them treated quickly with direct interventions, and that's not possible when there's a threat of incarceration, right? And whenever there's an arrest, there's a threat of incarceration, and that creates due process rights that delay meeting the needs both of the victims and children who found themselves in bad circumstances or in really horrible, committing really horrible mistakes, which happens.
Yeah, I still don't see exactly how the victims feel like they're getting any justice, but I appreciate your answer.
Well, and if I could also add, one of the other things is that when and most of the time, like we said, we're raising competency in these cases, that also affects victims as well, because these victims now, they think that they're going to be able to go into court and have, be heard, and they're waiting months and even years to be heard, and then often the cases are being thrown out because the child is not going to be found competent. So the outcomes are generally speaking the same for these victims because of the fact that cases are either being dismissed, they're going through competency, they're waiting, or say, for example, a child has to pay restitution. An 11-year-old, generally speaking, does not have the funds to pay restitution. So I don't think the outcomes are that different for victims, and that's why I think Ms. Egan is correct in saying we need to be focusing on other mechanisms to help victims.
I also want to point out that we work with complaining witnesses all the time with very young children who are very concerned for them, right? Very concerned when a 9-year-old shows up with a handgun, very concerned with an 11-year-old who may not have the proper supervision. But I work with complaining witnesses and communities all the time that don't seek out help and don't refer those children for help exactly because they are worried that they will be pulled into the delinquency system, and that is not what they want to see happen to those children. They understand that this system can do harm, especially to very young children who can't fully comprehend and are not competent to understand why they are there.
Yeah, I totally hear you. I think the suggestion, though, that we, refer them to SENA or to social services, that's also incredibly destructive to the family, and so I just don't know if that's the right answer here. Having a mother or father look at potentially losing custody of their child instead of the child standing in front of a judge and being found incompetent to stand trial, I'm not sure which one of those is really better. And I really kind of feel like the latter one is actually less damaging than having a lengthy social services investigation that could potentially rip the child out of their family.
Yes, I think that there are stages to child interventions and SINA petitions, right? Like there are ways to do family preservation and to deliver services to families to help support them and keep them together. We would obviously support and hope that that's the best thing because we know that's the best thing for kids.
Yeah, unfortunately, each jurisdiction and each state really treats that differently. So there's not a lot of equity happening, unfortunately.
Agreed.
Thank you, Chairman. This question's for the same, I can't remember your name on the end there.
Oh, I'm Miss Egan.
Okay, thank you, yes. There was a phrase you used, the threat of incarceration. So can you kind of expand on that? So you don't believe that the threat of incarceration works?
Especially the research shows very much that the deterrent effect doesn't impact children because they're not aware of the world, right? The deterrent effect of punishments or the threat of a punishment in the law doesn't have the same effect on an 11-year-old because most 11-year-olds don't know the difference between what is bad and wrong and can get me in trouble at home and what is a law and what is breaking a law.
So are you familiar with, or any of you with drug courts?
Generally, yes.
So I think the general idea there is kind of the threat of incarceration with these folks. I mean, they're going through this this drug treatment court to basically avoid, if they can check all the boxes and get through the program to avoid.
Yes.
And generally, I believe this court, the drug court works pretty well. At least I know back in my jurisdiction.
They tend to be adults who have had 8th grade civics, where children under the age of 13 have not.
All right. Thank you.
Thank you, Chair. I think it's interesting that we use the statistics that we have on future issues that arise when people are put into the juvenile system, right? We know what they do in the future, or recidivism, all the things. We've heard testimony today for hours about victims. And what these bills look at is the victim that we don't have the statistics for. Somebody brings a handgun to school, somebody commits a crime. What happens 50 years down the road when that person comes out and says, I have this or I have that? I mean, that's really what we're looking at here, because we can look at the statistics that we have for the people that you represent, but we can't look at the victim statistics, and that's my concern. So how do we handle a situation?
So the majority of children and serious offenses with victims and person crimes can still be charged under this law. They're asking to raise the age, and the majority of those cases were for misdemeanors, non-person misdemeanors. The number one charge against children under the age of 13 is theft under $1,000. The second is malicious destruction. That's who they're asking to go back to arresting.
Thank you.
What about malicious burning? What about animal abuse? Can they be charged and sent to juvenile court, either one of those two?
I don't think either of those can. And both of those, just so you know, under the literature, are usually signs of, especially for children under the age of 13, that they are experiencing abuse.
Okay.
Sexual abuse specifically. Thank you, Delegate Simpson.
Are there other questions? Delegate Kaufman?
Just very briefly, Mr. Chair, following up on Delegate Erican's question, are you guys familiar with the concept of restorative justice?
Very.
Okay, and for the benefit of the committee, could you explain what that is? Because I think Delegate Erican is right, that there needs to be consequences and we need to consider the victims too, but in my county, restorative justice is used very frequently, and I think it does assess consequences and compensate victims. So could you explain what it is and how it works?
Can you? Yeah.
So there's a lot of different concepts of restorative justice, but restorative justice in general is the overall idea that when harm is caused, the people who are impacted by that can get together and discuss the causes and the harm that was caused and come up with a mutually agreed upon way to address that harm. There are lots of different permutations of that we see in the law. But I believe your question is whether or not that might be more appropriate. I do think it would be more appropriate, and it is one of those referrals and systems that is available through a local care team. I know personally the local care team in Baltimore City works with Restorative Response Baltimore, who often does community conferences and restorative circles with young people and neighbors or people who are in conflict with very young children and young families, even when they haven't been brought into the juvenile justice system, and it is incredibly successful. The statistics from an organization like RRB show that they are more likely to have victims say that they were satisfied by the process, more likely to get and pay restitution, and more likely for the person who caused harm to feel like they got a fair shake.
Yes, I think that's right. And just for the benefit of the committee, one example that I've heard of before is if a kid splatters paint all over the walls, they have to work with the custodian at a school to clean the walls so they get a real sense of the consequences of their action. Thank you, Mr. Chair.
Are there further questions for the panel? Seeing none, thank you all very much. That concludes the testimony for House Bill 698. We're going to go now to House Bill 762. Delegate Cardin, who's on his way up to the front. Who do you want with you?
I want, where's my panel? Did they leave? My panel is left me.
Barbara Mercado, you here? I feel like that was one.
She's going last, though, right? Yes. Okay. Mr. Chair, maybe I'll start. My panel will come.
Well, there's some people walking in. Tell me who you'd like.
We have Dr. Pat Savage, Dr. Stephanie Wolf, Dr. Stephanie Larte. And then we have a few others.
Let's see, Ms. Mercado. Okay, we'll start with that, and then we'll do another panel, and there are some people testifying in favor virtually, and we'll start to bring them in. All right, go ahead. Delegate Cardin.
Thank you very much, Mr. Chair. Members of the committee, for the record, John Cardin on behalf of House Bill 762. I got it right tonight. And asking for your favorable consideration of this. Child Advocacy Centers are an essential part of the spectrum of care for children victims of abuse. They are essential to make sure that these vulnerable children are treated properly, and we work with them, these very, very vulnerable populations, carefully. These are children who can oftentimes be suicidal, can be swept into substance abuse or other issues because of the abuse that they had received. They are also oftentimes referred, or almost not exclusively, but oftentimes referred by the counties or the state to these child advocacy centers. There needs to be stability and consistency in the attention and the provision of health care to these children. This bill basically requires a certain amount of oversight and regulation of these child advocacy centers to make sure that the children are being treated correctly. You will hear about a situation that happened in Montgomery County where some children were harmed. That is the impetus of the bill. In fact, if you look at all the testimony, much of it unfavorable, it all points to the same issue, which is what we are asking for is within the area of professional responsibility and should be done by all these centers. By the way, these centers are wonderful, and they're here. There's many representatives who are going to be here and testify. I think they're fantastic, and they all do a great job. We just want to make sure that they continue to do this great job. CACs are, in fact, agents of the state, and they should be regulated by the state. In fact, all other organizations that provide health care to individuals in the state are, in fact, regulated. So I don't see why this should be an onerous requirement. All the opponents, nearly without exception, either agree with the idea that there should be notice given to these young people or their parents. But they say this is the wrong way to do it. They say this is the wrong area of the code. And I am not tied to this specific area of the code. I'm just saying that we need to make sure that we are treating these children the way they need to be treated and that they are protected. I ask for your favorable report.
Good evening. I am Dr. Pat Savage, a licensed psychologist in Maryland who has served children and their families for almost 40 years in Montgomery County. I also serve as chair of the Maryland Psychological Association's Legislative Committee. Today I am testifying in strong support of HB 762 on behalf of the Maryland Psychological Association, which represents over 1,000 doctoral level psychologists living and working throughout the state of Maryland. You also have a copy of the association's written testimony on file. HB 762's intent is simple: to protect one of the most vulnerable populations of Marylanders, traumatized kids and their families, and the providers who treat them. It is a simple ask to provide guardrails consistent with the standards of care and ethical principles of people like myself who provide mental health services to the public. The ask is designed to fill a hole that was brought to our attention by an MPA member who experienced firsthand the harm that can occur to kids, families, and therapists when the procedures outlined in the bill are ignored, not followed, or simply not present, period. The opposition claims the following: that our goal is somehow to impugn or tarnish the good work that CACs do to support these vulnerable kids and their families, that no children or families were harmed by the situation in Montgomery County, that these protections already exist throughout other processes or via other oversight organizations. These protestations are not consistent with what we know, the experience, and you will hear from other witnesses on this panel the extent to which those therapists who were involved attempted to reach out to others in the community to prevent harm to the children, families, and themselves in this particular situation and have had no success to date. They will also say that there is no need for the provisions outlined in the bill because what happened is a one-off occurrence. If this is true, why was there no response from several of the agencies who have testified and our own licensing boards that there was nothing that could be done? I'll close by saying that we would invite you to work with us to protect these vulnerable kids and families from this kind of event ever happening again. And if you have any questions at some point, I'm glad to answer them. Thank you for your time.
Good evening. Thank you for the opportunity to speak today. My name is Dr. Stephanie Wolf, and I'm a child trauma psychologist here in Maryland. I'm also the vice chair of the Maryland Psychological Association Legislative Committee, and I'm here to testify with strong support for HB 762. I love CACs. I worked at a child advocacy center for many years in the past. Child advocacy centers are wonderful places. The child advocacy centers provide integrated care to the most vulnerable of children. However, no system is perfect, including the CACs. Through an incident in which over 41 children lost their mental health providers and had insufficient continuity of care, this is how we learned about this gaping hole. Sometimes the people within the system have the hardest time seeing the problems. Children were harmed. Many children and families were harmed from the lack of legal requirements codifying procedures for a sudden loss of a therapist. Those children had been abused by parents, people they love, and people they trusted. They had finally found a safe haven in a child advocacy center. The therapist and the abused child have an extra sacred bond, and this bond instills hope and healing. And in the best of situations, a child will finish treatment and say goodbye to their therapist. However, in the situation that occurred, these children lost their therapist suddenly. The opponents of the bill have pointed to the OIG report as finding that no children were harmed. However, the OIG only spoke to the management of the CAC, who were the ones responsible for the actions. The OIG did not speak to the therapist, did not verify through the record systems how many kids were in treatment, and did not talk to any of the families impacted. I am here to shout as loudly as possible that children were harmed and are still at risk. This bill aims to codify best practices for a sudden departure of a therapist. This bill is not an onerous task. It merely codifies the standards for quality of care that all should be following, and we ask for your support.
Hi, my name is Dr. Stephanie Olarte, and I'm a licensed psychologist in Silver Spring, and I'm also the chair of the Child and Family Subcommittee for the MPA Legislative Committee. And I just want to thank everybody for giving me the opportunity to discuss my impressions of this bill, which is a privilege that I get because I get to control my own schedule, and that's not a privilege afforded to a lot of people who would have liked to tell their story today. Some parties who oppose this bill are suggesting that children were not harmed as a result of the actions that we're trying to prevent with this bill. My most polite response to this is to say that I find it alarming for any mental health provider to assume that no psychological damage would occur if a child were to lose their therapist suddenly. This is why we have ethical codes to guide the termination process. But more specifically, I have a personal story about the resulting harm
of a child and their caregivers. Years ago, I was asked by a friend about the ethical codes that psychologists abide by as it relates to the termination of psychotherapy. Their child was receiving services at a child advocacy center. They were asking me this because their child's therapist had been terminated and their child never had a chance to say goodbye. In short, a child with a significant history of attachment trauma lost their therapist suddenly. Their caregivers received little to no support as the child suffered this sudden loss. Their caregivers' attempts to raise concerns about the psychological damage this would further inflict was met with deeply concerning efforts to silence them, to the point where they are afraid to come forward and share their story publicly. And I just want to thank them for giving me permission to do it on their behalf. Thank you.
Mr. Chairman, members of the committee, I'm Barbara Brocato, and I'm here on behalf of the Maryland Psychological Association and in support of House Bill 762. I kind of want to speak to the testimony that this committee's heard today and the fact that no matter how well-intentioned a program is, no system is perfect. And to say that the children and families being served in these child advocacy centers are in the public system. These entities are agents in the public system and receive public funds. Therefore, this bill, as introduced, and as we saw it, was a modest initiative requiring notification and some due process so that these families and children would not be abandoned and not know why or where to go. The opposition, the strong opposition that has emerged has really surprised us. Opposition that's been generated by the child advocacy centers, and they're here and others. We thought this was a simple guardrail. We've heard the bill's redundant, unfairly singles them out, doesn't meet the purpose of protecting children. I mean, we disagree with those statements. If this bill is not perfect, please work with us to fix it. These children and families deserve that. Thank you.
Questions for the panel, Delegate Pester.
Thank you, Mr. Chair. Excuse me. Thank you for coming with this clearly and looking at it, since my name is on there. I was certainly taken by what it is to do, and considering what I think is a dearth of places to support our children, having facilities in a variety of places to do that, especially those who are emotionally, psychologically very vulnerable and traumatized, if you will. Someone used that word, and I thought it was a good one. But going back and looking at it, and I still believe in it, but I just would like an answer to the section that talks about the 48-hour notice, being able to just remove a child, and doing that in that way so that the language says so they don't want the child endangered, and that was the word that was used. So my question is, under what circumstances would you take a child who's already traumatized, who's there because he or she has some emotional problems, and you want to be able to have them in a words used, stable and consistent environment. But now we have 48 hours and might be moving them out, showing where they were, where they're going, names and all of that. What are some of the circumstances under which that would happen?
The 48-hour requirement, it was meant to be a notification, right? So it's notifying, and the reason for 48 hours is because there's 48 hours when there is an abuse report, and these children involved often are suicidal, and if you have a child that has suicidality, then giving them notice as soon as possible and making arrangements for the transfer of care would be really crucial to keep them safe. However, we're not wedded to 48 hours. That's, that was a suggestion. That's what we, put in the bill, but that's open to discussion, right? If that is too onerous for whatever reason, that could be something that could be talked about and adjusted. Again, the goal here is to protect kids and to be able to give kids notice and keep them safe.
So if I may ask another question to that. So I'm hoping would you be looking at the child and the individual children and understanding that for however long that child's been there may have been some attachments made. So there may be some other things that you need to do before you give that notice. But other folks might not need that. So talk about, if you will, what goes into making the decision in terms of how long or what kind of notice is being given?
Absolutely. I mean, that talks about, quality continuity of care. And so, right. Our ethical, as psychologists, as other mental health professionals, we have a duty to think through all of those things. And so there's a provision in there that talks about, if it would not be in that child's best interest. I don't think that's the exact language, but something to that effect. And so I think part of that, what you're talking about, is that would be part of the equation, right? If there was a circumstance, each child, there isn't a one-size-fits-all model of how exactly to do quality continuity of care, but roughly we know the sooner that we can let patients know that there has been an abrupt termination, and the sooner that they have the ability to understand, to say goodbye, and then to be part of the decision making as far as what happens, right? They don't have to go back to the provider that left, but having the option to discuss and to say goodbye, given, especially for this population, they're so vulnerable, having been abused, most of the time by adults, sometimes not. They put a lot of trust, and that therapeutic relationship is that much more important for these kids. It's important to anybody, and anybody, on this committee and, in this room who's had a therapist. Imagine if your therapist just disappeared. And that is that much more painful for a child that has already experienced abuse and maybe abandonment by a parent, a caregiver. And so that's a precious relationship, and that's why we've come forward with this bill.
So in terms of, and I understand it in terms of the verbiage, can you just make that a little clearer? I've read this bill over and over, and you said it so much better than I was reading it in the bill.
Absolutely.
Thank you.
All right, Delegate Simpson.
For clarification, so from being in Child Protective Services, my understanding of the Child Advocacy Center, you have the Child Protective Services, you have the police, and sometimes you have the physician, doctor, and then you have some victim advocates that usually, or court, that help them through the court process. Are you talking about each one of these folks because some of them, are not going to have an ongoing relationship with, like, the doctor and things. I don't know that that's quite, this isn't a place they're going to stay. It's not, the child care center is specifically for that, like sexual abuse or some other, to bring those professionals together.
Sure. So they do stay some, right, depending on the center. Some centers do have within-house mental health providers. Also, sometimes it's one visit with a pediatrician, child abuse expert. Other times there's follow-up visits. All of the child advocacy centers, even if they don't have that in-house mental health services, they have the linkage agreements. If you are going to be a child advocacy center that is accredited, you're required to have linkage agreements with mental health provider centers to provide that support. And part of those linkage agreements is putting these requirements in, right? Putting requirements of having trauma-focused, specific evidence-based treatments, ways that you're assessing. And so it would be very easy if a center itself it wasn't providing that direct care as you're talking about, it would be very easy to then put it in those linkage agreements, ensure that they're there, and just like they're ensuring that those partners are doing the trauma-focused therapy, they would also be ensuring that this piece of the continuity of care would also happen.
Could I add to that?
Yeah, I was going to say, can you give me a little bit more specific? Because I see the 48 hours, and I understand child welfare, and you're trying to get out there when 24 hours for the, for abuse and for neglect. You have the 5 days. And I'm looking at this, and I see the 48 hours, and I'm kind of wondering where this continuity of care, or is there something specific that you're speaking?
Sure. Yeah.
Of? Because I'm sorry, I'm just a little bit missing it.
Totally. Yeah, I appreciate the question. The 48 hours is to be told, hey, your provider's no longer here, and here's the plan.
Which provider?
To have
That's what I'm
someone
asking.
handle.
There's these various different roles at the Advocacy Center. So when you say provider, what do you mean?
That's what I wanted to address.
Okay.
If you actually look at the bill, we're not talking about multiple other providers, with the exception of other healthcare providers. And in conversation with the CACs that we had prior to this hearing, we actually made the offer that if the healthcare providers, the medical providers, felt like this was too burdensome, we were willing to amend that out of the bill and only apply it to the behavioral mental health providers, because those are the folks that tend to have the more consistent relationships,
So
develop
the victim advocates, is that what we're,
No.
we're talking, okay.
They're therapists, counselors, whatever term would be used.
You're not the victim advocates. Yes, it would be any mental health provider.
And how long do they typically provide services to a child?
The mental health providers? Typically, in my experience at the CAC, it would be 6 months to a year, sometimes 2 years, depending on the severity and depending on the type of treatment that was being provided.
So would you put something in here to make it clear, like, because you're making an appointment and a next appointment, so 48 hours if you, right? If you had it, wouldn't it be until next week or something like that?
So some of the kids are in crisis and have crisis, especially when we get into the trauma work. And so the average would be every week, but definitely for some of the kids, we need to see them twice a week. We also, often will get calls and be contacted because there's been a deterioration in functioning. Perhaps they, had to have contact with their perpetrator. Perhaps, different circumstances change. And so the level of availability is higher. And so taking into account the intense symptoms that most of these kids have is why having the sooner that they can have the notification, the sooner that there can be a safety plan and account for those pieces. A lot of these kids have court dates. A lot of these kids have just things that pop up that are extraordinarily traumatic, even above and beyond just the therapy, and then they need that help and support.
Delegate Simpson, and just to kind of step off the dance floor and back onto the balcony for 1 second, this is about these children are getting mental health services. All we're asking is that if a provider is fired or let go or leaves for some reason, that the child who's receiving services finds out as quickly as possible that this person's not going to be there. So when you call for help and you're expecting this person and you've been talking to this person for a year and you feel comfortable, this is the one person you can call to get help, to get an understanding of how to, some of the trauma that we were talking about just a few hours ago. And these people could be like, they are not going to identify this problem for 40 years, and they're not going to be able to talk about it to anybody, but maybe their psychologist or their social worker, whoever this person is, and all of a sudden they call, oh, that person's not here, sorry, and they haven't come up with a plan to figure out how they're going to deal with this, and you know that this person is very volatile. I mean, thank God I have never had to deal with this personally, but I can only imagine. You saw how I broke down just listening to these people. Can you imagine if you called me to come up to your appointment, and they're like, oh yeah, we fired those people, and you're going to get somebody else. We'll figure it out in a couple weeks. Now, I'm not saying that these people do that. And these people are
But we
fabulous
actually,
and wonderful.
we had patients that showed up to Zoom rooms and their therapist didn't show. They were literally waiting and waiting. And we found out after the fact, and you will hear from other witnesses who will tell you of patients that reached out to them in the community, found them somehow, and told them about that experience. So we kind of laughed that would never happen. It did happen. They were expecting to see their therapist, and they waited and waited, and their therapist didn't show.
So we just want to make sure, and we want to do it in a way that is not onerous. We're not looking to create, we just want to figure out a way to do this. This is what we came up with, and we're hoping that with the committee's will and interest, we can figure out a way to do this.
All right, Delegate Simpson stole a little bit of my thunder. It's okay, Delegate Simpson. But just to kind of, as a follow-up, so you mentioned the 48 hours is simply merely a notice thing, I guess, because initially I was thinking, okay, within 48 hours they have to get a whole new therapist. And so my question becomes, if it's just a notice, then you were speaking about kind of the continuity of care and the concern about maintaining that continuity of care. And so, and maybe I guess I want to see more, maybe a little bit more specificity about, okay, we're giving them the 48 hours notice that, hey, you know, therapist Jane Doe is no longer here. And then what's that next step? I think that's kind of one, the missing piece. Two, the other thing, I guess my worry is that, but you kind of answered it as just a notice, because my worry initially was, oh, they have to get a new therapist within 48 hours. And we already know we have such a shortage right now of medical providers across the board, especially therapists, and especially if you're in a community of color and you wish to have a therapist that looks like you, there are even lesser of those available. And so I guess that was one of my questions. What is the process after that point, number one? And then I think my second question was with regards to some of the whistleblower protections, because that's also a conversation Delegate Cardin knows that we've been having throughout this committee on a variety of other bills. How is that played out with what we currently have under existing law? Because it seems like it may conflict a little. So anyway, those were my only questions.
If I could try and answer the first part of your question, which is the more specificity, there is a section in the bill that actually talks about permitting the therapist, unless there is some reason that it would be believed by the administrative folks at the CAC that therapist could represent some harm to the child by interacting with them. And
about the termination of the exit section.
Is being able to meet with their therapist, have some closure on that relationship, and then have that therapist help make the transfer to another therapist that would be assigned, I guess, by the CAC or provided by the CAC or the group that has the linkage agreement.
And what will be the time frame with that? Because the other thing you had testified is that some of these individuals have court dates coming up, those types of things.
Yeah, I mean, I think that, you know, best practices are that, you know, there would either, if that therapist that had been fired or, you know, left was not available to kind of be that link, then just like in any other practice setting, you know, we have other therapists temporarily step in and say, hey, you know, I'm kind of having a warm handoff with your past therapist. We're working on getting you the perfect person. And in the meantime, I'm here to support you. And, you know, it's not perfect, but at least they know and they're part of the conversation and they're not confused and they don't think that it's something they did and they still have that support.
In terms of the whistleblower, I don't know if anybody else wants to chime in, but I mean, we are just trying to include these individuals into the whistleblower statute. I'm not sure that, I think that is less controversial with the opponents, and we can, I mean, if there is a conflict in laws,
I saw that as a concern, and I'm just trying to figure out where, in some of the testimony, that written testimony that was submitted.
Well,
Okay.
I'll reach out to you, and we'll figure out if we can work that out.
Okay, all right, thank you.
I can just say one thing about that, and that's just that, through this experience, one of the things that kept coming up for, all of the therapists involved was, is there whistleblower protection? And one of the things, separate from this, which is just kind of how it impacted the therapist, that kind of thing, which is really not why we're here. But what we noticed was that there was a lot of questions if there was whistleblower protection, and there was actually a fight about there being whistleblower protections in court. And so that kind of suggested a need to be really clear so that there doesn't have to be a fight, that everybody is just on notice, hey, if you work in a CAC and you're going to be reporting that things are not great, you have protection, and the people that work, everybody knows. But again, as Delegate Cardin stated, it's secondary to us. It was just an additional piece. The reason that we're here is to make sure that kids are never harmed in this way again.
All right, last one.
Okay. So I'm a 30-year state employee, so I totally understand the whistleblower. I have no issue. It's the number 2 is so unprecedented to give that previous provider, someone who's done sexual abuse, and been a child welfare. I mean, sometimes when you're letting somebody go, we just heard a little while ago, are you letting go the priest, kind of who abused the kid? And are you giving, and I see it has that, but that can, the health and safety and welfare of a child, that just can get messy because you're tying up personnel. That is really professionally unprecedented, number 2, to have that closure and that follow-up.
Well, this is
The previous provider, so, especially because you keep saying fired, so that's kind of threw me, but to have a previous provider who is working for the state to contact or have that ability is extremely unprecedented.
I'll let Dr. Wolf talk about it, but there is specific language that says that if there's any question about it's inappropriate for endangering the person, that they will not be permitted to do it. However, for the most part, they're not leaving because they're incompetent. They're leaving for another reason, and that's the issue. It's not because they were doing a bad job or they were somehow harming the individual.
I know. It's very unprecedented to have that. It's like, I get that you would definitely want to make sure they knew who their new provider is and who they're going to contact and have that as quickly as possible. And I've seen that, or you have, I'm trying to think, like transitional care, where you're making sure that even if it would be before, that's not uncommon.
Right. Well, I think it's less unprecedented. I mean, I've seen this happen. I think it depends on why a person is left, but I think that it definitely I've seen happen in various workplaces that if somebody has to suddenly leave, whether it's just not a good fit, they're overwhelmed, there's often always a discussion of, are they in a place where they can say goodbye to patients and they can have these closure sessions? So it doesn't feel,
while they're still working.
Well, yes, no, as they're walking out the door, right? So I've had conversations as a supervisor with, in past employment with therapists that may be leaving and saying, like, hey, I know this isn't a good fit, are you comfortable? And we kind of have to have a discussion to say goodbye and to do that continuity of care. And oftentimes they are, right? Oftentimes people are able to separate, and that's where, that piece of, is it going to be a harm? Is there a safety risk, right? We have a catch-all there, but, all things being equal, it is always in the best interest, unless it's going to, if there's something about that therapist that, and about the way they were giving therapy, to allow that child to be able to say goodbye. The kids that are seen for trauma therapy, even when we graduate kids, right? Even when they are doing phenomenally well and they've improved, we have to talk about leaving for months, and they have a hard time. And at the end, they often are crying and don't want to go. And so that is so hard for them. And so imagine that child when all of a sudden, midway through treatment, their therapist just disappears. And so we're just trying to help that and correct that so that no kids are harmed in this way again.
All right, I think we got to move on, but your point is taken. There's a difference of opinion on whether this is a precedented or unprecedented move here, requested here. Thank you, folks. We do have a few more folks signed up favorable and a half dozen people signed up unfavorable. Let's see if we have any more of the in-person favorables here. Daniel Shattuck and Renee DeBoard. So we'll take these two along with, I think we have 3 online favorables. So let's start with the 2 in person, whoever would like to go first.
I'll go first. My name is Renee DeBoard Lucas, and I'm a psychologist specializing in work with children and teens impacted by trauma. I previously worked at a CAC and had the privilege of supporting families in the aftermath of physical and sexual abuse. I believe strongly in CACs and their mission's focus on reducing and preventing childhood trauma. I'm here to speak in favor of House Bill 762. This bill closes an important loop that currently exists where children may and have been suddenly and traumatically separated from their therapist if treatment ends unexpectedly. At the CAC where I worked, 40 children and families experienced an abrupt and unexplained end to their existing trauma therapy when myself and several of my colleagues were terminated. You all heard testimony this morning from many people who had experienced abuse and who were very brave to come and tell their story in a public place. Could you imagine if they had been matched with a therapist and then one day their therapist was just gone? Sometimes people ask me how I can do this work when I see so many children in painful situations. I love this work, and I do it because I can help children feel better. When my colleagues and I were terminated, I immediately worried for the impact on these children. I worried that they would think I had abandoned them, that I didn't care, and that they didn't matter. I worried that one client who had experienced recent thoughts of suicide may be in danger when his treatment ended without warning. This family was matched with someone who was not trained in the child's treatment, which disrupted their care and made the family understandably concerned. Fortunately, this family was able to find me through LinkedIn. They were distraught at the separation and at the fact that they were denied information on how to find me. I still worry about the impact on families that were not able to find me and who may still think that yet another person who was supposed to care for them abandoned them. I care deeply about my patients and my ethical duty to do no harm. It was devastating to be prevented from upholding my duty, which I typically would have exercised by telling my patients of my departure. The children and the families seeking care at a CAC have already been through enough. They deserve to be treated with dignity and respect and to have this loophole closed. Thank you.
All right, let's see. Online we have, why don't we go?
Mr. Shattuck.
Oh, yeah, sorry, go ahead.
I'll be brief, Mr. Chair. My name is Dan Shattuck. I'm here today on behalf of the Maryland Psychological Association. You've heard a lot of compelling testimony. You've heard the bill as we've laid it out that we think it represents best practices. We see it as a straightforward way to ensure what you've been hearing today, that children are protected, families are protected, the providers are protected. We've also heard in many ways that the providers were denied their ability to transition the clients that they were working with. But in that is the ethical duty, and my colleague next to me was speaking to that they are ethically bound to not abandon their patients, but they found themselves in a situation where, for lack of a better term, maybe it was a forced abandonment of their patients. And this bill is trying to reconcile that, to prevent any future scenario where providers and families and kids are put in this, unforeseen situation. And that's why, again, we think it's straightforward and, a fair way to go. And if the stakeholders want to sit down and find the best way to go and look at the hours and look at the terminology and all of that, I think we're willing to do that. But again, the key is giving everybody an opportunity to look at where they can go to turn for help. They're nationally accredited, but where does the state come into that? And I think this bill was trying to give a little window to those providers and families of what the process should be and how it should be done. And we think that's a fair thing to consider. So thank you very much.
All right, now we'll go to the online folks, and why don't we start with Allison Kramer-Kuhn?
Hi, thank you. My name is Allison Kramer-Kuhn, and I'm a child psychologist. I'm licensed in Maryland and DC and specialize in trauma-focused treatment. I'm a staunch supporter of CACs and have been employed by 2 of them. I think people generally understand that the relationship between a therapist and a client is important. It's that much more important for kids who've experienced trauma, specifically maltreatment by an adult that they trusted. Trust, stability, and predictability are critical in treatment. This is because by its nature, child maltreatment is confusing, it's chaotic, it's unpredictable. It goes against our expectations of how people are supposed to behave, how the world is supposed to be. Trauma fosters uncertainty and mistrust. For children who make a disclosure of abuse, unfortunately, the chaos and uncertainty doesn't end there. Kids have no idea what's going to happen to them or to their family. Many are shuffled between family members or foster homes. They may have to change schools. They can be suddenly separated from parents, siblings, friends, pets. Any abrupt and unexplained separation in the aftermath of an abuse disclosure contributes to this chaos and unpredictability and undermines treatment. So if the therapeutic relationship has to end before treatment is finished, it's our responsibility to provide a planned and thoughtful transition. And if that's not possible, for whatever reason, can we at the very least, give kids the opportunity to say goodbye? I'm confident that most therapists and CACs are already doing the right thing. But the fact is that children can be and have been harmed because of sudden disruptions in care like this, and some kind of regulation could prevent additional harm in the future. So to me, the purpose of this bill is to prevent organizations from even inadvertently contributing to traumatic separations. If there are disagreements about the wording or the practical implications of the bill, I respectfully urge interested parties to work together, please, to craft something that addresses any of these concerns so that the purpose of the bill is not lost. Thank you.
All right, next we'll hear from Bill Fluke.
Yes, hi, my name is Dr. Bill Fluke. I'm a retired psychologist, have spent my entire career in public education. Chairman Clippinger, Vice Chair Moon, and members of the committee, you've heard a lot today about childhood trauma. You've heard a lot about how it takes years with some traumatized folks to get over it and some never do. Early intervention through therapy, such as is provided at the CACs, is essential, and it's essential that we get it right to mitigate the long-term damage. So I'm going to speak today from the point of view of 2 organizations that deal with damaged kids. First, I'm a member of NAMI, the National Alliance on Mental Illness, which supports this bill. It's a grassroots organization, painfully aware of the impact of mental illness on children, adults, and their families. Early trauma left untreated is a significant factor in a lot of mental illness. Secondly, I'm here on the behalf of the Maryland School Psychologists Association. There are over almost 900 school psychologists in Maryland, and they provide essential behavioral health services in Maryland's public schools. We're also painfully aware of the terrible impact of physical and sexual abuse on kids, and to the extent that we can rely on our CACs to help these kids and help them get through it, these kids are going to do better in school and in life. So I'll end with that. There was a quote earlier today that moved me. Somebody referred to being abused as "there's a wounded child living inside you." That's an awful circumstance, and we want to avoid it. So we urge a favorable report on this bill. Thank you.
All right, and last we'll hear from Emily Pecan.
My name is Emily Pecan, and I am a licensed clinical social worker working primarily with children who have experienced trauma in Maryland. I sincerely appreciate the opportunity to speak in support of House Bill 762. I worked at a Maryland CAC for almost 2 years. I am bilingual, and so a large percentage of my client load were under-resourced Spanish-speaking families. When I was terminated abruptly, I would have been happy to see any of the families that chose to continue therapy with me, or even just have one closing session with them. However, my clients did not know why I was suddenly gone or how to reach me. In the following weeks, I did have 2 clients find me on LinkedIn who chose to resume treatment. They were both English-speaking families. I never reconnected with any of the Spanish-speaking families. There was only one other trained Spanish-speaking therapist at my CAC when I left who already had a full caseload, and as you can probably imagine, there are typically long waiting lists to see a Spanish-speaking therapist. So I really worry what happened to these clients. I especially worry about the 2 children who had recently been hospitalized for suicidal ideation and the young client who has experienced trauma-based psychosis that threatened his ability to continue attending school. In the middle of all of this, their therapist essentially disappeared without proper transition or termination. It has been scary and sad to consider the additional and completely avoidable trauma these families may have experienced. I understand that the requirements being proposed in this bill may appear onerous for some CACs. Much of what we already are required to do to care for our most vulnerable child clients responsibly could be considered onerous, but we do them because they matter. We should not deny these children the care they deserve because it is too much work. Many systems are set up to allow these marginalized individuals to fall through the cracks. It is our responsibility to do the work required to protect our most vulnerable. Thank you.
All right, I don't see any questions for this panel, so I'm going to quote you, Delegate Cardin. I think it's off the dance floor and into the balcony for you. We have a few people signed up unfavorable. I've never heard that term before, by the way. Charles Regan, Joyce Lombardi, Wendy Myers, Wendy Lane, and then we have some online, Will Laird, Judith Chagrin. If any of these folks are here, please come up. All right, whoever would like to begin when you're ready.
Thank you, Mr. Vice Chair, members of the committee. Good evening. My name is Wendy Myers, and I am the Executive Director of Maryland Children's Alliance, MCA. MCA is the accredited statewide chapter which serves as the convener of Maryland's 24 Child Advocacy Centers, or CACs. CACs serve child victims of physical and sexual abuse, exploitation, and trafficking. In 2022, Maryland CACs served more than 5,700 children. Between the years 2016 and 2022, Maryland CACs provided services to 37,529 children. To put that into perspective for you, the population of Talbot County is 37,510. We are experiencing an increase in the demand for CAC services, and our Maryland CACs continue to meet the needs of our communities. We have been on the front lines for decades, establishing best practice standards and successfully responding to the needs of children and families in Maryland. Each CAC team includes specially trained forensic interviewers, law enforcement, child protective services, family advocates, prosecutors, medical providers, and trauma therapists. The requirements set forth in House Bill 762 have a dissimilar impact on each of the 24 CACs in Maryland, given the differences in their organizational structures. 14 of the 24 CACs are operated by the Department of Human Services. 5 are nonprofit entities. 3 are operated by counties, and 2 are operated by law enforcement. Additionally, 20 of the 24 do not employ mental health providers in-house. These CACs instead coordinate services through linkage agreements with external providers. House Bill 762 proposes a one-size-fits-all approach to CACs that are of all different types, with different professionals and entities at the helm. The proposed requirement would blur the lines of our established multidisciplinary teams and potentially create conflicts within our established individualized protocols by requiring state or county employees to report these changes. For these reasons, we respectfully request an unfavorable report. Thank you.
Vice Chairman and members of the Judiciary Committee. My name is Charles Regan, and I am the Executive Director of the Treehouse Child Advocacy Center of Montgomery County. As you've heard, the entire reason for our existence is to facilitate communication and collaboration among the investigating agencies, including the police, child welfare, state and county attorneys' offices, among others. This fiscal year alone, in the last 8 months, the Treehouse has already provided over 3,300 services to 726 children and their families, including forensic interviews, medical evaluations and reviews, victim advocacy services, and mental health trauma therapy. Now, based on the previous testimony, you would get the impression it was the Wild West with no oversight. As one of the only 5 CACs in Maryland that are independent 501c3s, our funding comes from multiple sources, including Montgomery County directly, state and federal grant programs, and other foundation grants, multiple foundation grants. The oversight for each of these sources include detailed monthly, quarterly, and annual reporting. To retain our accreditation, we are required to maintain accurate records for every child and service on a daily and weekly basis. In addition, the Treehouse conducts annual independent third-party audits of all, not only financial, but all other records as well. When treatment is interrupted, it's never ideal. Our policy and our approach is always in keeping with our child first approach. Anytime there is a change of service, the team gathers, the guardian of the child is informed immediately, and a transition plan is developed to determine what is best for that child. Now, due to ongoing litigation brought upon by the proponents, I'm limited in what I can share in detail today. However, I will tell you on the record that of the 27 children that were being under care of the terminated therapists, every one of them was either put under new therapy, none went on a waiting list, including several that went and continued with their existing therapists that were terminated. This legislation is a solution looking for a problem, and with the levels of oversight already imposed, it is burdensome to both the state and the CACs. For these reasons, I respectfully request an unfavorable report.
Good evening. My name is Judith Shagrin. I'm here on behalf of the Maryland chapter of the National Association of Social Workers. All social workers in Maryland are licensed healthcare professionals, providers, and today I represent those who would be affected by the bill, social workers who work as therapists, and those who work in child welfare, which is where I spent my career. What happened in Montgomery County was deeply troubling, but there is literally no evidence of a statewide problem that needs to be resolved. While the notification the bill would require seems reasonable for a well-resourced child advocacy center with an embedded therapeutic staff like Montgomery County, it makes no sense at all for child advocacy centers who don't. Baltimore County, one of the first advocacy centers, for example, has a memorandum of understanding with a specialized mental health provider and makes referrals to community therapists. By state law, CAC investigations must be closed within 60 days. The CIC has no authority to require a community provider notify them anytime a therapist or healthcare provider changes, and HB 762 prescribes no time frame. Moreover, Baltimore County DSS has an all-social work workforce, one of only 2 local departments. That means they're all licensed healthcare professionals. When the CAC refers children to agency services such as the Sexual Abuse Treatment Program or even foster care, because the bill would require notice any time a healthcare provider is changed, the bill would mandate the CAC provide notice literally any time the child social worker resigns, goes on maternity leave, or transfers to another position. Internal policies and licensing laws already prescribe transitions and discharges. In short, HB 372 is confusing and impractical and adds an extra layer that won't impact client services. For that reason, we ask for an unfavorable report. Thank you.
Mr. Chairman, may I change chairs?
Thank you. Good evening. I am Joyce Lombardi.
And I'm here again on behalf of Center for Hope. Mr. Chairman, members of the committee, thank you very much. You have our written testimony, and there we detail, as long as I think it's 13 other written testimony from State Council on Child Abuse and Neglect, Child Coalition to Protect Maryland's Children, Maryland Coalition Against Sexual Assault, Maryland Coalition Against the Counties. You had a lot of written testimony in opposition of this bill. We feel that it is unnecessary. We feel that it is impractical and it is legally defective. As Delegate Williams pointed out, it does in fact already contradict some statutes that are in law, one of which is the whistleblower provision. Others are listed in our testimony. There's already standards in place. We list a lot on page 2 of our testimony. There's the accreditation standards. There's the ethical licensing boards that are already there, and those go up the chain, right? So if you're a therapist and you have these boards, it goes up the chain. Same thing with the common law and statutory notion of abandonment. The word abandonment was used here. Again, that can be against the provider, and that can be against the agency. So those, even if Maryland needed a new law, this is not it. This law is defective on its face. Its terms are ill-defined, and it is so broad as to be unworkable and and perhaps in some cases absurd. You have testimony of the American Academy of Pediatrics. Wendy Lane is not able to be here tonight. You have others who are also Springboard, who it's the mental health provider for Harford County, Carroll County, and others, saying that it is unworkable. One of the provisions, for example, it says that child advocacy centers have 48 hours to pick a new provider in the instance that we can't, that there is a change. Unworkable, and it can't happen. We ask that you not make bad law out of disputed facts. Thank you.
Delegate Arikan.
Yeah, I just wanted to give Joyce an opportunity to add stuff if she needed to add anything, that she got a little cut off there. If you wanted to just finish your thought. I know you hurried yourself up at the end there.
Thank you, Delegate. I think you do have 5 pages of our written testimony. We do go through, and I think the last thing that I would say is that the statute contradicts the very law that it is in. It is Criminal Procedure 11-928, and if you read that, page 3, line 15, you will see that the body that is charged with setting standards for child advocacy centers, which are not agents of the state, they are broad, as written in the statute. The body in charge of that is the Maryland Children's Alliance. So there is no amendment that would work. Let the law go as written. Thank you.
Thank you.
Delegate Young.
Thank you, Mr. Chair. Quick question for Wendy. Can you just tell me what the accreditation process is or the standards for child advocacy centers?
Absolutely, thank you. National Children's Alliance, or NCA, is the nationally recognized and federally supported accrediting body for child advocacy centers. MCA is also an accredited chapter of National Children's Alliance. So Maryland law requires that CACs be developed and located throughout the state to ensure that every child has access to a child advocacy center, and also best practice services in response to those types of allegations. The 10 mandatory standards include each aspect of joint investigations, each discipline related to the multidisciplinary team, as well as governance and organizational capacity. So in order to become accredited, you would need to meet those 10 standards of practice.
Arikan, you have another question? Oh, is that Tomlinson? Yeah, go ahead.
Thanks. Thank you, Vice Chairman. Sir, you're with a business, right? Or, sorry, with
Executive Director.
Okay,
Right.
yes. Thanks for, so you kind of painted us a picture of what the process is for your organization. So my question is for Ms. Myers. Since he kind of gave us an idea of how when a provider's changed for a child, at least in his organization, is it I mean, is that kind of the same across the board, or can you kind of take us through that same journey as well?
Yes, absolutely. There is oversight at the local level, at the state level, and even at the federal level with National Children's Alliance. Our CACs look as different as the populations they serve. Each one is just made up based on local resources, and it looks different in every single jurisdiction. In Maryland, 14 of the 24 are operated by the Department of Social Services, so that's DHS. 5 are nonprofits, as Mr. Regan said, but 3 are operated by the county in which they serve, and 2 are operated by local law enforcement. 20 out of our 24 do not employ in-house mental health providers.
May I respond also to of what policies look like, if I may? Mr. Chairman? And so we have in our written testimony what, for example, our Child Advocacy Center that serves Baltimore has a termination policy that says if there is a change, if it is an abrupt change versus a plan change. If there's a plan change, you have a termination session with the person, right? That's best practices. If it's something that's unplanned, illness, something like that, if that provider is no longer there, then we instantly try to find somebody in-house for our mental health team. We give 3 external referrals, which I'll point out that this bill completely contradicts. We don't pick the provider. And we give notice of if there's an abrupt change, we give it immediately, written or by telephone, because we have a population with housing instability and in crisis, and so written obviously is not going to work in all situations. You asked what it is across the board. There are, again, and I point you to the licensing standards that were mentioned here and also by Ms. Shagrin. Like continuity of care, those standards and ethical responsibilities are across the board. They are never as granular as what you see here. That does not exist in health or any health or COMAR regulation for providers. But internal policies and standards exist for all of us.
Thank you guys very much. And again, as I said before, my goal is not to try and be like opposing here. It's trying to figure out how to make this all work. Yeah. This is for Ms. Lombardi because, I mean, I heard the gentleman speak, and it sounded to me like if you're doing the daily and weekly kind of work for the finance reasons, then you have the information to be able to do what we're asking for. And you just said that you're informing people immediately if there is an abrupt change. So you're already doing what we're asking. So maybe it's and then you're saying that this language doesn't work. This language doesn't work. But you're agreeing that your professional responsibility requires you to do what we're asking you to do. So why wouldn't we can't we come up with, you just don't want the state to tell you that you have to do this? You want to be able to say that, no, it's just our professional responsibility for our accreditation, and you don't want the state to be able to have that same requirement to tell you? I just don't understand. You're doing exactly what we're asking according to your own testimony. So.
Thank you for that question, Delegate. So let me be very clear. Our standards are, so for number one, is what I said, this law is unnecessary. Some of us are already doing it, so why add a new law that's actually more restrictive and on its face untenable and vague and actually contradicts?
You said you're doing it immediately. So we're saying no within 2 days, which we said we were willing to make, whether it's a week, it could be 10 days. I mean, but you say you're doing it immediately, which would say to me is faster than 2 days. So.
Right, and so what I'm responding to is the bill as written, right? You're legislators, and so what you have in front of you is not the intent, right? But you have a bill in front of you that says not exactly what you mean it to say. And so let's just narrow this down to just a termination procedure, right? And so we have termination procedures that are far more nuanced than the ones that are here codified in statute. And it's not that we don't want regulation, it's just how are you going to regulate? For example, the Harford County Sheriff's Department now has to go and comply. They have to call Springboard and say, hey, give me the name of your provider, right? So I think, or actually Springboard has to call the Harford County Sheriff's Office and say, there's going to be a change in provider, even though we only see this person for 3 to 5 days, Harford County Sheriff's Office, could you now call the family and say, there's going to be a change in provider, and I have to now pick you a new provider, and I have 48 hours, except I don't know who I'm referring them to, and I have to figure this out, and I have to do a contract. And,
With all due respect, that's not what the bill says, but that's okay.
and with all due respect, it absolutely is.
If I can make one more thing, there's two parts of that bill. The other one says that we addressed it before. This is, it's never ideal to change. There's a high turnover in social work therapy and even higher with children, right? In an ideal, and this happened to us last week, a therapist came back from maternity leave. This wasn't so you have some runway, right? We go through this. We let the therapist works with the child to make an exit, but that's not always the case. So when there is an abrupt termination, then there, as you point out, there's policies. And why? And part of the bill says, doesn't matter why they were abruptly terminated. It could be, in our case, deliberate harm caused to the organization. Material harm, damage done to the very existence of the organization. So in any other aspect of business, those people are, will cause harm to much more. So there's a bigger issue there. So
And I think that was covered. That's okay. Thank you, Mr. Chairman.
All right, I think that's it for this hearing. Thank you very much. That's going to end the hearing on House Bill 762. We are now on our final 3 bills. We still have over 40 witnesses. There are 3 bills from Delegate Crutchfield, who I believe is going to be joining us from Zoom while she's out sick. Is that correct? And while we're getting Delegate Crutchfield, we'll start with House Bill 749. One second, Delegate Crutchfield. So for House Bill 749, we have Christopher Arnold, virtual, and Ralph Watkins in person. Do we have Christopher Arnold from the, okay. All right, well, okay. Delegate Crutchfield, why don't you kick us off with 3 minutes when you're ready.
Okay. Thank you very much, Mr. Vice Chair and committee. Please, I appreciate your indulgence in allowing me to testify virtually. I'm going to kick this off with 3 next bills that are on my bills, so hang in there. Starting out with HB 749. This legislation will clarify that state and local authorities may assert jurisdiction over juveniles on military installations in areas of exclusive federal legislative jurisdiction. Currently, juveniles who are accused of delinquent acts on military installations are detained and subject to federal jurisdiction, where they are referred to a federal court system designed for adults. The problem is that these courts lack the resources to help juvenile offenders, often denying the families and juveniles the resources and programs needed. HB 749 would allow offenses committed by juveniles to be transferred to state court and allow them to take advantage of diversionary programs and other services offered through the state. Studies show that addressing juvenile matters through diversionary programs and community-based supports produces better outcomes and reduces recidivism. Under this legislation, the federal government may seek retrocession at all Maryland military installations. When retrocession has not occurred, this legislation creates a procedural mechanism for the state to assume concurrent jurisdiction when the federal government waives it. That is the process already in place throughout the state. Still, there is no underlying statutory authority to support this referral process. So HB 49 provides this authority and allows Maryland courts to accept the transfer of jurisdiction back from the federal government. Within the last 12 months, there have been similar legislation that's been enacted in Arizona, Connecticut, New Hampshire, and North Carolina. HB 749 will ensure that juveniles in military installations receive the same justice, fairness, and protections under the law that we would that they would when living off base in civilian communities. For this reason, I urge a favorable report on HB 749. Thank you.
All right, we're going to hear from Christopher Arnold next. Christopher, you have 2 minutes when you're ready. Please unmute yourself.
Good evening, Chairman. I am the Mid-Atlantic Region Liaison at the United States Department of Defense State Liaison Office. Our shared mission is to ensure youth on military installations receive the same protections under the law that they would living in civilian communities by working to remove the barriers to concurrent juvenile jurisdiction. The policies proposed in House Bill 749 add clarity to the state's authority to adjudicate juvenile misconduct arising on military installations. It provides a retrocession option for areas acquired by the federal government prior to 1941, where there currently is none, and provides for an alternative means of relinquishment when a retrocession has not yet occurred or is infeasible. Research provides evidence of a critical period for neuroplasticity in the frontal cortex during the teenage years, a time at which risk-taking behaviors and mental illness peak. Risky behavior presents more frequently during adolescence. Only a small percentage of young offenders escalate their behavior committing crimes during adulthood, and neuroscience has demonstrated a capacity for change and rehabilitation. At the moment, there are large numbers of civilians, both adults and juveniles, with a tenuous military nexus, traversing areas of federal exclusive legislative jurisdiction on our installations, where delinquency offenses are referred on a case-by-case basis to the county. Some installations have juvenile review boards for most delinquency offenses which do not rise to the level of a crime, which are authorized to take administrative action and typically hear 3 to 5 cases per quarter. There were 59 more serious cases in federally exclusive areas in Maryland from 2017 to 2021, which were referred to the juvenile court, as the federal government does not have the personnel programs or established procedures to address these juvenile offenders, which is why we defer to the state. House Bill 749 creates the vehicle for us to get past these barriers, providing statutory authority to relinquish jurisdiction, and for Maryland to accept it back creates enforceable law, allowing the department to lawfully refer these cases to your court system. As always, as liaison to the Mid-Atlantic, I stand ready to answer whatever questions you may have.
All right, Ralph Watkins, you have 2 minutes whenever you're ready.
Thank you, Mr. Vice Chairman. Members of the committee, my name is Ralph Watkins, and I'm speaking for the League of Women Voters of Maryland. The League supports the use of specialized courts for processing juvenile offenders, and as has already been stated, the federal court system, while well equipped to deal with adult offenders, lacks the specialized resources needed to address juvenile offenders. Granting concurrent jurisdiction will create flexibility in addressing these cases to ensure the most effective response. We urge a favorable report on this bill. Thank you.
All right, it doesn't look like there's anyone signed up in opposition or with a written letter, but are there any questions? One question, Delegate Bartlett.
Thank you, Mr. Chair, and thank you, Delegate Crutchfield, for bringing this bill. This is a pretty big deal, isn't it? I mean, we're getting the federal government to relinquish a power and ask for the state's assistance. Am I understanding that correctly?
That is correct.
Wow.
And Mr. Dodd, if you want to elaborate a little bit.
And not only relinquishing, you're actually asking and giving the state, Mr. Arnold.
Affirmative, Madam Delegate. The Congress has actually directed the departments to relinquish jurisdiction as of the fiscal year 2018 National Defense Authorization Act, and the Deputy Secretary of Defense, Dr. Hicks, has directed the military services to retrocede jurisdiction. So as we handle state government relations for the Office of the Secretary of Defense, we're trying to identify these barriers in state laws, which would prohibit us from relinquishing our jurisdiction. So we believe that Delegate Crutchfield's legislation would allow us to achieve the Congress's and the DepSecDef's aims.
Is this, one more question? And it might have been in the testimony and I might have missed it. How many other states does this exist in? or in which this existed?
Yeah, so in the last 12 months, it's been Arizona, Connecticut, New Hampshire, and North Carolina that have actually put legislation like this in place.
Okay, all right, Maryland's moving up there. Thank you.
All right, Mary Ann, go ahead.
Thanks. Mr. Arnold, if you could just, maybe I missed this, what precipitated this change at the federal level?
Copy. So in the fiscal year 2018 National Defense Authorization Act, there was a directive to the departments to seek to retrocede jurisdiction. But it has been the posture of the federal government since 1962 to relinquish its jurisdiction whenever practicable. The Department of Justice is vigilant in protecting the communities it serves, the most vulnerable. They're the ones that initiate federal action, but there's no federal framework with which to address serious juvenile matters. So these cases are almost always referred to the states under informal agreements.
Okay.
And we're concerned that without valid statutory authority for the federal government to relinquish its jurisdiction under the section of Title 10, which allows us to do so, and a corresponding state provision to accept the fact that these informal agreements may not be enforceable.
Okay, yeah, because I was going to say, I thought at least in my county, this may already have been going on, so maybe it was an informal
Roger, and we have a breakdown
agreement.
of all 9 installations and the juvenile framework and how it is currently handled. It's generally articulated through a memoranda of understanding.
Yeah.
But in that second paragraph, which is the authority to enter into the MOU, it says that it doesn't conflict with any other federal or state law, or there's an opinion, an informal opinion of the Attorney General that says that, you know, we probably have the authority to do this. So the statute would affirmatively allow those case-by-case or matter-by-matter referrals to take place.
Okay, thanks. Thanks for clarifying.
All right, that's going to end the hearing on House Bill 749. Thank you very much. We're going to move on to Delegate Crutchfield's next bill, House Bill 1180, Youth Accountability and Safety Act. There are 23 witnesses on this one. We have a few signed up on the in-person panel. Phil Karoom, Judith Lichtenberg, Rachel Kamens, Lila Meadows, Erica Sudar. All right. Delegate Crutchfield, when you are ready.
Thank you, Mr. Vice Chair. And again, to the committee, thank you for your indulgence in allowing me to testify remotely. For the record, I am Delegate Charlotte Crutchfield, representing District 19 in Montgomery County, and I'm here to testify in support of HB 1180. One of the fundamental elements of a just and fair criminal justice system is that individuals are held responsible for the crimes that they committed or intended to commit. That's not happening in every case in Maryland. In 1978, Aruna Pretty, then 18, was in a relationship with an increasingly controlling and abusive man named Ronald Brown. On April 6, 1978, Brown ordered her to participate in a store robbery, along with a friend of his, at a store that Ms. Pretty had recently stopped working at. During the robbery, Brown fatally shot the owner. All 3 were arrested, and on the advice of her attorney and facing a death penalty, Ms. Pretty pleaded guilty to first-degree murder. No one accused her of the killing. You may recall this story because I wrote then Governor Hogan in May 2020 during the height of the COVID-19 pandemic, requesting that he commute Ms. Pretty's sentence. Several of you were signatories on that letter. At that time, Ms. Pretty had spent 42 years in prison, being the longest-serving woman prisoner in the state of Maryland, and she was suffering from poor health. Ms. Pretty was one of many convicted and sentenced under a legal doctrine known as felony murder rule. Basically, it holds everyone liable for murder and any death that occurs during the commission of certain crimes such as burglary, robbery, even if the death is accidental, unforeseen, or unintended, and even if the person was not directly responsible for the death. The felony murder rule originated in English common law centuries ago, but it is still used in many jurisdictions in the United States. This year, we have an opportunity to limit its application with young people under HB 1180. It is a bedrock principle of our criminal justice system that a person be held personally accountable for his intended actions and not the intended actions of another. This undermines the principles of our criminal justice system by severely penalizing people for crimes that they did not commit nor intend to commit. So please listen carefully to the testimony you will hear about the effects that a conviction under felony murder can have on our young people. And for these reasons, I urge a favorable report on HB 1180.
All right, whoever would like to go first up here.
Good evening, Mr. Vice Chairman and members of the committee. I'm Rachel Kamens. I'm an appellate public defender asking for a favorable report on House Bill 1180, which would prospectively eliminate the crime of first-degree felony murder for people under the age of 25. Felony murder is guilt by association. Felony murder is strict liability. Felony murder has you going to prison for first-degree murder for the rest of your life, for a murder you didn't commit, didn't help commit, didn't know was going to happen, did not even consider the possibility that it might happen. Felony murder is when someone gets killed while you were committing or attempting to commit a felony. As Delegate Crutchfield mentioned, most commonly robbery or burglary. Forget about intent to kill. In felony murder, the prosecution need only prove your involvement in the felony. In this variety of first-degree murder, the felony substitutes for the mental state that must be proved for the premeditated variety of first-degree murder. The idea is that a killing that occurs during the commission of a felony is foreseeable to all those participating in the felony. House Bill 1180 seeks to eliminate felony murder for people under 25, the population most vulnerable to peer pressure and least likely to appreciate the risks and consequences of their actions. As applied to this age group, felony murder makes no sense. It is unjust and should not be the law. Let's punish people for the crimes that they actually commit. As the title of this bill suggests, let's hold youth accountable for the crimes they commit while keeping our communities safe. Thank you.
All right, I'm Phil Karoom speaking today, not for the Maryland court system, but for Maryland Alliance for Justice Reform. I filed written testimony, but I'd like to take these 2 minutes to respond to a memo sent by the Judiciary's Legislative Committee, which objects to HB 1180 because it conflicts with other Maryland statutes that set adulthood at 18 years and treat some adults differently. I'd like to point out this analysis is superficial and wrong. Having sat with this legislative committee that produced that memo, I can tell you they review about 100 of your bills every week, and they spend 1 or 2 minutes doing that. In essence, what their memos represent too often is a gut reaction with very little analysis. If we analyze the actual impact, the actual presence of treating adults differently than the age of 18 under U.S. constitutional, state constitutional, and Maryland law, you'll see that this principle is everywhere. In the U.S. Constitution, to be in Congress, the Senate, or to be president, you need to be age 25, 30, or 35. To have your jobs here as delegates, you need to be 21 at least. To be a state senator, you need to be 25. We draw these distinctions based on maturity, going back even before we had the scientific studies that support HB 1180. In Maryland, juvenile delinquency can continue past age 18 to 21. You can't possess alcohol or cannabis in a few months unless you're 21. Statutory rape attaches not just to age 18, but age 18, 19, and 20 with different offenses depending on your age. And under the sentencing guidelines, we have different standards if you are age 23, up to age 23. In conclusion, I would say that it is good public policy. There's a rational basis for it. It will be upheld on appeal. And there are many other states, including Republican states such as Nebraska and Texas, that have emerging adult courts and draw the same distinction that HB 1180 would provide for this, our laws in Maryland. Thank you.
Good evening, Vice Chair Clippinger and members of the committee. My name is Erica Suter. I'm an assistant public defender, director of the UB Innocence Project Clinic, and president of the Maryland Criminal Defense Attorneys Association. I've filed written testimony, but I'd like to use my time to respond to some of the written opposition testimony. According to Mr. Schellenberger, it would have been much more difficult to convict Donta Harris, the driver of the stolen Jeep that killed Officer Caprio, and it would have been impossible to convict Mr. Harris's 3 co-defendants of first-degree murder. As you will hear from my colleague on this panel, prosecutors have plenty of tools in their toolbox to hold individuals accountable for their conduct. If you've ever heard a prosecutor argue in closing argument about the time necessary to satisfy the premeditation element of first-degree murder, they will tell you mere seconds to consider one's actions is sufficient. Taking felony murder off the table for youth would not hobble prosecutors. But more relevant to this conversation, though, is that in the case of Mr. Harris, there were 3 boys, ages 15, 16, and 17, that were in a house that they chose to break into, but they could not see what Mr. Harris was about to do. They did not plan it. They did not intend it. They did not expect it. They were kids who did not consider the horrible potential outcome of their conduct. Their exposure for the crimes they did commit was 20 years per burglary, and there were multiple burglaries that could have been run consecutive, and 5 years for auto theft, which likewise could have been run consecutive. In short, they faced significantly more time for the crimes they actually committed than they received for pleading guilty to first-degree murder, a crime they did not commit. This bill is about holding youth accountable for the crimes they commit, not a legal fiction that fails to consider the mental development of children. We would urge a favorable report.
Good evening. My name is Lila Meadows, and I'm a member of the clinical law faculty at the University of Maryland School of Law, where I represent individuals who are serving long sentences, including Arena Priddy, who Delegate Crutchfield highlighted in her remarks. I was one of 3 attorneys who helped secure Ms. Priddy's release in 2020. I'm here to urge a favorable report on House Bill 1180 for all the reasons my colleagues have and will highlight, but I do want to talk about the special injustice this works on people who are victims of intimate partner violence themselves. Because felony murder imposes identical sentences, and in Maryland that's a life sentence, on any individual involved in the felony, regardless of their actual role in the murder that results, it can result in very disproportionate sentencing in cases where women participate in the crime under the duress of their abusive partner, as was the case with Arena Priddy. And unfortunately, she is not unusual. I've represented many other women in similar situations. And while we won't be able to give you an exact number of individuals who are serving sentences for felony murder because of the way the statute is constructed here, it's charged the same as regular premeditated murder, other states are instructive. A study in California found that among women serving life sentences for felony murder, 72% were not the primary perpetrator. 72%. I also, as Erica referenced, as Professor Suter referenced, prosecutors have the tools to hold people like Ms. Priddy accountable. They can be charged with conspiracy where appropriate, accomplice liability, premeditated first-degree murder, where the facts bear that, second-degree murder, the underlying felony itself, use of a weapon in the commission of a felony, all of which can be run consecutively. I urge you to issue a favorable report.
All right, what's the gentleman's name?
Hi, my name is Steve Gravatt.
I think I might have you on panel 2.
Oh,
If you
okay.
don't
My
mind- If you don't
apologies.
mind, yeah, sorry. I'm going to get questions in for the sponsor first before we move on. Delegate Eric Hand.
Thank you, Mr. Chair. Thank you all for being here. Could you just remind the body, how long do people serve for life? What's the minimum amount of time they serve when they get life?
Life.
No, the minimum. What's the minimum?
We
How
don't
many
have-
years is it?
We don't have that. We have, I mean, anybody else can chime in, but life,
Life means life, huh?
Life means life. With a parole eligible life sentence, previously you could be considered for parole at 15 years, but the instance, I'm not aware of anybody who was serving a life sentence who was paroled their first time up at 15 years. And there's no mandatory, if you have a life sentence, there's no mandatory release date term of years.
The General Assembly also changed parole eligibility when it removed the governor from the process and put that at 20.
Okay, 20 years. Yeah, I couldn't remember. I thought it was something like that. So my next question is to the gentleman in the glasses. You had talked a lot about sort of brain development, and everyone's mentioned children a bunch of times. Obviously, this bill is not just about children. It's 25 years old. It's considered by most people's standards to be an adult. They can vote. They can go to strip clubs, and they can drink alcohol. They can do all these things. And are you aware in the state of Maryland that we are going quite literally in the exact opposite direction of this bill on many things? We've allowed children now, minor children, to consent to medical treatment, mental health care, medications in many circumstances. So I'm just wondering, how does this policy jive with the direction of literally almost every other policy that we see outside of the juvenile justice arena?
The scientific studies suggest that brains of humans in general are not fully developed until approximately age 25. And the part of the brain that develops last is good judgment. That fact is really supported not just by our common experience, but by the number of offenses that you see committed by age group, which are offenses of impulse, and it also, I think, is supported by popular culture. When you see the people who participate on game shows and do the most idiotic, self-endangering things, they are people under the age of 25.
Yeah, I don't disagree with you. I find it a little odd that our body is trying to now get people to vote at 16, to do all kinds of things as minors, yet this area where they need to be held accountable for murdering people, we're saying, oh no, they can vote, they can consent to drugs, but they can't do this.
The reason, of course, that we dropped it from age 21 to age 18 was the draft. And the premise that was accepted by people across the country with amazing rapidity is if you're old enough to be pulled into the Army and face death, then you ought to be old enough to vote.
Yeah, I certainly understand the concept of voting, but with all due respect, voting and the draft has nothing to do with the mental health treatment that we're now letting kids consent to, all kinds of other treatments they're allowed to, without parental knowledge. We're making very serious, potentially dangerous decisions for children that are literally flying in the face of what you've just told me about brain development.
A corollary of the scientific evidence is that people who are under the age of 25 are also more susceptible to rehabilitation and can actually change their behavior, change their values, and become much more responsible than a person who displays similar behavior after the age of 25. If they're still doing this after the age of 25, that person is likely got serious character defects and, in fact, may be appropriate for public safety purposes to be incarcerated for some substantial period of time. But if we can get these people while they are young and give them behavioral treatment and get them jobs and get them the education which all too often they didn't get before, you can actually drop their recidivism from way above 50% down into the low 20s or better.
Okay.
So
I hear
there
you.
is reason to treat them differently because you're actually improving public safety if you do.
I hear you. I think many people might feel that someone who drives over a woman with a car has a character defect, but thank you very much.
All right, Delegate Taylor.
Thank you, Vice Chair Moon. Baltimore State's attorney wrote in opposition and cited that very case about the officer that was run over. There were 4 young men in a car, and they all were charged with felony murder. If this bill becomes law, what would the other 3 be charged with?
The other 3 would be charged with the burglaries that they were committing. Those burglaries each would have carried 20 years. It's my understanding they went into a number of homes together, so they could have been charged with 20 plus 20 plus 20. In effect, they could have been charged with 80 or 100 years, depending on the number of houses that they went into. I do not know enough about that case to know what additional charges they would have been.
So still a substantial amount of time.
A very
in
substantial
prison.
amount of time that would have limited their eligibility for parole potentially to take an even longer period of time than if they had the life sentence.
And if I could add also, if the state were able to prove that this was a plan to harm an officer or to harm someone else, then those individuals who were not in the vehicle that was driven by Mr. Harris could also be held accountable under a conspiracy theory. So if their object in coming together was in fact to murder somebody, then they would be subject to a life sentence, subject to being charged with first-degree murder, if that was in fact what their intent was.
Thank you.
Thank you, Vice Chair. I just wanted to kind of piggyback a little bit on the earlier question about the life charge and the parole. So you mentioned that they would first be up under 20 years, but in your experience, you also mentioned that typically, even though that's the first time they're up, they typically are not granted parole at that time. And so my question is, based on your experience, kind of when is the typical time frame? Is it after their 3 attempts through the parole system? Kind of what is that time frame that you've seen?
So I think it varies, but I don't know that I could give you an average, and I don't know what we're going to see moving forward now that the governor is no longer in the process. But in my written testimony, I talk about a juvenile, someone who was convicted as a juvenile of felony murder, who I represented. He was 16 years old, and the state alleged he stood behind someone in a robbery. He had 1 infraction his entire time in the Department of Corrections that occurred when he was 17 in an adult prison. Perfect record, worked for Maryland Correctional Enterprises. He went up for parole 5 separate times and served 37 years in prison before I was able to bring him home through court, not the parole process at all. And I would say that's not unusual. I think everyone on this panel has represented clients who are similarly situated.
And if anyone else wants to answer as well.
I just would echo that. I mean, it's as we said, it really never happens the first time up. Parole Commission tends to give 3-year, return dates or hits, as they're colloquial called, 5 years. Very frequently, we have clients who are, told to come back in 10 years, and then they go back in 10 years, and then another 10 years. Tremendous amount of decades served before people are paroled. So the eligibility is a little misleading. Yes, they're eligible, but that is
doesn't
very
mean that they're
different
going to get
from
granted
when they actually are released. And also, just to reiterate, I know it was said before, but in many states, life has a numerical value. A certain amount of years is considered life. In Maryland, life does not have a number. It doesn't translate into 50 years or 60 years. It means life. So the way out on a life sentence is only through parole.
Right. Okay, thank you.
All right, thank you very much. We are going to bring up a few more favorable witnesses. Margaret Berry, Ann Kirsch, Stephen Gravitt, Christine Dufour, Heather Warnken. How many of these folks are here? John Giannetti, Hannah Breakstone. Does that get us to 5? All right, great. Whoever would like to begin.
Good evening. I'm Margaret Martin Barry, and I'm an emeritus professor of law and former director of the Reentry Clinic at American University's Washington College of Law. I'm before you again this evening on behalf of the Montgomery County Women's Democratic Club in strong support of this legislation. Felony murder has been called an indefensible principle, and an indefensible principle because it takes culpability, as you've heard this evening, takes culpability that we tend to connect to causation and intent, and throws that causation and intent out the window. So when we talk about murder, we're in the felony murder context, we're talking about a strict liability that does not attach to what we typically do when we're looking at murder. I've taught criminal law, and whenever we get to the felony murder part of the curriculum, students are outraged. They're going, wait a minute, what happened to all the things we spent weeks learning about? Well, what happened is we're in this new territory called felony murder, and it's a strict liability. So we have to forget everything that we think about. As far as I'm concerned, it's not murder. It's this creation that the creator, the United Kingdom, has done away with, as has others, and we still tend to hold on to it. The reason we hold on to it is this idea that we want to deter activity that surrounds certain kinds of felonies. But to deter something, there has to be an intended act, and we're trying to deter something that was unintended. What are we doing when we do that? We're undermining our very principles in criminal law. So we reach and say, well, but they should have foreseen that this would happen. And I could go on, as you know, but we strongly oppose it, and we ask for a favorable report on HB 1180. Thank you.
Thank you, Mr. Vice Chairman, members of the committee. John Giannetti, Jr. for the Maryland Criminal Defense Attorneys Association. When I sat on the committee, Joe Valerio had a motto for the committee. He says, we may doze, but we never close. So you guys have lived up to that motto here tonight. Guys, I really admire what you're doing here. You don't close. You clearly don't. MCDAA supports this measure. In fact, we would go even farther with this measure. The Criminal Defense Attorneys Association would like to get rid of the felony murder statute entirely. This bill does, I think, a very more responsible action than in past bills because they're trying to take a smaller chunk. In the past, they went after the folks who are already incarcerated and said that they should get another trial because they were incarcerated under this outdated policy. Well, this bill just says, well, listen, let's just go prospective. Let's go prospective because other folks have put in bills, second look and things like that to handle the second part. But look, felony murder statute was, we adopted it in Maryland in 1776 when we got the common law from Britain, right? It was part of the law in Britain. Well, in 1957, Britain said, no, this is no longer constitutional. The transferred intent that we are convicting people under Britain's law, we don't do it, but we still seem to hold on to it. Maryland, cherishes its common law roots. We've made it into statutory. It doesn't make a lot of sense when you think about the transferred intent. These people can still go to jail. We're in favor of this bill. Thank you.
Hello, my name is Steve Gravatt, and I'm here to provide a juror's perspective on the felony murder rule. In 2020, I was alternate juror number 1 for a trial where the defendant was charged with armed robbery and felony murder in the first degree. The defendant participated in a robbery where his accomplice accidentally killed the victim with a box cutter. As a juror, I was torn between competing duties. On the one hand, I wanted to do the right thing, and condemning a non-murderer to a murder one sentence did not seem like the right thing. On the other hand, I wanted to do my civic duty and apply the laws of the state of Maryland as best I understood them. Since I had no reasonable doubt that the defendant had participated in a premeditated robbery or that the robbery had resulted in a death, that meant finding him guilty of first-degree murder. Whatever choice I made, I was going to feel bad about it. Fortunately for me, all of the real jurors made it to the end of the trial, so I didn't have to participate in rendering a verdict. I later learned the jury found the defendant guilty of armed robbery, but innocent of felony murder. There are two possible explanations for this illogical finding. The first is that the jury simply didn't understand the law. After all, it's counterintuitive that the state would expect you to find a non-murderer guilty of murder. The other possible explanation is that the jurors willfully chose to disregard the law because they found it unjust. The crux of my testimony is that the state of Maryland should not be asking its citizen jurors to enforce a law that is either, one, so illogical we're liable to misunderstand it, or so contrary to our sense of justice that we choose to disregard it. So long as the felony murder rule remains on the books, it's important that we reduce the charges associated with it. By removing the first-degree murder charge from Marylanders under 25 convicted of felony murder, we will reduce the burden on jurors to condemn young people who haven't murdered anyone to a lifetime in prison. Let me move.
Hi, I am Ann Bocchini-Kirsch. I'm Director of Advocacy for Prepare, and what I do is parole advocacy and reentry support, but really the parole advocacy is what I'm here for today. I heard a number of questions, and I can't tell you how many cases I've seen where somebody came in as an emerging adult, and I now have their case. I have cases from the 70s. I have cases from the 80s. I have cases from the 90s. This is how long lifers are spending in prison because these are the cases that I'm currently advocating to the Parole Commission. Now, the governor was recently taken out, and that is going to change things. But when you're looking at felony murder and you're looking at condemning an 18-year-old, and then I have a case where there is an 18-year-old who is felony attempted murder, and you're looking at condemning an 18-year-old for being present to a lifetime in prison where I may be looking at their case 30, 40, 50 years later, which is not unusual, that takes pause. I wonder, as I'm looking at these cases, where is the intent? I'm looking at people who are confused, people who did not have a good understanding of what they were getting into, people who are peer pressured, people who never had a chance and are given the support they need once they get to prison. They're sent there with a life sentence, become good people who would be mentors, who would be helpful in the community, but they're never given that opportunity, and to me that's a tragedy. When I see someone who lives 18 or 19 years in desolation, is present at a crime that they don't actually themselves commit, and then is condemned to a lifetime in prison where, ironically, they're given the services they need to rehabilitate and become productive members of the community. So as you're looking at this bill, I'm asking you to stop the bleeding now and give a favorable report and stop giving youth felony murder. Thank you.
Good evening, members of the committee. My name is Heather Warnken, and I'm the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law. I submitted written testimony on behalf of our center, and I will use my time this evening to read a letter from a directly impacted person who wants her voice to be heard. My name is Ayula Mitchell, and I have spent 40 years working in America's criminal punishment system. In my experience, the following three things have been constant since I took my first group of youth to San Quentin in 1984. Number one, Black and brown people continue to be incarcerated at a disproportionately high rate. Number two, mandatory and extreme sentences do not prevent crime. And number three, under the felony murder rule, the person who actually took a life could serve less time than their co-defendants. I've personally witnessed it and not as an anomaly. I have heard countless stories on both sides of harm. My most important one, however, is my own. On January 30th, 2009, my oldest son survived 17 gunshot wounds. 15 months later, on Mother's Day, my middle son was murdered. My heart was broken, my family devastated. The absolutely unimaginable happened again a few years later when my godson was killed by a drunk driver. None of America's or Maryland's extreme sentencing, including the felony murder rule, was going to help heal my family or make us safer. Never once did I desire another person be sentenced to life. From the onset, I knew that my family needed resources, support, and love. I had to create this for me and my surviving children on my own. No one from the system that claims to represent the people ever asked me what we needed. I am interested in laws that help victims of violence, not ones that throw away people in our name.
Delegate Williams.
Yes, two things. One, Ms. Berry, thank you for your testimony. I had a question. You were kind of talking about the strict liability piece with regards to felony murder, and our colleague, Delegate Grammer, isn't here, but I know he always likes to talk about the mens rea necessary. And so in your, I guess, analysis of this, would you say that the mens rea is lacking of someone who is possibly convicted of felony murder because that was not their intent, so to speak, when they were committing whatever crime it was that they were committing?
Exactly. I mean, that's the underlying problem with the felony murder rule. We throw mens rea out the window. We impute this idea that if you're at the scene of the crime, you are as culpable as the person who actually did the killing. And that's just not so. We also say that you can even take felony murder and apply it to the person who accidentally killed someone, right? So you have causation there, but you don't have intent because it was an accident, so you have a different level than murder one. All of this is wrapped into something that totally throws out the window what we know is the analysis that should be applied when we're talking about murder one, murder two, manslaughter. No. If you were there at a felony, prosecutors don't have to bother to prove this, right? They can just say, no, they were there. And just as the juror who spoke about it, it puts the jury in an awful position. They have to convict someone for something they didn't do. So definitely, mens rea is out the window.
Okay. And I know you got cut off of time. I didn't know if there was anything else you had wanted to add because you were like running out of time.
Oh yeah, well, I had a whole story about one of my clients I could tell, but I think you've all been here a long time and very patient. But and we do have written testimony from WDC. So
okay, thank you.
Thank you.
Sorry, guys, we're not going to do that this hour. All right, we have we have a number of online witnesses who would also like to testify in favor of this bill. So we're going to turn to some of. Oh, we have another question. Sorry, before you step off.
Can I thank to the professor as well. Thank you very much, all of you, for being here. Just very quickly, from what I'm learning, from what I've read while you were testifying, this was felony murder originated in common law in 1600s from England, and it was codified in Maryland in 1809. And it's the term that Charlie Moylan used apparently in his law book, which I unfortunately never had him as a teacher, but maybe you read this, is the implied malice, the implied mens rea. Is there an effort, the question is, and as briefly as we can do it, is there an effort by like the academic world to try and get the 47 states that have felony murder to rethink this and try and move the idea of getting rid of implied malice, which seems to be an inappropriate use in 2023?
Well, I'll give you a quote from one of the law books. They call felony murder an unsightly wart on the face of criminal law. So, yes, there's a huge debate that's been going on for quite some time that this should go away. And if we look back to the time when felony murder first came about in common law, there were very few felonies. And for any felony, the punishment was death. So you didn't have to kind of sort through very deeply what we were talking about when we said felony murder. We've progressed from there, and I suggest to you we should progress tonight in looking at this bill further in that direction.
Thank you.
All right, thank you. All right, now we're going to move on to the online witnesses. And for what it's worth, I think I had this bill at one point years ago. So. All right, so for
yes, Mr. Vice Chair, you did.
Okay.
The adult side of it.
Yes, even more hardcore. Okay, we'll take Judith Lichtenberg first for 2 minutes. You have to unmute yourself when you're ready.
Thanks. My name is Judith Lichtenberg. I'm Professor Emerita of Philosophy at Georgetown, and I'm on the Executive Committee of the Maryland Alliance for Justice Reform. I've also been teaching college courses, tutoring and mentoring incarcerated people at Jessup JCI and at the DC jail since 2016. Through this work, I've gotten to know a number of people serving life sentences or more than that even for felony murder. Felony murder rules are flawed, I think, for two reasons. They're unjust and they're ineffective. First, justice. As others have said, felony murder punishes people for crimes they didn't intend or commit. Sentencing them as if they intentionally killed someone violates the fundamental principle of our criminal justice system that punishments should be proportional to crimes and that intentional killing is a more serious crime than unintentional killing, let alone not killing at all, which is also part of felony murder. In addition, felony murder applies disproportionately, as you've heard already, to juveniles and young adults who don't fully appreciate the consequences of their actions. They're less culpable than older adults and have better prospects for rehabilitation. The other problem with the felony murder rule is that it's ineffective. Some people think it's a deterrent, and that's why we should have it. But it isn't. And the question is, why not? Well, first, only a very few of those charged with felony murder know of the rule before acting. Second, it's not plausible that someone contemplating robbery would risk a 20-year sentence but not a life sentence. One study found no difference in the crime rates of states with or without the felony murder rule. I'm in close touch with several former students who are 20 or more years into life sentences or life plus for felony murder. They're very different people than they were at the time of their crimes and deserve to be released from prison. Incarcerating them, I think, is a terrible waste of human resources. I sincerely hope you'll give a favorable report to HB 1180. Thanks.
All right, next let's go to Emily Virgin.
Good evening, Mr. Chair, Mr. Vice Chair, members. My name is Emily Virgin, and I serve as the Director of Advocacy and Government Relations at Human Rights for Kids. We are a nonprofit focused on the protection and promotion of the rights of children in the criminal legal system. Previously, I served in the Oklahoma State Legislature for 12 years, so I want to thank you for your service to your home state. In 2020, because of the way children were treated in the criminal legal system in Maryland, Human Rights for Kids designated the state as one of the worst human rights offenders in the nation in our state ratings report. The state was penalized in our assessment in part for its application of the felony murder doctrine to children. While it is very important to note that the vital reforms affecting children in the legal system that Maryland has passed since the 2020 report resulted in the state's recognition as the most improved state in the 2022 edition of our report, Maryland is still penalized for its felony murder policy. We support House Bill 1180 because the application of the felony murder rule to children runs counter to international human rights standards that require states to avoid sentencing children by the same guidelines that apply to adults and to consider child brain and behavioral development science when charging and sentencing child offenders. We know, and you've heard many times just today, that because of their underdeveloped brains and diminished capacity for decision making, that children often fail to appreciate the unintended consequences of their actions. And nowhere is this more apparent than in felony murder cases where children can be criminally convicted of murder even though they did not kill or intend to kill anyone during the commission of a felony offense. This bill would help create more age-appropriate charges and sentence, but this does not mean that children who commit crimes cannot be held accountable. It just means that they'll be held accountable for the underlying criminal action, not a loss of life that they did not intend or foresee. So we ask for a favorable report on House Bill 1180. Thank you.
All right, next we're going to hear from Elise Desiderio.
Good evening, all. I'm Elise Desiderio, a post-conviction attorney with OPD, urging a favorable report. I'll briefly touch on points from my written testimony, which I recommend the committee members review. As we know, the felony murder concept started in the 1500s as a way to show implied malice, or in modern words, implied intent to kill. Felony murder as a predicate for first-degree murder was first codified in Maryland in 1809, and now qualifying felonies are listed in the criminal law article at section 2201. While most other countries have rejected the felony murder doctrine outright, 47 American states, DC, and the federal government still cling to it in some way. I'll tell you about a few of those things and what a few states and jurisdictions have done to move away from it. Hawaii, Kentucky, and Michigan have all gotten rid of the felony murder rule entirely. In Ohio, while the doctrine persists as of 2004, many situations that would have sustained a felony murder conviction are now instead considered involuntary manslaughter. California has redefined felony murder for accomplices to make the standard much more stringent. The law also sets out procedures for those convicted under the old felony murder rule to apply for resentencing under the new rules. Colorado lawmakers have removed 2 of the conditions needed for an affirmative defense claim for felony murder, which makes it so that more people can successfully raise that defense. DC has eliminated accomplice liability felony murder for those who did not intend to kill. Today, Maryland too has an opportunity to reduce the harm caused by the felony murder rule as it exists today. You've heard, and you will continue to hear from panelists about the wide variety of harms that it causes and the ways that we can and should move away from it. OPD urges a favorable report, and I welcome your questions.
All right, next we're going to hear from Braden Stinar.
Thank you, Vice Chairman and members of the committee, for the privilege to speak before you today. My name is Braden Steiner, and I'm a third-year law student at the University of Baltimore and research fellow with the Center for Criminal Justice Reform. I'd like to use my time to share a letter from a directly impacted voice. Adnan Khan was the first person to be released from prison following a felony murder conviction pursuant to the recent passage in California of a similar bill to this one. Here is his message for the committee. My name is Adnan Khan. I'm testifying in favor of House Bill 1180 as a person both charged and sentenced under the felony murder rule, as well as a recipient of relief under the felony murder rule change in California. On March 24, 2003, I would commit the worst act of my life. A friend asked me to do a snatch and grab of marijuana from another young man named Kevin McNutt, whom I did not know. The agreement was there to be no weapons. I impulsively agreed. I was a teenager and did not understand how risky my behavior was. Since neither of us had a car, my friend called another young man to be the getaway driver, a man I did not know. Once Kevin handed me the marijuana, what appeared to be a fight broke out between Kevin and the getaway driver. I got out of the car and yelled at him, "What are you doing? Get back in the car." The getaway driver then ran back to the car and we left the scene. I was arrested a few hours later at 2 a.m. and taken into interrogation. That's when the detective told me I was being charged with robbery and murder. I found out the getaway driver was bipolar schizophrenic and was not taking any of his 8+ medications assigned to him. He had a concealed knife on him, which he used to take the life of Kevin. I was 18, charged with felony murder. I faced the death penalty for my first 18 months of incarceration. And after 16 years of incarceration, the same judge who sentenced me to life in prison modified my sentence due to the change in California's felony murder law, and I was released. I am proof that we don't need to throw young people away to make society safer. Thank you for allowing me to share Adnan's story.
All right, we've got Gregory Kadajski.
Good evening, and thank you for the opportunity to support House Bill 1180 today. My name is Greg Kadaisky, and I'd like to start by saying that this is all very new to me. I am not a lawyer or a member of the legal community in any way. I simply had an experience that gave me some new perspective on the judicial system, especially regarding felony murder. In July of 2017, I was tasked with being the jury foreman on the trial of a woman who had multiple charges against her, including first-degree felony murder. The woman and her boyfriend were accused of robbing and beating a man to death in January of that year. Her boyfriend had already pleaded guilty and was already serving his sentence. However, it seemed clear, to me at least, that while she was certainly guilty of the robbery, it was not at all clear that she had anything to do with the murder. Now, prior to being on this jury, I had a limited knowledge of the difference between the various murder charges. So when we were asked to render a verdict in this case, it wasn't immediately clear what the distinction between murder and felony murder actually was. More to the point, once we understood the distinction, it seemed unfair that, given the facts of the case, we were basically forced to render a verdict of first-degree felony murder. In my opinion, the state did not prove beyond a shadow of a doubt that the woman on trial had murdered that man. At the very least, it seemed clear that her boyfriend was the main actor and that she had been an accomplice to murder while also being guilty of robbery. That actually led us to rendering an invalid verdict at first. As I recall, we wanted to find her guilty of robbery and second-degree murder, but the law wouldn't allow it. So upon further deliberation, we were forced to find her guilty of first-degree felony murder. Personally, this didn't feel right to me, especially because, having already accepted his own plea deal, her boyfriend, who seemed more culpable of the murder, ended up receiving a much lighter sentence than she did. Now, as I said, I can't speak for the other jurors on this case, but to me, it seemed that the charge of felony murder forced us to effectively send a woman to jail for the rest of her life, even though I can't honestly say whether or not she was in fact guilty of that crime. Because that felt wrong to me, and because I still believe we should only punish people for the crimes they actually commit, I urge you to support 1180. Thank you.
All right, there don't appear to be any questions for our online witnesses. Thank you very much. We have one person signed up favorable with amendment. Gabrielle Bradley, if you're here, you have 2 minutes to pitch us on your amendment.
Good evening and thank you. My name is Gabrielle Bradley and I traveled from Pennsylvania today to testify in favor of House Bill 1180. I am also the wife of a wonderful man who is serving a life sentence in prison for felony murder. Although he was found not guilty of the actual killing and also found not guilty of the predicate felony. But due to felony murder, which states that anyone involved in a felony in which someone dies can be found guilty of first-degree murder. Even if, like in cases I know personally, the person didn't even have a weapon. In some cases, the person wasn't even at the scene of the crime, let alone committed the actual killing. I strongly believe that one should be held accountable for their actions. And if you commit a crime, there's a punishment that comes with that. But what I don't believe is one should be held accountable for another person's actions, especially those under the age of 25 where it is proven that their brains are not fully developed and matured. But that is exactly what felony murder allows, for one to be held responsible for another person's actions. So for that reason, I urge a favorable report on House Bill 1180, but I will also urge an amendment to include those under the age of 25 who have already been affected by this harsh, unjust, and unfair felony murder rule. Thank you so much for your time.
All right, it doesn't appear like there are any questions for the witness either. We are going to bring up a few unfavorables. Stephen Kroll, Scott Schellenberger, bless. And we have some folks online maybe, Vince McAvoy and William Katzif.
We have Ms. Wilt here.
Okay. Do we have Vince McAvoy? No, okay. All right, so it's just the three of you whenever you're ready.
Mr. Vice Chair, ladies and gentlemen of the committee, good evening. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases, including felony murder cases, since 1984. couple things we need to clear up that the proponents said that do not apply and are not correct. First, there is no felony attempted murder. That's not a crime. And to say it is, as one of the proponents did, is wrong. Professor mentioned manslaughter. Felony murder is first and second-degree murder in the state of Maryland, is not manslaughter at all. So those corrections have to be made. To Delegate Williams, they talked about just being parole. They passed the juvenile JRA. Remember, 3 times you could ask for a modification if you're a juvenile under the age of 18. So it's more than just parole. Those are options available as of last year that were not mentioned by the proponents. What's the best way to look at this? Well, when we're asking for an unfavorable report as to House Bill 1180, I'd suggest the following. Look at George Floyd. Now, there is no strangulation in Maryland. I repeat, there is no strangulation in Maryland. But substitute any of the felonies that are listed in this bill, any of the felonies that a police officer could commit. How were the defendants convicted in Minnesota if applied to Maryland? And again, not strangulation. It's by felony murder. That's how they were convicted. They didn't do anything except stand there. Maybe they did more, but for the most part, they allowed it to happen. Therefore, felony murder. So substitute any of the crimes here and you get felony murder. That's the best way to understand it, and that's how they were convicted. If the people that Mr. Schellenberger mentioned, and I said this to Delegate Taylor when she mentioned it, if there wasn't felony murder, they'd be in juvenile court. They're not applicable to adult court. So that's where felony murder comes into play. So if you look at what's available to the state, it is a tool that's been around and a tool that's necessary. And for those reasons, we'd ask for an unfavorable report as to House Bill 1180, and I pass it over to Mr. Katzif at this time. Thank you.
Mr. Chairman, members of the committee, my name is William Katzif. I'm an assistant state's attorney from Anne Arundel County, here on behalf of the Maryland State's Attorneys Association in opposition to House Bill 1180. Now, first of all, this particular bill indicates there's going to be a difference between somebody who's 25 and 24. All right, someone who's 25 presumably could be convicted of felony murder, whereas someone who is younger cannot. Now, I see absolutely no reason why you draw a distinction between a 24-year-old and a 25-year-old. Let me bring out a couple of other points. Number one, with the whole concept of felony murder. First of all, we're not just talking about any felony. We're talking about a violent felony. We're talking about a felony such as armed robbery or carjacking, armed carjacking, where in all likelihood there are persons that are involved in the crime that are carrying a gun. Now, any gun that's in the hands of the wrong individual is a potential homicide. It's a homicide waiting to happen, especially if they are determined to commit a crime such as armed robbery or carjacking. That is a homicide waiting to happen. Now, I realize that it may not necessarily be that was the intent, but that is a very likely consequence of something happening during the course of a robbery where something goes bad, someone gets nervous, and all of a sudden someone is dead. And I would point out another thing. Suppose, for instance, I have a situation where you have two people, one who's 24 and one who's 25. They're both carrying guns. They go into a liquor store, a convenience store. Someone is killed. Now, we have absolutely one shot is fired, someone is killed, but we know they both had guns. The police are able to make an arrest based on information, but they can't determine precisely who was the trigger man and who was the accomplice. Okay, let me if I could just finish this. How would each is interviewed and accusing the other. How do we successfully prosecute a murder on the theory of felony murder where we have two people, one 25 who can be convicted of felony murder, the other is 24 who may very well be the trigger man? We can't just determine which one it was. There's absolutely no reason to change the existing law, and I would strongly urge the committee to give it an unfavorable report.
Good evening. My name is Laura Wilt. I am a prosecutor in Frederick County. Been doing it for 26 years. I am here testifying against the passage of this Bill 1180. The argument against felony murder is, the argument I'm hearing today is an argument against felony murder as a whole. And the rationale is that when you purposely and intentionally commit one of these inherently dangerous felonies that society decided that you would suffer the consequences of that behavior. So the state cannot find someone guilty, cannot bring them in, well, you can bring someone in, hypothetically, but you will not be found guilty because you are at the scene of a crime. The state must prove that you intended to commit the underlying felony in order to be able to go forward on the felony murder. It's not you're at the scene of the crime and you're guilty of felony murder. That's just not the law. I would argue that if we see a problem with the felony murder, that this bill and this proposal goes way beyond what the problem that was identified is. If you want to address the sentence, address the sentence. If you want to address the definition, the mens rea, address those things. That this goes way beyond, and I would urge an unfavorable report.
Delegate Cardin and Young.
Thank you very much, Mr. Chair. Thank you guys very much for coming in and testifying, as always. Going back to Mr. Katzif, your scenario, your hypothetical, it seems like you want to be able to have leverage. You want to use the felony murder as leverage, whether it's you're not sure who the trigger person is, or you want to be able to let somebody know that they're exposed, they've got serious exposure, so maybe you can use that to help them identify or provide further evidence. It seems to me that those aren't fair because one person, in that scenario, one person actually murdered the individual and the other person didn't. But yet, you want to be able to use the felony murder so that you can put both away, even though only one person actually murdered them. I mean, to me, it seems like there's a cognitive dissonance here where, because I understand that they're committing a potential violent crime, but they're not. If they didn't pull the trigger, why are we? I mean, philosophically, why are we doing it? And then I'm just gonna add to that, to the gentleman I think his name was Greg, who spoke, the juror who spoke, who said, look, the one person copped a plea, and he got 15 years. And then the woman who didn't have anything, they all agreed that, or not, maybe not all agreed, but most of them agreed that she wasn't actually involved in the murder. She may have been involved in the violent crime, but not in the murder, that the other guy was the murderer. But yet, she wound up going to jail for a lot longer because she didn't cop a plea. It just seems to me that there's some sort of cognitive dissonance here about using felony murder to put people away who didn't actually pull the trigger.
Delegate Cardin, is there a question?
Well, I mean,
I think you began by asking me if we're trying to gain leverage. I'm not trying to gain leverage. I'm simply saying two people went in there with bad intentions. They went in there to rob. They both had firearms. Obviously, one of them they were both principals in the first degree to the crime of armed robbery. No question about that, right?
Mm-hmm. Yep.
Okay. In the course of the robbery, someone was killed. One person fired a gun. We don't know who that person is. We cannot determine that. Each is accusing the other. So I'm going to rely on the testimony of one of the accomplices, okay? Again.
And do you think that Louis Brandeis would say, yeah, it's okay to put both of them in jail for murder because we're not sure which one did it?
With Louis Brandeis? I don't know what Louis Brandeis would say.
Louis Brandeis said you don't it's better to have 9 guilty people go to jail than one innocent person. 9 guilty people go free than one innocent person go to jail.
Yeah, he meant it. Well, I mean, first of all, we're not talking about innocent people. We're talking about two people that were principals in the first degree to the crime of armed robbery. Okay. Now, first of all, as I said before, when two people are walking in there with guns, that is a homicide waiting to happen. Now, it may be that only one of them actually fired the fatal shot, but the fact is they went in there with the same intentions to rob the place. They had guns, and the possibility of someone being killed was was pretty high, okay? Now, the question is, what happens? Does the 25-year-old, catch the felony murder charge and the 24-year-old avoids it because we can't determine with any degree of precision who it was that fired the fatal shot because each is accusing the other, and we have no additional evidence of that.
Yeah, okay, thanks. Thank you.
Delegate Young and then Phillips.
Thank you all for being here today. Thank you, Mr. Chair, Mr. Vice Chair. My question is this. Is it true, was it correct, that an individual could be killed by a law enforcement officer who's effectuating an arrest, and the defendants would therefore be charged with felony murder?
I know that was the case at one time. I don't know whether or not the felony murder rule has been tightened so that in that situation, say the proprietor or say a police officer were to shoot one of the assailants, whether the other one would be subject to the felony murder. I know at one time it clearly was. I don't know if that's the current state of the law.
At this point in time, the last time I looked at a Bar Association question, which is where last time I saw that, the answer was yes.
That was, I think, earlier we heard...
My case was 1979. The answer was yes.
Yeah, earlier we heard the testimony about law school. I think that's the hypo that I recall from law school. And so I just raised that for consideration. Because certainly in those circumstances, we're talking about burglaries or something like that. And, an individual could be killed by the law enforcement officer. If me and Valentine... Valentine would never, though. Were to be...
He's looking at you.
But certainly, if someone in their accomplice was doing a crime and the law enforcement officer killed the accomplice, certainly the person who remained alive didn't intend for their accomplice to die. But my understanding of the law, and it sounds like yours is too, is that person who still remained would be subject to felony murder, particularly if they were simply doing... not simply, but, if they were doing a burglary, which obviously, in the hypo I presented, there's no circumstance where anyone else was in danger, potentially.
And if it's one of those that are listed in which burglary is, just to tell you, Delegate, you're exactly right. My memory of the bar exam, I will check it just to make sure, but I believe you're correct.
Just raising it for you all's consideration.
But I just would point out, you took the bar exam a little bit later than I did, but I still got to check.
And I would certainly argue that that's the argument against felony murder as a whole, whereas this law is very particular with an age and addresses a different issue, I would say.
I think it addresses both, but in a more narrow way. And I would actually be in support of removing the age, and getting rid of felony murder completely. But again, thank you all for taking my question. Thank you, Mr. Chair.
All right, thank you. I don't know how you guys remember your bar exam questions, but anyway. Delegate Phillips and then Conaway.
Delegate Moon, we will not get into the rule of perpetuity this late in the evening.
Thank you. I don't remember one question that was on the bar. I think, I'm sorry, the young lady to the end.
Yes, I'm Laura Will.
Not Miss Laura Will. You mentioned that society kind of made a decision, and that's where felony murder kind of arose. Common law carried over, Maryland held on to it. Isn't it fair to say that society does change and values change?
Absolutely, and actually that made me dive into the sentencingproject.org reports that 48 states still have felony murder. There's only 2 states, according to this website that I just pulled up, Sentencing Project, they're saying only 2 states have gotten rid of it completely. So, I think we should look into what's the definition of felony murder, how is it proved? I think that's worth a deeper dive. Society does change, we learn things.
And in many of those states, there have been adjustments to their felony murder statutes, as I understand it. Right, it varies significantly, isn't that so? I want to, Mr. Kroll.
Yes.
You talked about George Floyd, and I got to call you on this one because I think you're mixing apples with oranges when you bring that one up. Do you know what those officers were actually charged with?
They were charged with murder.
No, yes, they were, but they were charged with aiding and abetting. It was not felony murder.
But if applied here, my point was, and I make this point, if applied in Maryland, it wasn't strangulation, but trying to give an example associated with it. It's in Maryland, and it was one of the crimes listed in 11080. Was just my point. if you
But
take
there were
that-
other things that they could have been charged with
Absolutely.
here in Maryland as well.
Absolutely.
I just want to be careful about
Oh, I understand. I was just trying to
the-
associate, whether it's police officers, especially police officers or not, Delegate Phillips, I don't want the guilty to go free. And I want to use every tool possible. And I don't want in a law enforcement situation, if they committed one of those crimes and they stood around, and not the person who actually did it, because that person deserves to be charged with murder. Obviously, we could agree upon that. But I don't want people saying, I didn't do it, therefore I should go free. We have those tools available.
So if they participated in a felony, then they could be charged with the felony.
They could charge with the felony and charge with one of these in 1180, felony murder.
I understand, but if we're looking at particularly a younger person, we've heard all the statistics about, brain development, decision making, etc. Once again, this is a carve out in what Delegate Crutchfield has brought us as sponsoring. With the change in the juvenile justice kind of reform, you do not think that there is an opportunity to address an issue for younger people?
We're talking about 24-year-olds here. I don't consider a 24-year-old a young person. That same person can become a police officer who could commit one of these crimes in 1180. They're old enough to be a police officer. They're old enough to be a legislator here. They can sit here. And they're not young.
Thank you.
All right, Conway and then Eric Hand.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. I'm so happy. I'm so happy. My question is, why wouldn't you charge both people with a lesser crime? And I just want to say that I believe it was last week I brought up the example of people being guilty, and the actual quote is 10 guilty persons go free. It's better for 10 guilty persons to go free than one innocent person to be convicted. And that is stated to come back from Roman law and then comes through a 1769 doc. So if you wouldn't mind answering my first question.
I'm not sure what the question is.
Well, I was bringing you up to date on what one of the delegates was asking about, but my question is, why wouldn't you charge both of the individuals with a lesser charge than both of them with a greater charge? Instead of both of them getting the felony.
Well, if you're the victim of a crime, and that victim says, Mr. Kroll, why don't you charge what's available? And felony murder is available for the sake of the victim. Why wouldn't we charge it, is my question to the victim.
Because you can't figure out which one person pulled the trigger and which one person didn't. So therefore you think that you should charge both people with pulling the trigger when you know there's one bullet, one shot, but two guns? Is that what you're thinking? Is that what you're saying?
I'll let Mr. Katz.
That's what I said. I said if you have two people who are similarly engaged in a violent felony, such as armed robbery, such as armed carjacking, okay, that in the event that someone is killed, we can't determine which one did it, that they're both responsible for the foreseeable consequences of committing a violent felony when that violent felony involves the use of a firearm.
Sure, I understand that, and I understand your passionate tone, but when I was a younger person, I was confronted with the example of if your friend asks you to drive them to the liquor store and they go in and do the robbery and murder someone and jump in the car and they say you were with them, I mean, both of you get charged with that murder. And you say, well, I didn't know. And then a person like you, it seems you're going to say, oh, you were with them, so you two conspired to rob that liquor store.
No.
Now, you're going to tell me no. I know you're going to tell me no. But
I want to make sure that I understand.
I'm going to tell you what is said in my community. You're going to charge both of us with that murder. Unless this guy doesn't know my name, then I was just hacking. You see, I already know about this example. So go ahead, tell me what you're going to tell me. Thank you very much.
That's all right. Delegate Conway, the only thing I was going to say, if we're talking about someone who was not the driver of the car, who drove the people that went inside with guns, but somebody was just
said is not the driver of the car.
Someone who just happened to be in the car?
No, the driver of the car drives a person to the store. They're hacking. Hacking means they're illegal taxi cabbing. They're doing something for gas money. The person goes in the store, robs the store, comes running out and say, let's go. You don't know that you just drove this person to rob the store. And they murder somebody and they keep going.
First of all, you didn't go in, you didn't know that the crime was going to be committed. Why would I charge him with murder?
Well, they do. They do.
If I thought that the person that was driving the car deliberately dropped two people and acted as a getaway driver for two people that he knew was committing a violent felony with guns, that's one thing. If we're talking about someone who happened to drive up to a liquor store with two other people, had no knowledge of the fact that those two people had guns, was intending to rob the store, why would I charge them?
And the way that you prove that that person didn't know that that this people were going to rob the store, or most likely didn't know, is that when you interrogate the people that you think did the shooting and they don't know the person's name, that's the driver, that means they're not associated. That means the person was probably hacked like they tried to.
I'm sorry, guys.
I think.
Yeah. So just for if people have hypothetical scenarios, we're going to take those into offline conversations to trap just because of the hour. But let's continue on. We had Erican and then we got Erican. All right, we'll stick with that.
Thank you, Mr. Chair. Thank you guys for being here. Lots of interesting hypotheticals. I'd just like to know, could you just tell me again, Mr. Kroll, what is in 1180? What are the crimes that you can get? What are the felony crimes?
Arson in the first degree, burning of a barn, and things associated with the burning of the barn that I'll move forward at 9:30 at night.
Yeah.
Burglary in the first, second, and third degree, carjacking or armed carjacking, escape in the first degree, kidnapping, mayhem, rape, robbery, sexual offense, robbery under 3402, 3403, sexual offense in the first or second degree, sodomy as a crime after October 1st, 2020, and a violation of 4-503 concerning destructive devices.
Okay.
Those are the crimes.
Okay. So let's say that with the Amy Caprio case, we didn't have felony murder. What were the three young men who were not the drivers of the vehicle? What would they have been charged with?
Well, even though I was in Baltimore County, I'm very good friends with Mr. Schellenberger. I'm not familiar exactly with the facts of the case, but I know there was burglary charged.
Yeah.
And that would have put them in juvenile court.
Juvenile court.
Yes.
Okay, thank you. That's exactly what I wanted to know.
All right, this might be the last question. Delegate Tomlinson.
All right, thank you, Mr. Vice Chair. So we're seeing the number of murders and violent crime go up every year across the state. Governor Moore, I mean, he's made a point of saying that crime and public safety is one of his top priorities. He just said last week when, I believe when he announced the new superintendent of the state police, he made a point of saying that violent crime, murders, and even non-deadly shootings has just about doubled over the last couple of years. So all day and night, yeah, this did start in the day. Now it's whatever time. All day and night we've been hearing about how, harsh sentences like the supposedly harsh sentences, I use that word loosely, supposedly do not discourage crime. So my question is, okay, if things like this don't discourage crime, if this bill passes, what kind of messages does this send to people out there?
Well, let me just add one thing. I'm a prosecutor, not a politician. I'm not a social scientist. I have an undergraduate degree from the University of Maryland of Criminology. So I do know one thing. People think juveniles are not smart. Juveniles are very smart. When the word gets out on the street that they get away with something, they're going to get away with it. Good defense attorneys like Delegate Cardin, who is not here, but a good defense attorney like him, are going to tell his clients what to get away with and what not to get away with. And the word spreads fast. What I can tell you after 39 years of doing this is word spreads fast on the street, juveniles are smart, and they're going to try to get away with anything they can. In fact, most criminals are going to try to get away with anything they can. I am confident, and I'll say this here, that there is hope. And I think the governor is going to give the resources that he said he's going to do, and I'm confident he's doing the right thing. I support that. And I'm confident we can turn this around. And one of the ways to do it is to show people, not that you can commit the crime, do the time, but there's responsibility to victims and witnesses who I care about. And I think given that, the governor's resources, given the fact that we do hold people responsible and accountable and truly mean it, we could turn this around. And I'm confident of that. But again, I'm just a dumb old prosecutor, not a politician.
And if I could add just that common sense, everyday approach, I'm a mom. If there's not a stinking consequence, my kids are going to act differently. So I think you can find a statistic for anything that you want to support. I mean, it's true. We can define things and find the statistic. But real life, we all know the people in our life, if there's not a consequence for me, I act differently. I mean, let alone kids. So I just got to throw that up.
Thanks. All right, thank you very much. That's going to end the hearing on House Bill 1180. We're going to move on to the last bill of the night, House Bill 96, Delegate Crutchfield. 28 witnesses, probably not all still here, but we'll see. All right, Delegate Crutchfield, and we have you with Marlon Tillman, Keith Wallington, Markeisha Bennett, Melissa Miller, Jenny Egan. All right, Delegate Crutchfield, whenever you're ready.
All right, thank you very much, Mr. Chair. All right, last bill of the night, HB 96. For the record, I'm Delegate Charlotte Crutchfield, representing District 19 in Montgomery County. And I am here to testify in favor of HB 96. My first job as a lawyer was as an assistant state's attorney for Montgomery County. It was an experience that taught me about advocacy and the lasting impact that the criminal justice system has on young people. I am also a single working parent of a young Black man, now a college junior and a computer science major at Hampton University. I think about both of those experiences when I tell you that children as young as 14 years old can be automatically charged in adult court and may have to wait nearly 6 months, sometimes in an adult jail, before a judge decides whether they will stay in adult court or be moved to juvenile. I think about both of those experiences when I tell you that over 80% of the children automatically charged in adult court are Black children, and that 87% of those children who are charged in adult court do not end up with an adult criminal conviction. We are unnecessarily churning hundreds of Black children through a brutal process during the most important and formative years of their lives, when they could be assessing health, guidance, counseling, and life skills training during those critical months and years. The issue has been studied and debated. The literature, the science, and the moral necessity of ending this practice are clear. We need to get this done, and we need to get it done this year. You will hear arguments that the juvenile system doesn't have enough time for older kids to be treated. There will be a lot of conversation today about what is or is not an adequate response to some of the most violent crimes that can be committed. I need you to keep in mind that nothing in this bill prevents the state's attorney from moving a child to adult court, and nothing in this bill prevents a child from receiving an adult sentence. The YES Act will simply start the case in juvenile court so that a judge that has training and experience can consider all the relevant factors, including the nature of the offense and the time the child has left to be rehabilitated in the juvenile system. And at their discretion, they decide where a child should be placed. According to decades of research, youth are tried in the adult criminal system are 34 to 77% more likely than youth retained in juvenile court system to be rearrested for a crime. This recidivism increasingly affects the transfer of is strongest in causing violent crime. This holds true in Maryland as well. The 3-year reincarceration rate for young people under the age of 25 released from DPSCS is 300% higher than young people charged automatically in adult court, moved to juvenile, and then treated in DJS committed facilities. But in light of these concerns about the most serious crimes, today we have an amendment that has been negotiated and agreed upon by the advocates, the Attorney General's office, and the Department of Juvenile Services. The amendment would end automatic charging for the vast majority of cases, but continue to automatically charge in adult court 16 and 17-year-olds charged with murder and first-degree sexual assault. We further agreed to a provision where the AG or the state's attorney can also indict a young person if they are involved in an organized effort to commit a series of violent crimes, like as a series of armed robberies or carjackings. We believe this amendment strikes the right balance and fixes the inefficiency in the system so that the vast majority of children whose cases should be in adult court start their cases in juvenile, where they can receive services, intervention, and support. For this reason, I urge a favorable report on HB 96. Thank you.
All right, thanks. And I think we've got one more person up here than I called. Do you guys happen to know? I have Marlon Tillman, Keith Wallington, Markeisha Bennett, Melissa Miller, and Jenny Egan.
I think Josh came up early. Our apologies.
Not a problem.
See you soon.
Yeah.
I told him.
Too eager. All right, whoever would like to go first.
Good evening, Reverend Dr. Marlon Tillman. Good evening, Chair and Committee. Bridge, Maryland Incorporated offers this moral imperative from the members of our interfaith organization. Children and teens are at risk of emotional, cultural, and situational trauma if they are placed in adult situations prematurely. Our sacred text teaches us that children are an inheritance from God, and that God wants our children treated justly, and treating children and teens like adults in callous, disposable ways affects our children's future and offends the creator of us all. The Yes Act is what Michael Eric Dyson meant when he said, justice is what love looks like when it speaks in public. Mr. Dyson is referring to agape, which is the Greek word for unconditional love, a love that sees everyone as human beings. So what upsets the members of the faith community is that opponents want to classify teens as adults, as if they have the same cognitive abilities as adults. However, since science has proven that that is false, the same way it was false to classify people of color as inferior, which would justify dehumanizing them with statutes, rules, and laws. Opponents want to live out by the Old Testament theology of an eye for an eye, which only leaves everyone blind to the truth that love is how justice prevails, particularly for children that cannot vote for lawmakers that determine their quality of life. And if we continue to put teens in the adult penal system, they may never have the right to impact democracy in this country. What disturbs members of the faith community is that opponents want to classify teens as adults as if they were unredeemable, because any reasonable person knows that the adult prison system is not designed for rehabilitation, but for perpetual incarceration. The Yes Act is a common sense step in the right direction to curb dehumanizing our children who need care and not cages. We implore you to vote in favor of HB 96. Say yes.
Thank you, Mr. Vice Chair, members of the committee, for bringing this bill to a hearing. My name is Keith Wallington, and I'm with the Justice Policy Institute. HB 96 is a racial justice bill that will improve public safety. When you have a state that leads the nation in racial disparities by far, then it would be irresponsible for this not to be a racial justice legislation. Maryland not only leads the nation in racial disparities in the justice system, but it is particularly pronounced in the young adult population. In addition, and of great concern, the declining youth incarceration rate has not benefited racial groups equally. Black youth are overrepresented in confinement. Despite all of the reforms, recent reforms intended to improve the juvenile justice system, judicial waivers in 2017 were the most racially desperate in 40 years. State data provide a window into these worsening racial and ethnic disparities. For example, in Florida, of the 1,115 youth under 18 years of age certified to the adult court, 79% were youth of color. Similarly, of the 677 transferred for violent offense, 81% were youth of color. These numbers indicate that while youth transfers are being used less often, an increasing percentage of youth sent to the adult system are young people of color sentenced for violent offense, despite findings that youth of color are engaged in acts of violence at similar rates with white youth. Black youth are more likely to be admitted to prison for violent offenses. According to a 2017 American Community Survey, black individuals under the age of 18 comprised 14% of all youth, while white youth accounted for approximately 68%. Despite this, black youth represented approximately 54% of all youth who were judicially waived to adult court. I'll stop there and ask for a favorable report for HB 96. Thank you.
Thank you. Good evening. My name is Melissa Miller, and I'm here to testify on why I support the Yes bill. I don't take being here lightly, and I earnestly considered coming here to testify on this bill. I want to tell you why hearing from me is important. I started my law career as a law clerk, and I went straight to the prosecutor's office. I was a prosecutor in Prince George's County for 10 years, 2 of which I was the chief of the juvenile division. If you would have told me a year ago, and after 10 years I went into private practice. If you would have told me a year ago I would be supporting the yes bill, I would tell you absolutely not. Even though I also am a mother of 3, and I believe consequences affect children. How it does, but it will not always. I have a child, one of my children, I had to guide through high school and stand with him. If he did not have me as a parent, he would be in the same situations as many of the kids in the juvenile system or the penal system are. We deal with this a lot. And as the state's attorney that was here before says, why did I change my mind? Well, society changes and we learn things. What have we learned? We learned that, it's like Tomlinson said, what we are doing is not working. We need to fix this. How do we fix it? Well, we know that our recidivism rate is high. We know that the criminal system, probably 60% of cases that I deal with that are charged as adults, juveniles that are charged as adults, do not get any time. Wouldn't it have been served a purpose if they went straight to the juvenile system and got wrapped around services? If their parents were brought in, if they were forced to pay restitution, if they were dealt with dignity and dealt with consequences? Because what we are doing now is we are sending our children into a system where they are getting nothing. They're getting nothing except they come out. We're putting broken children in a penal system where they come out more broken, and we have to fix this, and this bill is the answer.
Good evening. My name is Dr. Markeisha Bennett. I'm a licensed clinical psychologist in Prince George's County, and I also conduct psychological evaluations for the purpose of transfer and waiver hearings since 2018. In my experience conducting these evaluations and testifying in the court, there's 2 things that stand out to me, 2 opinions that I often encounter from lay people within the courts. The first opinion that I often hear in variations is, if they're grown enough to commit the crime, then they're grown enough to deal with the consequences. I want you to consider just a different view of that. Children and teens, they're not grown at all, and the science demonstrates that. They don't reach maturity until 25 years old. What's not clear in the literature, but I've observed and is also in the research, is that trauma impacts their ability to also mature as well. And a lot of the children that are involved in the court systems have been traumatized. They've been victims themselves. So automatically charging youth as adults and the entire waiver process, as I've observed it and have evaluated children in it, it's not only stressful, but it's traumatic in and of itself. These children are detained, or they're in the community hanging in limbo and uncertainty for months and sometimes up to a year at a time. In my evaluations, a typical juvenile evaluation is 3 hours, but because I'm tasked with evaluating trauma, my evaluations can be 9 hours sometimes and meeting them over multiple times. So these children are opening up to me, exposing their trauma histories, and then I go and I testify and put all of their stuff out there. What then is learned from that? The only thing that they gain in that experience is how to be re-traumatized and learn how to survive that situation. And from that experience, they just become re-traumatized, and it doesn't deter them from committing crimes. It just causes them to figure out how to cope. And I urge you to move in favor of supporting this bill. Thank you.
Thank you so much. Vice Chair, members of the committee, my name is Jenny Egan. I am a youth public defender in Baltimore City and a proud resident of District 45. I want to state unequivocally that the reason that Maryland started sending a disproportionate and inordinate amount of children, more than any state does automatically per capita except for Alabama, and more in number, in raw number, than any other state than Florida, is because of the myth of the super predator. The myth was advanced by a combination of political scientists, prosecutors, and a media frenzy that painted Black children in the late 80s and early 90s as somehow less than human, who had no redeeming qualities and should be warehoused in adult prisons for the rest of their lives. This myth has been disproven and should have long been left in the dustbin of history. But the laws and policies passed in support of that racist idea are still on the books. And one of those is this measure. The number of offenses was drastically increased in 1988 and then again in 1994. But we know, according to decades of research, we know that it does not work. Youth charged in the adult criminal system are 34 to 77% more likely than youth who are retained in the juvenile system to be rearrested for a crime. In other words, charging children in adults is part of what is driving crime and violent crime in the state of Maryland. You will hear from opponents that the juvenile system doesn't work and that it's too soft. I ask you to remember two things as you listen to testimony today. One, nothing in this bill prevents a child from being tried, sentenced, or sent to adult prison. Nothing. This is about where the case starts and letting a judge decide which children and cases should be moved up to adult court. And that's because 87% of children charged in an adult court do not end up with an adult sentence. And 60% of that tiny fraction that do go to adult court come home before the age of 21. If we want a system that works, then we need to fix this inefficiency, start cases in juvenile court, and prosecutors can move them up if they warrant that.
Delegate Boucher.
Too early in the day? Sorry.
Thank you, Vice Chairman. Earlier today, we heard traumatic experiences of adults who experience sexual assault. Is there data to show that the juveniles who are put in adult facilities are suffering from physical and sexual abuse, and are they being traumatized as well into their adult life?
Thank you, Delegate Boucher. There is plenty of evidence that children who are charged in adult court are at much higher risk of sexual assault and physical assault in those systems. We also know that the clients that I represent every day are cognitively challenged. They have much higher rates of cognitive deficiencies, as well as mental health histories, right? Adolescence is when psychoaffective disorders start to emerge, right? So sometimes kids are acting out and they don't even know why. But we also know from all the literature that children charged, and especially children charged in adult court, are disproportionately victims of trauma and abuse in their early years.
So that leads to long-term trauma for them as adults and potentially stunts their recovery?
Yes, that's correct. And that's why we don't, the thing that Dr. Bennett said that was so important is that when you incarcerate a child or a traumatized child, you can freeze them in that development, right? We want a rehabilitative system so that kids can work through that trauma and have access to counseling, which they do in the Department of Juvenile Services. Children committed in Department of Juvenile Services have access to weekly therapy, dialectical behavioral therapy, cognitive behavioral therapy, good evidence-based programs that are not provided in any program in DPSCS.
Thank you.
Okay. Guess we're going to move on to the next panel of favorable witnesses. Phil Karoom, Gordon Pack Jr., Lavelle Kennedy, Nick Maroney, Josh Rovner.
Yeah, no, that's going to be your shirt. Yeah, that's going to be your shirt.
Do we have 5 here? All right. That's all right, fine. All right, whoever would like to begin.
All right, I'll begin. Again, Phil Karoom speaking for Major, not for the Maryland court system today, although I'm going to draw in my testimony on many years of experience as a juvenile prosecutor, a juvenile magistrate, we call them now, and a juvenile judge, to tell you especially 4 procedural points why HB 96 is a good bill. The first is that you should realize that there's no savings of time or money by having direct charging in adult court, because in 99% of all cases, there's going to be a waiver hearing, whether it is a waiver with the defense lawyer trying to send the case back down to juvenile court, or a waiver with the state's attorney trying to send it up. It's going to take the same amount of time, and there's going to be a waiver hearing anyway. The second point is that if we are concerned about time, it is way better to start the case in juvenile court, because in juvenile court, that waiver hearing will take place within 30 days after the petition to send the case to juvenile court is filed. In adult court, if it's charged as an adult case, it may be 6 months, it may be more. And in all that time, the juvenile is probably languishing, probably in a local detention center, almost in solitary confinement, getting no treatment at all. The third point is that whenever the case is started in adult court, it is going to have a permanent impact on this child, whether or not the charges are dismissed, whether or not it's sent back to juvenile court, even if the child is found not guilty or guilty only of a misdemeanor, because those charges in the adult system are going to be there indefinitely and are difficult to expunge. The last point is the decision to put the case in juvenile court is one which should not be made by a prosecutor who doesn't know anything about the background of the child except perhaps the prior record and what this offense is. It should be made by a juvenile judge who's trained to understand the developmental issues and the treatment that's available in the juvenile system, as well as being made after a full hearing where all parties have the chance to be heard, rather than just preemptively being made by a state's attorney who may be more concerned about what's in the newspapers. For all those reasons, we'll ask you to give a favorable report to HB 96.
My name is Lavelle Kennedy. Good evening. When I was a juvenile at a young age, I made a mistake in high school that could have caused me a long time in my freedom. I support the Yes Act because when I was a teenager, I ended up in the system early. Sometimes it's crazy because when you're a teenager, you could be charged as an adult. And you are threatened with your early adulthood being taken away from you, not knowing when you're going to come home or if you got a chance to come home because of a mistake you made that you could have learned from. I support the Yes Act because in high school I was supposed to be graduating. It was the end of the school year. I got into a situation where I was arrested at 17 and charged with armed robbery. In that situation, I feel as though it could have been resolved in school between juvenile court or our parents. I did not learn anything from going to jail. Getting arrested at a young age, I felt embarrassed because my friends seen me walk away in handcuffs from school. Felt like I threw my whole life away. I made a mistake that I can't make up for or come back from. That's how I felt when I first got arrested and taken to adult jail. It felt like I threw my life away. My name and my picture was on the news. As I grew older trying to get employment and find jobs, I ran into problems. I say, when you're young, you're easily influenced by your peers, and you might not recognize or understand what you're doing might be wrong. If proper rehabilitation is in place for a teenager or young adult, they could grow and learn from their mistakes instead of having to grow up in harsh environments for career criminals. They should be able to start somewhere and get the mental help and counseling that they need to send them in the right direction so they don't have to repeat the same mistake that they did. Say if a young person starts off in juvenile court, it gives them a chance to recognize where their life could have went if they keep making the same mistakes. I feel as though all cases should start in juvenile court because when you're under 18, our brain's not fully developed till we like 23 or 25. That's all I had to say right now.
Good evening. I'm tired, so I know you're tired too, so I'm not going to be long. My name is Gordon Pack, and I was adjudicated in the adult system as a 15-year-old. In hindsight, I believed I deserved to go to prison. and I'm very sorry, and I've been doing everything I can to atone to the direct and indirect victims of my crime. I support the YES Act because I question whether the practice of automatically sending kids to the adult system because they committed a violent crime is a necessary injustice. As a 15-year-old, I can tell you when I went through the system, neither the police that arrested me, the state's attorney, the defense attorney, or even the judge were prepared to deal with me as a child. It wasn't their job. They weren't juvenile counselors. They weren't clinicians. They didn't know anything about adolescent psychology. They treated me like an adult because that's what the system called for. As a kid, I was intimidated by the system. All I said was one-syllable answers the whole year process it took before I pled guilty, and they sentenced me to life in prison. I do believe that some of us, kids, may need to go through the adult system. I just don't believe that should begin from the beginning, as soon as they commit the crime. It shouldn't be based on that. The juvenile system is better equipped to deal with that particular issue because they have the background to do it. So for this reason, I ask that you vote favorably for House Bill 96. Thank you for your time.
Thank you, Mr. Chairman. My name is Josh Rovner, the father of 2 teenagers. I'm here as Director of Youth Justice at the Sentencing Project. We endorse the YES Act as a common sense approach that will at last bring Maryland in line with the rest of the country. Maryland has long been an outlier when it comes to automatically charging our youth as if they are adults based on the offense. We were just the second state to enact such a law, and in the years since, we've added charges at a faster pace than almost any other state. So today, Maryland has 33 charges that automatically start a young person in adult criminal courts. So by comparison, Virginia has essentially 2 charges: murder, divided into 4 categories, and aggravated malicious wounding. And in 2020, our neighbors to the south became one of 40 states this century to roll back its pathways into the adult courts. Per capita, only Alabama sends more of its kids into adult courts based on the charge than we do. This bill, as introduced, would make Maryland a leader, but hardly an outlier in youth justice. Starting every single case in juvenile court is already the law in 8 states. Those states are California and Hawaii, Kansas and Kentucky, Missouri and Oregon, Tennessee and Texas. Kentucky joined that list in 2021. In those states, as under the original and amended drafts, teenagers can be charged in criminal courts after a hearing in juvenile court. It's a good policy. The evidence shows youth charges if they're adults are more likely to reoffend than similarly situated youth held in the juvenile courts, and there's no deterrent effect for other teenagers because you see high school sophomores don't follow along with their state's criminal codes and are not motivated by amendments to it. My written remarks cite many studies, including from the CDC and the National Research Council, arguing against statutory exclusions. So this tough-on-crime approach foolishly creates more crime, not less. This is unapologetically a public safety bill. Thank you.
I will defer to you, Mr. Maroney, because I think I may be officially on the next panel.
Good evening, Chair, Vice Chair, members of the committee. Nick Maroney with the Juvenile Justice Monitoring Unit out of the Attorney General's office. We perform unannounced visits to the juvenile justice deep end of the system, the detention centers, the placement centers for kids. There's no such equivalent in the adult system to try to see if there are services and that people are being treated appropriately and not being abused, at least until you guys pass the badly needed ombudsperson bill. There's nothing to oversee that billion-dollar enterprise. In the meantime, to talk about the automatic, relatively recent practice of the automatic prosecution, I'm sorry, I do think it's persecution, but prosecution of kids as adults. takes away the balance afforded by decisions that a court can make, that a judge can make, that a magistrate, if we're still calling them magistrates, can make, and gives the prosecutors a free ride, basically, throws in the kids into the adult system, immediately punishes them on the back of a charge, an allegation. Nothing has been proved. Nobody's been proved responsible for anything. Nobody's been proved guilty of anything. And that can last for maybe a year. We take a side, and we have about 80% of those kids who are kids of color, and we destroy their lives very quickly, their education and everything else that's involved in their life. So by the time they get out, even if they're straight released or anything else, they've still got to try and pick up the pieces as a young person, which is extremely difficult. If they get put into this non-transparent adult system, their risk of suicide and abuse is absolutely enormous. If we're looking to punish people, this is a really good way to do it. I don't understand quite how we're got into this extremely skewed situation where you have a system that you automatically prosecute all of these kids who have very little wherewithal, and then the prosecution fails to get those kids into the adult system, into an adult facility 80% of the time. That's a frickin' enormous failure rate as far as I'm concerned. So why would you do that? And why would you destroy the lives of these children in the meantime? I think it's up to the prosecutors to go to court and make a case. Start the kids in a safer situation, a secure, safer situation, and then have the prosecution prove the case if there is a case to be proved. Thank you, Chair.
Very much.
Please support this
Ms.
bill.
Gross, please.
Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent youth and young adults, including those who are charged in adult court as if they were adults. I'm asking this committee to support HB 96, the S Act. And in your support of that, think of a 14-year-old, an 8th or 9th grade student, in a jail jumpsuit that's too big, hanging off of their body that has not yet hit their growth spurt, a belly chain weighing them down, because none of this was designed for them. None of this fits them because they're in a system, the adult and carceral system, that was not designed for them. And think of a 16-year-old who's crying for services, which are delayed during the lengthy transfer process. They're waiting for mental health treatment, waiting for placement at a residential treatment center, that they may ultimately get once their case is transferred to juvenile court. But those services are delayed because that case starts off in adult court. The research and the studies show that this is right for better outcomes for individual youth, that this is right for public safety, and that this is right for Maryland. I'm haunted by the youth who I represented, who I failed, whose cases were not transferred to juvenile court, and they were sentenced to the violence of an adult prison. And I'm also haunted by the youth that I represented, whose cases were transferred to juvenile court, but who still have to live with the nightmare of the days, the weeks, and sometimes the months that they spent in an adult jail cell before they were given a chance at rehabilitation. And I think of each of them when I ask you to pass the S Act.
Questions for the panel? Delegate Bartlett.
I just have one quick question, I hope. I think Ms. Gross can answer this question. With some of your clients, what's it like for the parents of the children?
I appreciate the question, Delegate Bartlett, and I will say before I even offer a response, there are multiple parents of children who were charged in the adult system who will be testifying. I know at least 2 of them who will be testifying virtually.
Well, then I'll listen.
Okay. I'm happy to give the more general response. They will speak about their personal experiences, but yeah, I'd rather leave it to them, and hopefully they can answer those questions, and if not, I'm happy to answer any other
let's
questions.
do that at this hour. Thank you.
Delegate Schmidt.
Thank you, Chair. You made a comment that this is in the best interest of public safety. Can you elaborate on that?
Yes. This is in the best interest of public safety because of the recidivism rates when we talk about youth who are retained in the adult system versus youth who are transferred to the juvenile court system where cases start in the juvenile court system. The recidivism rates in the adult system are much worse than they are in the juvenile court system. So if you look, and the studies are actually done by the Department of Justice, and if you look at a side-by-side comparison, youth who have committed similar crimes or are charged with similar crimes. Take the youth whose case was retained in the adult system or sent to the adult system and compare them for similar crimes, similar behavior, similar background to the youth whose cases are sent to the juvenile court system. The youth whose cases are retained in the adult system or sent to the adult system are much more likely to recidivate. I'm sure Mr. Rovner might have some more information on that. He might even be better equipped to answer that question.
No, I think that was a great answer, but that dealt with half of the equation. So what she just described was specific deterrence of what would happen to an individual young person, whether in the adult system or the juvenile.
Yeah, you see where I'm going. Public safety to me is the victim side, right?
Well, so here's the
that's
thing.
what I'm trying to
There's
understand.
another piece of this, Delegate, because there's a general deterrent as well. And we know this because there's natural experiments that happen all the time. Idaho passes a law, and Montana and Wyoming don't. And we see what happens to the crime rates in those places. So when we talk about what happens to victims, we also need to look statistically at what happens to victims who never emerge because it is better for public safety. Now, the question of what is the best result for victims, we have no shortage of people who are crime victims who will testify later. I would hesitate to speak on their behalf, nor would I say that they are a monolith in speaking so.
Thank you.
Further questions for the panel? Seeing none, thank you very much. We'll hear on the next panel from Ralph Watkins, Ben Peck, Frank Patinella, and then virtually from Emily Virgin, Leonora Taylor, and that'll be fine. We'll hear from these 5 people and then move from there. Sir, on my right, please. On your left, go ahead. Yes.
Okay, I'm actually coming in place of Frank. My name is Damon Walker. I'm for the YES Act because in 1994 I was charged as an adult, and I was put into the old jail, the Maryland State Penitentiary on Greenmount Street. Very savage place for violence, witnessing all type of, brutal things happening to people. But I was lucky enough to get a transfer jurisdiction hearing where the state prosecutor, the state psychologist, as testimony said I was a career criminal, unreformable, a menace to society, and the most manipulative person she might have ever met. But for some reason, the judge saw something in me and allowed me to go back to the juvenile system, which I feel saved my life because it gave me, I was put on home monitoring, forced to stay home, to like mend some of the issues I had at home. But also I was given a job where, that gave me a lot of self-respect, responsibility, started getting straight A's in school. And it changed my life, but a lot of people don't get that chance. A lot of young men, maybe they didn't have a great lawyer or a lawyer that could, that could give them that special attention. The public defender's office, they do great work, but I'm sure they have, inundated with many cases. So, in my case, I was very fortunate to be given a second chance. And so now I sit before you as an advocate for victims of violent crimes. Youth. I teach at the detention center every week, the juvenile detention center on 300 North Gay Street about career development, emotional intelligence. Also work with kids with disabilities, IEPs, 504s. So, I've become a person, a pillar of my community to, to make it a better place. At one time, I wasn't that, but, I got a chance to grow and blossom into the man I am today. And that was because the juvenile services, even if I wanted to fail sometimes. I might have even missed my home monitor thing, but they was like, look, we're going to keep working with you. And I made it through, and I appreciate it.
Thank you very much. Sir?
Mr. Chairman, members of the committee, thank you very much for this opportunity. My name is Ralph Watkins, and I'm speaking on behalf of the League of Women Voters of Maryland. We have long supported the juvenile court system with its wide array of supportive services geared to dealing with young offenders. As we noted in our written testimony, and as you've heard from a number of people, the human brain is not fully developed in childhood. It is inappropriate to apply the rules of adult court and the consequences of adult court to children. This bill will ensure that the default setting for cases involving juveniles is the juvenile court and not the adult court. We thank you for this opportunity to testify, and we urge a favorable report on this bill. Thank you.
Chairman Clippinger and members of the committee. My name is Ben Peck, and I'm testifying in favor of HB 96, the Youth Equity and Safety Act, on behalf of Jews United for Justice, which organizes more than 6,000 Jews and allies across Maryland to help win social, racial, and economic justice campaigns. I wanted to share with you the experience of a relative of mine who was not a great kid when he was growing up. He had real challenges in school, committed an ever-growing and escalating series of crimes. And what I can say to you today is that what turned him around and took him off that path was a juvenile justice system. I'm sorry to say that our family couldn't help him, and that's where he ended up and actually got changed. He was incarcerated, and he was put in a facility. He was mandatorily charged with 10 years, so that he was in the juvenile system, I believe it was for 7 years, and then aged out and went into adult. And what I wanted to share with you is my experience of what I saw and what that system did for him. When I visited him in detention, it was clear to me that the counselors, they were called counselors as opposed to guards, cared about his rehabilitation. Yes, they were there to perform a security function, but they were clearly there to change him and help him grow. One of the things that was most striking to me is that his mother died while he was in prison. And I called up the facility and said that I needed to talk. Oh, that was fast. Okay. Anyways, my point is that they said to me, does he know that his mother has died? And so from the operator on down, the people in that system cared about him and his direction. And I'm here to support the Youth Equity and Safety Act because I think that system turned him around. He has had no contact with the justice system for 10 years since leaving the system. And I think it's because of that system.
Thank you very much.
Thank you.
Emily Virgin, please, for 2 minutes.
Good evening, Mr. Chair and members. My name is Emily Virgin, and I serve as the Director of Advocacy and Government Relations at Human Rights for Kids. We at HRFK have been gathering data from each state on how many people are currently incarcerated for crimes that they were convicted of as children. We'll be releasing the full report on this data in a couple months, but I want to highlight a few things from the data that we received from Maryland's DPSCS. This data that we received has been uploaded with my written testimony, and it's safe to say that we can tell that Maryland has what we would consider an extreme automatic charging statute because the data bears that out, especially when we compare Maryland to the rest of the country. As of the time that we requested the data, there were 1,132 people incarcerated in the state who had been there since childhood. This represents over 6% of the overall prison population, which is more than double the national average of 3%. This places Maryland as the 5th highest incarcerator of children in the entire country. Only Michigan, Louisiana, Wisconsin, and South Carolina have higher percentages. This population is over 90% people of color and is 81% Black. Those percentages place Maryland as 4th highest in the nation, and the state also ranks highly when considering the length of sentence. In short, Maryland is an outlier. These rankings are attributable to Maryland's longstanding practice of automatically charging so many children as adults. Many other states that rank lower begin all cases in juvenile court, and then those cases can be waived up to adult court. We know that the kids we're talking about are often victims themselves, and we urge you to consider that fact when thinking about classifying them as adults. We believe that children deserve second chances and at the very least deserve to have their childhood trauma and life experiences considered by a juvenile court when deciding. classified as adults. Thank you for your time and urge a favorable report.
Leonora Taylor, please, for 2 minutes.
I am here tonight in support of the Act and my son, who was robbed of the opportunity to walk the stage on his 18th birthday as a result of being charged in adult court for a minor offense that could have been and should have been resolved under the authority of the school instead of the justice system. He has had to live with the shame, humiliation, and lingering embarrassment that came when his name and picture was made public, not just on social media or Google, but on the national news. To this day, he lives with the shame of all things surrounding this unfortunate event, all because every time his name is Googled, the event, his name, and his face pops up. We know that if this were initially handled in juvenile court, he would have been offered youth services, which provides guidance, treatment, and rehabilitation, not a public display of an infraction that took place when he was a juvenile. Now, this may be a little off script in comparison to the other testimonies today. However, I feel led to say what I feel needs to be said. Let me first say this. What I'm about to express is contingent upon the nature of the crime committed. The decision to pick the child as a juvenile versus an adult should be made by a judge or magistrate on a case-by-case basis. If the individuals who are opposed to the YES Act have found themselves in similar situations as those who went from the schoolyard to the yard of an adult correctional facility because of some unflattering behavior on their part, would they themselves want to have been subjected to the adult system, being charged as an adult, having to face the results of their actions from the inside of an adult prison? Or would they want someone extend to them a little extra grace and mercy by recognizing, understanding, and acknowledging that children will be children? Children will do things regardless of how they were raised. Children will do things when they think authority figures aren't watching. And children will do things they think they can get away with, just like a huge number of adults. However, we can treat them as adults. We can't treat them as adults simply because they have yet to mature to a level that affords them a full understanding of cause and effect. Furthermore, and lastly, if these very individuals who are opposed to this act learned that one of their offspring had went out into the world and performed in such a way that was totally contrary to the way in which they were raised, they raised their child, and that child was faced with the same consequences of their own actions, yes.
Sorry, I'm going to need you to wrap up, please.
This is the very last thing. How would they want their seed to be handled? Would they want their seed handled with care by individuals who personify sympathy, empathy, compassion, and a little pity? Or would they want their child handled as if they were an adult who's fully cognizant of their actions and where those actions could lead? Thank you very much for allowing me.
Are there questions for the panel? Seeing none, we thank you all very much. We'll now hear from Christine Dufour, Braden Stinar, Heather Warnken, Tracy Wright, Laura Stewart.
Should I go?
And your name again?
Laura Stewart.
Oh, I see you. Hold on one second. We'll do the people in the room first, and then we'll get to the people on virtually.
Okay, thank you. Good evening, members of the committee. Again, Heather Warnken. I am the Executive Director of the University of Baltimore School of Law Center for Criminal Justice Reform. Among the many reasons why we are in strong support of HB 96, I will focus on the one stated as top of the agenda for countless elected leaders across the political spectrum in our state, keeping our communities safe. From a public safety standpoint, the evidence is clear. Charging youth in adult court leads to significantly higher recidivism, more violent crime, and more victims. Youth charged in adult court are 34% more likely to be rearrested and with more serious offenses as compared to similarly situated youth who have their cases heard in juvenile court. I will keep it brief as I know it's late and I don't want to be repetitive. We cover many of the other reasons in our written testimony, including that charging youth in adult court is expensive and inefficient. HB 96 is a public safety and racial justice imperative, and we urge a favorable report. Thank you.
All right, Laura Stewart now for 2 minutes, please.
Thank you. Good evening. My name is Laura Stewart. I am the Vice President for Advocacy for Free State PTA, which is our statewide PTA representing over 50,000 volunteer members and families in over 500 public schools. House Bill 96 aligns with our legislative agenda, which includes the use of compassionate youth justice by advocating for practices that are equitable within the justice system and considers the mental development of youth. We believe the YES Act helps resolve inequities, increases continuity of educational attainment, and minimizes recidivism while fostering greater access to youth rehabilitative services. Free State PTA supports this bill, given the inherent inequities that exist when 81% of youth charged in adult court in Maryland are Black. Because Black youth are more likely to be sent to adult prison and receive longer sentences than their white counterparts for similar offenses, the PTA is fighting against this disparate discipline, and this bill attempts to eradicate just that. From an education perspective, youth detained in a Maryland juvenile facility managed by the DJS are more likely to receive appropriate education while being detained because the Juvenile Services Education Program provides comprehensive educational services. Students can receive instruction and coursework aligned with the Maryland State Department of Education graduation requirements. Furthermore, students can receive career and technology education certifications, special education services, participate in GED completion, and receive school counseling support and post-secondary opportunities. Having youth detained in an adult facility denies youth continuity in education while awaiting trial. Today, youth wait for as long as 140 days in solitary confinement in an adult institution, even when waivers are eventually granted, which is traumatic in itself. And for all of these reasons, Free State PTA supports this bill, and we urge a favorable report on HB 96.
Tracy Wright, please, for 2 minutes.
Good evening, ladies and gentlemen of the committee. My name is Tracy Wright. I'm here today to testify on behalf of my son's experience, which he was arrested at age of 17 and detained in an adult facility. When he went to court, the prosecutor asked that he be held in an adult facility. And before he was arrested, he was experiencing severe mental health crisis. And when he was first detained, I heard from him on a daily basis. About a month and a half into his detainment, he stopped being able to use the phone. He was incapable of being able to use the phone or communicate verbally. When we went to court in December of that year, he was incoherent. He couldn't say his name when asked to speak his name and state it for the record. And when he was in the adult facility, he was unable to receive the special education services, which his IEP stated he should be getting. He was only able to have 2 hours of instruction per week, and he was supposed to be getting 30 hours a week, plus an hour of counseling, which he was unable to receive in the adult facility. And after going to court, I heard from the teacher who called me, who was seeing him at the adult facility, and she said that she was unable to provide my son with instructional assistance because he was incapable of doing so because of his mental health needs. But she decided to continue seeing him in an effort to help him at least eat and get some liquids into him so he wouldn't dehydrate. And then on December 26th of that same month, I heard from physician from the emergency room saying he was treating my son for catatonia and severe dehydration, and that after a few hours of receiving medication in the emergency room, my son was able to speak once again, and he was able to eat independently. But sadly, he returned back to the facility where he was unable to get medication, and now, gratefully, because of the efforts of his public defender, he is getting the mental health treatments he needs, and he was able to graduate high school. Thank you. This is for this reason I ask you to vote in favor of the Yes Act.
Thank you very much. Mr. Stinar.
Thank you, Chairman and members of the committee. My name is Braden Steiner, and I'm a third-year law student at the University of Baltimore and research fellow with the Center for Criminal Justice Reform. I'd like to greet you and ask how you are today, but the real question to ask is, how are the children? The Maasai tribe did not just say hello, but would greet one another with Kasirian Ingeda, translated, how are the children? This greeting was shared with the expected response to be, all the children are well. The Maasai were aware that the wellness of their young people was a barometer for the wellness of all. So I greet you again with one question. How are the children? Can you honestly return the response that all the children are well? Because truth be told, they're not. I'm here today in support of the Yes Act because the basic facts are indisputable. Children are children. They are not adults, not physically, not emotionally, not cognitively, not socially. And regardless of skin tone, identity, socioeconomic status, access, or educational opportunities, children are uniquely, remarkably, medically, and scientifically children. This may seem obvious to some, but our state has historically ignored this. Second to Alabama, the state of Maryland sends more children to adult court per capita than every other state in the country. Further, 81% of the children first charged in adult court are Black. I ask again, are all the children well? What will your answers say about us, you, our state, our community, and our future? Maryland's current practice of treating children as adults is not only devoid of any scientific, medical, or evidence-based research, it's also undeniably racist. As this legislative body seeks to align itself with Governor Moore's pledge to leave no Marylander behind, I could think of no more important place to start than with our children. Until we can say all the children are well, we cannot and will not rest. Thank you.
Other questions for this panel? Seeing none, thank you all very much for speaking with us this evening. That concludes the testimony of those in favor of the legislation. We'll now hear from those opposed. Steve Kroll, Scott Schellenberger, Laura Wilt, and Billy Katzev.
All right. Thank you again, Laura Wild. I am the Chief Juvenile Prosecutor in Frederick County, been doing just juvenile work for the last 18 years. I'm happy to be here to address any questions that you have. What I can tell you without a shadow of a doubt is that the juvenile rules and statutes that are currently in place are not appropriate for this set of crimes in this group of juveniles, that the department's facilities and policies that are currently available are woefully inadequate for this population and these crimes. The department has spent the last 5+ years closing down facilities, shutting down, offering less programs. They have fewer programs with serving less juveniles than we've ever had in my 18 years of doing juvenile work. We need more services for the youth we currently have. We don't need to add another whole set of youth in there to not be properly helped. I certainly would argue that there is no one in this chamber who could say, when I considered this legislation and when I voted on it, juvenile court was ready for this set of facts. That our juvenile, and that's what you're proposing. You're proposing to pass legislation that tells the court, we are telling you our juvenile court is the appropriate place. And it's not. Today it is not, but it should be. I am certainly in the camp that we need to do something with our juvenile justice system. I want to address some of the arguments that were made. You have passed laws over the last couple of years that have fixed some of the arguments that are made here. The argument that the juveniles in solitary confinement, that doesn't happen now because the law says you need to go to juvenile detention. We fixed some other things that I would love to answer. The expungement, names are not public anymore. Our process is the right process to compare our laws to the other ones that are auto-filed. It's very different, and if you ask me, I'll tell you.
Thank you. Where would you like to go next?
Mr. Chairman, members of the committee, my name is William Katzev. I'm an Assistant State's Attorney from Anne Arundel County, here on behalf of the Maryland State's Attorneys Association. I joined the State's Attorney's Office in 1978 as a law clerk. My duties, in addition to general legal research, included enforcement of juvenile restitution orders. Back in those days, the type of orders that I was enforcing was restitution that was the result of the type of crimes that juveniles committed at that particular time, or offenses they committed at that time, which involved theft, which involved acts of vandalism, such as destruction of property. We're nowhere near where we were back then. Today, I'm a felony screener. I'm screening felonies that involve everything, including murder, assault, attempted murder, armed carjackings, armed robberies, you name it, I screen it as long as it's a circuit court felony. And I can tell you, these crimes are being committed by 16 and 17-year-olds on a regular basis. The number of juveniles who are in possession of firearms, okay, even if it's just wear and carry, it's enormous. It's absolutely amazing compared to how it was when I started 45 years ago. These are adult type of offenses that are referenced in this particular bill. Okay, those offenses, when committed, are committed by people who have absolutely declared their independence, their emancipation from the juvenile justice system. It's adult behavior and should be tried or should be charged in adult court. I urge the committee to give House Bill 96 an unfavorable report.
Thank you, Mr. Chairman, members of the committee. Good evening. I'm Stephen Kroll, State's Attorney Coordinator for Maryland, Executive Director of Maryland State's Attorneys Association. Been prosecuting all cases since 1984, and asked for an unfavorable report as to House Bill 96. Question, Delegate Eric Ann, and you asked it before, but the question I'm going to ask this panel, and it's a rhetorical question, is, are the victims well? And the victims are not well. The Assistant Public Defender said, give it a chance. Give things time. Victims and witnesses do not have the time. And why are the victims and witnesses not well? If you read Mr. Potachnik's letter to you that you have in your material, if you commit armed robbery, carjacking, serious crimes like that, murder, anything like rape, what is your sentence going to be in an in-state facility? How many months are you going to be incarcerated for doing that in juvenile court? 5 months. 5 months. No, the victims are not well. The victims are not well. And that's what you got to look out for. Public safety are victims and witnesses. And you know who I speak for, and I speak for them who are not here today because they can't be here because they're victims of crime. The people that did come here and tell you the crime they committed did not tell you what crime they committed, who they committed it against, and what they did and what their sentence was. Armed robbery is not a life sentence in Maryland. What did they do? If you want rehabilitative justice, who did you commit the crime against? What did you do? Didn't hear anything about victims and witnesses. And ladies and gentlemen, we're asked for opposition and an unfavorable report on behalf of victims and witnesses, even at this late time. And even in this late time, I say to you the following. The victims and witnesses are not well. Unfavorable report as to House Bill 96. I'm happy to answer any questions.
Questions for the panel? Delegate Valentine.
Thank you, Mr. Chair. And my question is for Assistant State's Attorney Wilt. Could you elaborate on some of the other juvenile programs that could be improved upon as a whole, as you were discussing earlier?
Well, our programs right now, we have one locked facility for behavior modification. So that is the Victor Cullen Center. That's the one with the average length of stay of 5 months. Those programs that are even available at that center have been greatly reduced because I believe that the intent of the juvenile system is to get them out as quickly as possible. So we're not offering quality, maybe programming, because the goal is to get them out instead of provide the right amount of care. We closed our only locked juvenile female facility. The residential treatment centers, which are focused on mental health, those facilities have also they went from 18 months, it's about 18 months average length of stay. They now are down to, on the 6 month, like exactly 6 months from the day they enter, I'm suddenly getting the report that they're ready and it's time to get out. So the policies have started to bleed over into the RTCs, which are privately run, which we need to realize that RTCs can't be forced to take these youth charged with those serious offenses. So I'm sure I've diverted off of your original question, but we have so many programs that need to be developed in our system.
I just wanted to give you the opportunity to follow up on what you wanted to say at the beginning. So.
Thank you.
Thank you. Okay, so I just want to make sure I got this right because I was taking notes. We have one locked facility now for male young juveniles. Yes. Average getting out is 5 months. We've got reduced services in that. We've closed our female location, so we don't even have one for them. We have residential treatments, and that state-run used to be 18 months. Now they're getting people out in 6 months, and we're shifting people to what, private prison? What is it? Where are they going? Private?
Well, no, the RTCs, the residential treatment centers, are privately run. So
Okay.
when our court orders primarily a mental health commitment, those are privately run facilities.
Okay,
I do want to make sure there are locked facilities that are temporary detention centers.
Okay.
That'll hold a juvenile female, but they're not locked placements.
Okay, and how long can someone be in a temporary detention center?
Well, I mean, the law says you have to review the detention every 2 weeks. The goal is to get them moving as quickly as possible. That's a temporary holding facility before you're adjudicated, you're tried, you're sentenced.
Yeah, this almost feels like we're trying to save money all of a sudden at the expense of
I
our
know
kids.
they have a surplus of money. I think it's a policy decision.
That's disturbing. Thank you.
Further questions for the panel? Delegate Munoz, then Bartlett.
Thank you, Mr. Chair. Someone may have said this earlier because it's been a long night, and I apologize if it has been mentioned and I missed it. But are you aware of any data on this particular age group when they're tried in juvenile court versus adult, and what the recidivism rates are? Does that exist?
I personally, the only statistics I know are the ones that are published by the Department of Juvenile Services, and they look at rearrest. So personally, I couldn't comment on that.
Okay. I'd like to see that later. Thank you so much.
Thank you, Mr. Chair. I appreciate what you all do, but you all get to represent one side. We have to represent both sides. So I'll tell you, Mr. Crawley, you know it. We're here for the victims as well as we are here for the accused. So I just want to make that on the record. And the other thing is, I wanted to ask was, how with an individual being incarcerated, or an individual, let's just stick to the bill, an individual who is immediately charged as an adult or treated as an adult, how does that immediate action assist the victim? And I guess I'll ask Mr. Crawl, because you brought it up, but how does that action help the victim?
From my experience of 39 years of talking to victims in similar circumstances, when you tell a victim in a serious crime that you're the defense, the respondent, because it's a juvenile/defendant, depending where they are, is going to adult court, that shows, number one, society cares, the state cares, and it sends the message that you're taking it seriously. By going to juvenile court and only serving 5 months says you're not taking it seriously.
So what
That's
happens?
that's not fair to victims and witnesses.
What
we tell them
happens
that.
with that 80% that we were talking about before? How does that help victims? I was, when we were talking on, I hope it was the same bill, and I hope it's not that late that I'm starting to mix bills. But if 80% are not waived, or whatever the 80%, and you know the 80% I'm talking about, right?
I'll let Ms. Wilt directly deal with
Thank
that.
you.
She knows the
So
stats.
if that happens, and if that statistic is true, how does that help victims?
I think it helps tremendously, because what they see is a fair and just process where the court listened to what I have is 2 doctors testifying to the details of this youth's history. They're like Dr. Bennett. She's been in the court with me before. So you also have expert social worker. All these experts are available and testify during transfer hearings. And why transfer? Because it started in adult court and the burden is on the defense. It's a small burden. If it benefits either the kid or the community, it goes back to juvenile. I mean, that's the question. If it benefits the kid or the community, it goes back to juvenile. And we have multiple experts testifying as to all the details of their history.
Okay.
The difference in...
Hold on 1 second. I have to stop you just for a second, because I want to just make sure I get my questions out really quickly, because it is late. So let me make sure I understand. You just said that in that situation, the burden is on the defendant?
If it started in adult court, that's right.
So if it starts in adult court, the burden is on the defendant. And so we are no longer, not only are we charging this individual as an adult, we're making them prove why they should be transferred to juvenile.
That is what the law says. Because the crime is so serious, and the burden is on them, but they are provided 1 or 2 counsel that help them, 2 doctors, 1 social worker.
Hold on. I want to stick with my questions just for a second. The reason for this is because in my first year here, I got a phone call from a constituent. My child, unfortunately dumb, brought a knife to school. That child was immediately charged as an adult. That child
with what crime?
Beats the hell out of me.
Well, if they were charged with first-degree assault, which means they used the knife.
That kid ended up in adult court. Because I am a delegate, I was able to get that kid moved a little faster than someone who didn't have the wherewithal to call their delegate and say, this is wrong, this is a mistake. My question to you again is, here's my question. Do you think, you said it is law, but do you think it is fair for a defendant, when we have said as our overarching criminal law that the state must prove beyond a reasonable doubt that an individual is guilty, in your opinion, is it fair, is it equitable, is it just for a defendant to have to prove why they should be transferred over to juvenile court when they are, in fact, a juvenile?
Yes, absolutely, because we have the statutes in place that provide that process, which is just. If you do it a waiver, if you put the burden, if you say the prosecutor shouldn't be the one choosing, the waiver, if you're saying, start in juvenile, then it's totally up to the prosecutor who, as you said, you don't want a prosecutor who doesn't know anything about this youth making the decision. You want a judge making the decision. Well, you're going to force a prosecutor who looks at the crime, file a waiver right away, which in a lot of jurisdictions, it's not going to happen. They must file right away because they don't have time to research anything. The waiver has to happen in 30 days. Burden would then be on the state. Juvenile says, I don't want to go to adult court. I'm not going to participate. I'm not giving any information. I'm not going to talk to the doctor. And then the court looks at the state and says, the burden's yours to move it to adult court. you have no information, because that's true. I don't have any information. I don't have access to youth. If we want a full and just hearing, it has to be the transfer hearing. It has to be the transfer hearing where the defense counsel can present that information about their youth. And as far as the 80% going back to juvenile, first of all, we have the rules. They're not held. They're held in juvenile detention. Their record is no longer public until that transfer hearing is over. And three, that's how you can have the full and just hearing. The waiver hearing in 30 days, how is that just?
Okay, well, it's late, but I think that it's just if you do it in the reverse. But I understand what you're saying. We just disagree. Thank you.
Thank you.
Mr. Chair, promise. Just want a quick commentary. I think we should use the word child. We're talking about children. I think juvenile is antiquated. We should probably do a bill to get rid of the word. Nevertheless, a question to you all is if we started in juvenile court, how confident do you feel that you would be able to, in the egregious circumstances, still win the transfer?
So then that would be, so what percentage will we be able to win?
I'm just saying, how do you, I mean,
so
if these cases are so as bad, I mean, and I'm sure that many of them are, why wouldn't you still be able to just
So if the law requires I try that waiver hearing in 30 days, if defense counsel, which they do, stands up in court and says they must try it in 30 days or the case is dismissed or the waiver is dismissed, and I don't have any evidence about that kid's background because they didn't cooperate, that's done. It's over.
So to follow up quickly, how long does it take you now?
For a waiver? Or, I'm sorry, either way. So the state must be ready to try that case, try the transfer hearing within so many days of getting the report. I don't know, somewhere about 90 days in total.
Because I'm concerned.
But defense counsel in every one of my cases has postponed for at least 6 months after that totally defense request because they want more experts, and they're always given that.
In any respect, I'm concerned about children in school or whatever they should be doing or not being able to be available. I mean, obviously, any of these circumstances disrupt everybody's life, including the victims and witnesses. Last thing, Mr. Chair, and I'm out of the way. Are these generally cases where folks are innocent until proven guilty? Does that still apply?
In the course of a criminal trial, of course it does.
Of course, and I think that's part of what our concern is.
In the course of a criminal trial,
is when you all and I'm done. You all are concerned about victims and witnesses, as you should be. But it's not the judge's job at that point to be concerned only about the victim and witness. It's their job to be concerned about fairness and justice. And I think that what we're trying to get at is fairness and justice for a child who is a child, no matter how many words we choose to use, requires that we start in juvenile court. And at the end of the day, if the case is the case, you will have the facts ultimately, and you will be able to make that determination and win that.
I'd like you to see that transfer hearing.
I used to work at State Attorney's Office. I know what they look like. Thank you so much, Mr. Chair, for your indulgence.
Thank you.
Okay, seeing no further questions, I don't believe. That concludes this panel. That concludes the witnesses for House Bill 96, and that concludes bill hearings today, and it concludes Elizabeth Embry's birthday today, and Karen's anniversary. And it also means that we are going to adjourn 3 minutes short of going for 10 hours, which is okay. We will be back with the voting session tomorrow. Thank you.